ಯಾವ್ದು ಸರ್ ಅದು? ಸರ್ವಿಸಾ? ಇಲ್ಲಿ ಏನು ಸರ್ವಿಸ್ ಯಾವ್ದು ಬರಲ್ಲ. ಯಾವ ಮ್ಯಾಟ್ರ್ ಸರ್ ಇದು? ಇಲ್ಲ ನಮಗ್ ಬರಲ್ಲ ಸರ್. ಅದು ಇದನ್ನ ನೋಡ್ತಾ ಇದ್ರು, ಸಿಡಿ ನಿನ್ನೆ ನೋಡ್ತಾ ಇದ್ರಲ್ಲ, ಅದಲ್ಲಿ ಬಟ್ ಅದು ರಿಸರ್ವ್ ಆಗಿದೆ. ಅಲ್ಲಿ ನಮ್ಮ ಚೇಂಬರ್ ಅಲ್ಲಿ ಇದೆ. ಎಲ್ಲಿ ಆಗ್ತದೆ ಸಿಡಿ? ಆಕ್ಸಿಡೆಂಟ್ ಹೆಂಗಾಯ್ತು? ಅಲ್ಲ ಇದು ಡೇಟ್ ಮ್ಯಾಟರ್ ಇದೆಯಾ? ಆ 3 ನಂಬರ್ಸ್ ಬರ್ಕೊಡು, ತರ್ಸ್ಬಿಡೋಣ.
Connected match, no? After
2018
after connected. After.
Oh, sir.
What is the problem? ಏನು ಪ್ರಾಬ್ಲಮ್?
ಅಪೀಲ್ ಫೈನಲ್ ಇಯರಿಂಗ್ ಮ್ಯಾಟ್ರ್ ಇದು. ಫೈನಲ್ ಇಯರ್ 21
2021 order of seniority. Yes.
adjournments.
Well, correct. If that is the case, they have to reconcile. Yes.
Adjournments, page wise, list 1, Page 1, seal number 1 to 4. Page 2, seal number 5 and 6. Page 3, seal number 7 and 8. Page 4, seal number 9 to 13. Page 5, seal number 14 to 17. Page 6, seal number 18 to 22.
It appear for respondent, my lord.
Hmm.
They will.
As to senior claim. ಅದು 18
My lord, last date also.
They say they're trying for settlement. Are you aware? Have you spoken to your party?
My lord, kindly date may fix, my lord.
No, he should know that the parties are trying for settlement. Oh, he's well.
We are not aware, my lord.
Welcome. As requested, I'm sorry, now counsel for the appellant seeks adjournment on the ground that the parties are trying for a settlement. List all. They have moved. Who has moved? You have moved.
You remember.
But you have moved. List all on date.
2 weeks.
Yeah.
18.
18.
My lord, 11th or 12th.
Wait, this is 2024 matter. In a settlement, you can talk because she says your senior is talking.
18 to
18. Interim order granted earlier is extended till extended.
page 7, seal number 23 to 26. Page 8, seal number 27 to 31.
No, limited by time with the serial number 38.
38.
Admit
Page 9, seal number 32 to 37. Page 10, seal number 38 to 43.
38. I tell you, we have come to see page number 10. Serial number 38. Whom do I represent here? Want time? As requested by the appellant's counsel, list after 2 weeks. Want it after 10. Inform the other side also. No, he'll be, otherwise he has to come and wait here.
Date. Page 7, seal number 44 to 46.
Serial number 44 minutes. Serial number 44 minutes. Just after 2 weeks. Please not. Serial number. Well, it's in the
44
minutes.
Serial number 44.
Maybe just after 2 weeks.
Whom do I represent?
I have answered the R1 minute. Prominence.
R1. Appeal against R1 is dismissed.
Yes.
Appeal against R1 is dismissed.
Ala Subramanya. Connected matter R1.
My lord, there are
Appellant
connected
with the first matter.
First matter is appellant.
Hmm.
Adjourned at the request of the appellant's counsel. Yes.
Page 12, seal number 47 to 49. Page 13, seal number 50. List number 2 for adjournment, seal number 1 to 5.
Yes, ಎಲ್ಲದರಲ್ಲೂ ಬೇಕಾ? Second time, first time. State appeal of 4.
It's fine.
First one, Veda Vyasara.
Date.
ಅದೇ 2 to
Adjourned.
2 to 5 ಅವರೇನು ಬಂದಿಲ್ಲ. 2 to 5 ನಲ್ಲಿ ಬರ್ಕೊಂಡ್ಬಿಡಿ.
Instance number 2, serial number 1.
House.
I appear for the petitioner. There's a 2 weeks silent.
5 objections.
1 to 5 ಎಲ್ಲದರಲ್ಲೂ at request 2 weeks time is granted to develop. Yes, 2 weeks in all the matters. 1 to 5.
List number 1, fraud, seal number 1.
I am for the petitioner, my lord. My
There
lord,
is a
in this,
time for that.
Allah, some review petition first.
Madam, one ನಿಮಿಷ.
ಒಂದು ನಿಮಿಷ ಇಸ್ಕೊಂಡು ಕಳಿಸಿದ ಏನಿದೆ ತಗೊಂಡ್ ಕಳಿಸಿ. ಇದು ಕೊಡಿ ನೋಡ್ತಾರೆ ಕಳಿಸ್ಕೊಡ್ತಾರೆ.
Fraudus, seal number 1. Yes, Nirmala.
My lord, I am for the petitioner, my lord. I have already served the hand summons which this honorable court has ordered, along with the memo of hand summons having served it on 23/20/23 summons. I have a copy of the presentation. 27/23 ಸ್ವಾಮಿ ಒಂದು ಕಾಪಿ ಅಲಾಂಗ್ ವಿತ್ ದಿ ಹ್ಯಾಂಡ್ ಸಮನ್ ಸರ್ವ್ ಮಾಡಿದ್ದಕ್ಕೆ ಕಾಪಿ ಹಾಕ್ಬಿಟ್ಟು ನಾನು ಹಾಕಿದ್ದೀನಿ ಹೈಕೋರ್ಟ್ಗೆ. ನನ್ನ ಹತ್ರ ಸೀಲು
Was
ಸಿಗ್ನೇಚರ್
that
ಎಲ್ಲ
day?
ಇದೆ.
When was
Hands-
that?
ಸ್ವಾಮಿ 20
ಯಾವತ್ತು
7
date?
23.
17. ಯಾವ?
ಅವ್ರು ಶಿ ಇಸ್ ವರ್ಕಿಂಗ್ ಇನ್ ದಿ ಕಾರ್ಪೊರೇಷನ್ ಸ್ವಾಮಿ, ಹಾಗಾಗಿ ಹ್ಯಾಂಡ್ ಸಮನ್ಸ್ ತಗೊಂಡಿದ್ದೆ. ಹ್ಯಾಂಡ್ ಸಮನ್ಸ್ ಸರ್ವ್ ಮಾಡ್ಬಿಟ್ಟು ನಾನು ಅದ್ರ ಕಾಪಿ ಅಲಾಂಗ್ ವಿತ್ ದಿ ಕಾಪಿ ಆಫ್ ದಿ ಹ್ಯಾವಿಂಗ್ ಸರ್ವ್ಡ್ ಇಟ್, ಐ ಹ್ಯಾವ್ ಫೈಲ್ಡ್ ಬಿಫೋರ್ ದಿಸ್ ಆನರಬಲ್ ಕೋರ್ಟ್ ಆನ್ 23/23.
Where is that? When have you filed that? 20?
27/23 ಸ್ವಾಮಿ,
Where?
ಜುಲೈ 20/27.
But even that, otherwise there is one minor in the case.
ಸ್ವಾಮಿ ಅದೇ ಮೈನರ್ಗೆ ಮದರ್ ರೆಪ್ರೆಸೆಂಟ್ಸ್ 1
ಅವ್ರು
to 3.
ಬರ್ಲಿಲ್ಲ ಅಂದ್ರೆ we have to court ಗಾರ್ಡಿಯನ್ ಅಪಾಯಿಂಟ್ ಮಾಡ್ಬೇಕಾಗುತ್ತಲ್ಲ.
ಅವರೇ ಶಿ ಇಸ್ ದಿ ಗಾರ್ಡಿಯನ್ ಅಂತಾನೆ ಪ್ರೆಸೆಂಟ್ ಆಗಿರೋದು ಕೋರ್ಟ್
Madam,
ಬಿಲ್.
Order 32, if she doesn't appear, minor's guardian does not appear, you have to seek court guardian's appointment. First, let us see, because we are not finding any.
ಒಂದ್ ನಿಮಿಷ ಸ್ವಾಮಿ, ಶಿ ಹರ್ಸೆಲ್ಫ್ ಹಸ್ ರಿಸೀವ್ಡ್ ದಿ ನೋಟಿಸ್. ನೋಟಿಸ್ ಸರ್ವ್ ಮಾಡಿದೀವಿ, ರಿಸೀವ್ ಮಾಡಿದ್ದಾರೆ ಅವರು.
ಹಾಕಿದರು ಬ್ರಾಂಚ್
ಅದಕ್ಕೆ ಹ್ಯಾಂಡ್ ಸಮನ್ಸ್ ತಗೊಂಡಿದ್ದೆ. ಶಿ ಇಸ್ ವರ್ಕಿಂಗ್ ವಿತ್ ದಿ ಕಾರ್ಪೊರೇಷನ್ ವರ್ಕ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ ಸ್ವಾಮಿ, ಕಾಂಪನ್ಸೇಟಿವ್ ಗ್ರೌಂಡ್ ಮೇಲೆ. ಹಸ್ಬೆಂಡ್ ತೀರ್ಕೊಂಡ್ಮೇಲೆ ಅವರಿಗೆ ಕಾಂಪನ್ಸೇಟಿವ್ ಗ್ರೌಂಡ್ ಮೇಲೆ ಕೆಲಸ ಕೊಟ್ಟಿದ್ದೀವಿ.
ಹ್ಯಾಂಡ್ ಸಮನ್ಸ್ ಕೋರ್ಟಿಂದ ಆರ್ಡರ್ ಆಗಿತ್ತು. ಹ್ಯಾಂಡ್ ಸಮನ್ಸ್
ಆರ್ಡರ್ ಆಗಿತ್ತು ಸ್ವಾಮಿ ನನಗೆ.
ಆರ್ಡರ್ ಆಗಿದೆ, ಸರ್ವ್ ಆಗಿದೆ.
ಹೌದು ಸ್ವಾಮಿ, ಸರ್ವ್ ಮಾಡಿದ್ದೀನಿ ಸ್ವಾಮಿ. ಕಾಪಿ ತಮ್ಗೆ ಅಲ್ಲಿ ಹಾಕಿದ್ದೀನಿ ನೋಡಿ ಸ್ವಾಮಿ. 27/23 ಸರ್ವ್ ಮಾಡಿ ಅವ್ರು ಸೈನ್ ಮಾಡಿ 2/3/23 ಕಾಪಿ ಇಸ್ಕೊಂಡಿದ್ದಾರೆ.
ನಾನು ನೋಟು ಲುಕ್ ಇಂಟು ಅಂತ ಅಷ್ಟೇ ಇದೆ. ನೋಟು ಲುಕ್ ಸುಮಾ ಅಲ್ಲ, ಸಿಗ್ನೇಚರ್ ಇದು. ವಾಟ್ ಇಸ್ ದ ನೇಮ್ ಆಫ್ ಫೋನ್ ನಂಬರ್ 1? ಟ್ರಯಲ್ ಕೋರ್ಟ್ ರೆಕಾರ್ಡ್ಸ್ ಬಂದಿಲ್ಲಲ್ಲ, ಇದ್ರ ಸಿಗ್ನೇಚರ್ ನೋಡಿ ಕಂಪೇರ್ ಮಾಡಕ್ಕಾಗ್ತೈತೆ. ಗಾರ್ಡಿಯನ್ ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಮಾಡಿಸ್ಕೊಂಡು
ಅವ್ರು ಕಾರ್ಪೊರೇಷನ್ ಅಲ್ಲಿ ಇದಾರೆ ಸ್ವಾಮಿ. ಇನ್ನೊಂದ್ಸರಿ ಬೇಕಾದ್ರೆ ಇದರದೇ ಫೋಟೋ ಕಾಪಿ ಕಳಿಸ್ತೀನಿ ಬೇಕಾದ್ರೆ. ಶಿ ಇಸ್ ವರ್ಕಿಂಗ್ ವಿತ್ ದಿ ಕಾರ್ಪೊರೇಷನ್.
ಯು ಪೇ ದ ಪ್ರೊಸೆಸ್. ಇದು ಯಾವ ಟ್ರಿಬ್ಯುನಲ್ ಇಂದ
ಪ್ರೊಸೆಸ್ ಅಲ್ಲ, ಹ್ಯಾಂಡ್ ಸಮನ್ಸ್ ತಗೊಂಡಿದ್ದೀನಿ. ಹ್ಯಾಂಡ್ ಸಮನ್ಸ್ ಆರ್ಡರ್ ಆಗಿತ್ತು ಸ್ವಾಮಿ, ತಗೊಂಡಿದ್ದೀನಿ.
ರೆಕಾರ್ಡ್ಸ್ ಇದ್ರ ರೆಕಾರ್ಡ್ ಪುಟಪ್ ಆಗಿದೆಯಾ?
ಇಲ್ಲ ಮೇಡಮ್.
ಅಪೀಲ್ ಇಂದ ಆದ್ರೆ ಅಟ್ಲೀಸ್ಟ್ ಆ ವಕಾಲತ್ತಲ್ಲಿ ಅವ್ರಿಗೆ ಸಿಗ್ನೇಚರ್ ನೋಡಿದ್ರೆ ನಾವು ಮಾಡ್ಬೋದು. ಅಲ್ಲ ಬೇಡ, ನಾವೇನ್ ಮಾಡೋಣ, ಅದು ಬೇಡವೇ ಬೇಡ. ಈಗ ಈ ಕೆಳಗಿನ ಕೋರ್ಟ್ ಇರುತ್ತಲ್ಲ, ಟ್ರಿಬ್ಯುನಲ್ ಯಾವ್ದಿರುತ್ತೆ, ಎಕ್ಸಿಕ್ಯೂಷನ್ ಏನಾದ್ರು ಫೈಲ್ ಮಾಡಿದ್ರ ಅವರು?
ಇಲ್ಲ ಸ್ವಾಮಿ, ಏನು ಮಾಡಿಲ್ಲ.
ವಾಟ್ ಇಸ್ ದ ಎರರ್ ಹಿಯರ್? ಸೀನಿಯರ್ ಸಿವಿಲ್ ಜಡ್ಜ್ CJM Ramanagara. It is passed by the said court. She is shown as resident of
ಅಲ್ಲ ಇದರಲ್ಲಿ ಸ್ವಾಮಿ ರಾಮನಗರದಲ್ಲಿ ಕೆಲಸ ಮಾಡ್ತಾ ಇದಾರೆ ಅವರು. ಡಿಪೋದಲ್ಲಿ ಕೆಲಸ ಮಾಡ್ತಾರೆ ಸ್ವಾಮಿ, ರಾಮನಗರ KSRTC.
ನೀವ್ ಯಾಕೆ ಸರ್ವ್ ಮಾಡ್ಬೇಕು? ರಾಮನಗರ ಡಿಸ್ಟ್ರಿಕ್ಟ್ ಕೋರ್ಟ್
ಅವರು ತಗೊಳ್ಳಿ. ಶಿ ಇಸ್ ನಾಟ್ ಅ ಮಚ್ ಎಜುಕೇಟೆಡ್ ಸ್ವಾಮಿ. ಹಂಗಾಗಿ ನಾವು ಕಳ್ಸಿದ್ವಿ 2 ಸರಿ ಸ್ಟೆಪ್ಸ್ ತಗೊಂಡೆ ಸ್ವಾಮಿ. 2 ಸರಿ ಸ್ಟೆಪ್ಸ್ ತಗೊಂಡ್ರು ಹೋಗ್ಲಿಲ್ಲ. ಅದಕ್ಕೆ ನಾನು ಹ್ಯಾಂಡ್ ಸಮನ್ಸ್ ಆರ್ಡರ್ ಕೇಳಿದೆ. ಆನರಬಲ್ ಕೋರ್ಟ್ ಹಸ್ ಅಗ್ರೀಡ್ ಟು ಗಿವ್ ದಿ ಹ್ಯಾಂಡ್ ಸಮನ್ಸ್.
Earlier what had happened? Earlier service?
ಅರ್ಲಿಯರ್ ಏನಾಗಿದೆ ಅಂದ್ರೆ ಸ್ಯಾಲರಿ ಮಿಸ್ಟೇಕ್ ತಗೊಂಡಿದೆ ಸ್ವಾಮಿ. ಅದು ಒಂದೇ ಒಂದು ಗ್ರೌಂಡ್. ಅದು
No, not that. What was R134
R1 to R3 ಸ್ವಾಮಿ. R4 ಡಿಲೀಟ್ ಮಾಡಿ
ನೋಡಿ. ಪೋಸ್ಟಲ್ ಟ್ರ್ಯಾಕ್ ರಿಪೋರ್ಟ್ ಅಲ್ಲಿ ಅಬ್ಸೆಂಟ್ ಅಂತ ಬಂದಿತ್ತು ಅಂತ ಇದೆ ಮೊದಲೇ. Where was the material to show that it was served now, apart from this hand summons?
ಹ್ಯಾಂಡ್ ಸಮನ್ಸ್ ಕೊಡ್ಬೇಕಾಗಿರೋದಲ್ವಾ ನಾವು ಹೋಗ್ಬಿಟ್ಟು ಅವ್ರಿಗೆ.
ಕರೆಕ್ಟ್ ಹ್ಯಾಂಡ್ ಸಮನ್ಸ್ ಸರ್ವ್ ಆಗಿತ್ತು ಅನ್ನೋದಕ್ಕೆ, ಬಿಕಾಸ್ ದೇರ್ ಇಸ್ ನಥಿಂಗ್ ಟು ಕಂಪೇರ್ ದ ಸಿಗ್ನೇಚರ್.
ಸರಿ ಸ್ವಾಮಿ, ನಂಗೊಂದು ಇನ್ನೊಂದು ಇದು ಕೊಡಿ, ಅವ್ರದ್ದು ಮತ್ತೊಂದು ಕಾಪಿ ಸರ್ವ್ ಮಾಡ್ಬಿಟ್ಟು ಬೇಕಾದ್ರೆ ನಿಮ್ಗೆ
ಕಾಪಿ ಸರ್ವ್ ಮಾಡೋದು ಬೇಡ, ನಾವು ಆರ್ಡರ್ ಮಾಡ್ತೀವಿ.
ಆಯ್ತು.
Appellant's counsel submits that she has submitted the proof of service of hand summons on 27 ಅಂತ ಹೇಳ್ತಾರೆ, 31 ಅಂತ 27 ಅಂತ ಹೇಳ್ತಾ ಇದ್ರೆ ನೀವು.
27 ಅಲ್ಲ ಸ್ವಾಮಿ, 20/7/23 ಜುಲೈ 20. ನಾನು ಪ್ರೆಸೆಂಟೇಶನ್ ಫಾರ್ಮ್ ನನ್ನ ಹತ್ರ ಸೀಲ್
33 ಇದೆ.
ಇಲ್ಲ, ನನ್ನ ಹತ್ರ ಸೀಲು ಸೈನ್ ಇದೆ ಸ್ವಾಮಿ. ಇಲ್ಲಿ 20/7/23ಕ್ಕೆ
ಆನ್ 27 2023. However, no such record is forthcoming. ಇದೆಯಲ್ಲಿ ಮತ್ತೆ ಇದ್ಯಾವ್ದು 31(3) ಬಂದೇನೋ ಹಾಕಿದ್ದೀರಲ್ಲ?
ಅವ್ರು ಡಿಲೀಟ್ ಮಾಡಕ್ ಒಬ್ರಿಗೆ ಹಾಕಿದೆ ಸ್ವಾಮಿ. ಅದು
ಡಿಲೀಟ್
4 ಇದೆ.
ಮಾಡೋದಲ್ಲ, ಅವ್ರಿಗೆ ಸರ್ವ್ ಮಾಡಿದೀವಿ ಅಂತ
ಇಲ್ಲ,
ಹೇಳಿ.
ಅವ್ರು ಡಿಲೀಟ್ ಆರ್ಡರ್ ಆಗಿದೆ ಸ್ವಾಮಿ. ಡಿಲೀಟ್ ಆರ್ಡರ್ ಆಗಿ ಅವ್ರು ಡಿಲೀಟ್ ಆಗೋಯ್ತು.
Same is not forthcoming in the record. Appellant's counsel, petitioner's counsel. Petitioner's counsel shall take fresh notice to respondents 1 and 2.
1 to 3, Swami. 1 to 3.
3 gyaro 1 to 3, no? 1 to 3 for service through the process branch of district court Ramanagara. ರಾಮನಗರದ ತಾನೇ ಇದು?
ಹೌದು ಸ್ವಾಮಿ, ರಾಮನಗರ ಇದ್ದು.
ಯಾವ್ದಾದ್ರು ತಾಲೂಕಲ್ಲಿ ಸೀನಿಯರ್ ಸಿವಿಲ್ ಜಡ್ಜ್ MSc ಹಿಂಗೆ ಇನ್ನೊಂದು ಪಕ್ಕದಲ್ಲಿ ಫಾರ್ ಸರ್ವಿಸ್ ಥ್ರೂ ಅಲ್ಲ ಪ್ರೊಸೆಸ್ ಬ್ರಾಂಚ್ ಆಫ್ ಸೀನಿಯರ್ ಸಿವಿಲ್ ಜಡ್ಜ್ CJM and MACT Ramnagar. Needful shall be done within 10 days. On doing the needful, issue notice to response 1 to 3 as aforesaid. List on record.
4 weeks. 6-3.
Much obliged.
Cell number 2, Manjula Tejasvi, Sharad Gowda GB.
Depth of R4. R4 is dead ಅಂತ ಇದೆ.
The deceased man.
ಎಲ್ಲಾರು ಸಿದ್ರೆ ನೀವು ಈಗ ಕೇಳ್ತೀವಿ.
Yeah, all the LRs are already on record.
To file a memo that they are the survive.
Right.
In the memo
In-
it stated that
In the memo that I have filed along with the, ಹೇಳಿದೀನಿ ನಾನು,
legal aids of fourth respondent is
it's already on record ಅಂತ ಹೇಳಿದೀನಿ.
ಅವ್ರು ಯಾರು ಅಂತ ನೀವು ಹೇಳಿಲ್ಲ ಅಷ್ಟೇ. Fourth respondent is survived by whom?
My lord, other respondents, my lords, respondent number 1, 2, 3 and 5.
ಅದನ್ನ ಕ್ಲಿಯರ್ ಆಗಿ only other
Sorry, I should have specified.
only because
My lord, respondent,
6 to 9 are ಅವರು.
For 8 and 9 copy not served, madam.
They were respondents before the tribunal, 6 to 9. So he is survived by respondent number 1 to 3 and 5.
5.
Copy ಇಲ್ಲ ಇದ್ರು ಒಂದು ಕೊಡಿ. For 8 and 9 copy not served. For respond number 8 and 9 copy not served.
No. Okay. Counsel for response. You are appearing for all the response. I mean response 1 to 5 are.
1 to 5, at all 4 is no more. I represent other respondents.
Has submitted the memo reporting the death of respondent number 4 and that respondents 1 to 3 and 5 are the surviving heirs of respondent number 4.
4, please. ma'am.
Appellant's counsel shall amend the cause title of the appeal memo accordingly and furnish the copy of the amended appeal memo. Yes sir, copy serve ಮಾಡಿಲ್ವಾ ನಿಮಗೆ?
No, madam. 8 and
You are for ours.
or 8 and 9.
ಕೊಡಿ ಅವ್ರಿಗೆ.
7 and 8.
Or state. Third, ನಿಮ್ಮಲ್ಲಿ third ಅಂತ ಇದೆ ಅಲ್ರಿ?
Hello, sir. Copy.
They are third unrepresented. ಆಯ್ತು ರಿಕ್ವೆಸ್ಟ್ ಮಾಡಿಸ್ಕೊಳ್ಳಿ ಅವ್ರ ಹತ್ರ.
Please.
Otherwise your people have to come and give you the copies.
Please.
ಆಯ್ತು. ಏನಿದು withdrawal is filed.
I have filed an application, 50% deposit ಮಾಡಿದ್ದಾರೆ.
But ಈಗ to whom?
But
ಇದೆಲ್ಲ ಮಾಡ್ಕೊಂಡ್ಮೇಲೆ ನಾನು. If there is any dispute regarding the liability, you have examined, whom did you examine? RW1 and RW. So far as I 1,024 for withdrawal of the amount in deposit, appellant's counsel submits that the appellant's liability to pay compensation is under dispute. Okay. Records ಬಂದಿಲ್ಲ.
ಇಲ್ಲ.
Therefore, consideration of I 1,024 is deferred till the receipt of the TCRs. Call for the TCRs. ಅದನ್ನ comply ಮಾಡಿ ಉಳಿದಿದ್ದಾರೆ.
just for a date, my lord, because,
That's call for TCRs. List on.
7-3.
please.
Cell number 3, Bhagirathi L. Bhojaraja.
That's right. ಕೊಡೋದಿಲ್ಲ ಕೇಸ್. I 1 and 2. ರಿಕ್ವೆಸ್ಟ್ 2 weeks. ಇದ್ಯಾರಿಗೋ ಒಬ್ರು ನೋಟಿಸ್ ತಗೊಳಕ್ರೆ ಹೇಳ್ಬೋದಲ್ಲ? ಚೋಳಮಂಡಲಂ. Division, right. Dismiss ಆಗಕ್ಕಿಂತ ಮೊದಲು who was the advocate earlier? For respondent, for respondent number 1, ಯಾರು appear ಆಗ್ತಾರೆ? Insurance company. Are you aware who are appearing? Okay, that request. 2 weeks time is granted to the party. ಕೊಡಿ ಒಂದು 2 weeks ಕೊಡ್ತೀವಿ ಅಷ್ಟ್ರಲ್ಲಿ.
Cell number 4, Mohammed Tahir, P. Prasanna Kumar.
Just try that.
2021.
ಕಂಪ್ಲೈ ಮಾಡಲಿಲ್ಲ ಅಂದ್ರೆ ಮತ್ತೆ ಡಿಸ್ಕಸ್. ನಾನ್ ಫೈಲಿಂಗ್ ಆಫ್ ಸೆಕೆಂಡ್ ಸೆಟ್ ಏನು? You have filed already?
Yes, for the matter today.
See, you filed this appeal in 22.
Hmm.
For 2 years, you've not filed second set. Deliberately? Okay, after
December.
that.
ಯಾವಾಗ? This December? ಅಲ್ಲ, even otherwise that was before division bench it seems. ಇಲ್ಲ, it was single bench. At request 10 days time is granted for the benefit. ನಿಮ್ ಫೈಲೇ ಮಿಸ್ಪ್ಲೇಸ್ ಆಗಿದೆ.
Cell number 5, Narendra Gowda.
ಪ್ರಸನ್ನ ಕುಮಾರ್ ಇದಾರಲ್ಲ, ಬೆಳಿಗ್ಗೆ ಯಾವ್ದೋ ಒಂದು ಮೆನ್ಷನ್ ಮಾಡಿದ್ರೆ ಹೇಳಿದ್ರಲ್ಲ. ನರೇಂದ್ರ ಗೌಡ ಯಾವ್ದು? ನಾನ್ ಫೈಲಿಂಗ್ ಆಫ್ ಕಾಸ್ಟ್ ಪೇಡ್ ರಿಸಿಟ್ಸ್, ನಾನ್ ಕಂಪ್ಲೈನ್ಸ್ ಆಫೀಸ್ ಸಬ್ಸೆಕ್ಷನ್ ಫಾರ್ 6. ಯಾವ ಇಯರ್ ಅದು? 2023. What was the order this last time happened? High Court levels, no representation for the appellant. Sanjay Anand. It's a dismissal, no? Dismiss ಆಗಿದೆ. Petition filed against respondent number 1 is dismissed. Insurance 2 and 3 award 83%. No representation for the appellant. Finally, 1 week time is granted to the full failing which appeal shall stand dismissed.
Cell number 6, H.L. Pradeep Kumar.
6 for this one. You were representing the ಅಲ್ಲ, ಇದ್ರಲ್ಲೇನೋ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕೊಂಡಿರಲ್ಲ. Who has filed these applications for transposition? Appellant filed 6. Pleading of appellant as ಮತ್ತೆ ಅದನ್ನ ತೋರಿಸಿದ್ದಾರೆ. Formal parties, therefore their names will be deleted. No, impleading ಅಲ್ಲ, delete. If they are not joining the appellant, they need to be impleaded as correspondents. No proof is produced regarding this. You have produced the proof, no? Apply ಮಾಡಬೇಕಿತ್ತಲ್ಲ ಅವ್ರನ್ನ. Then correct is why have you not transposed them? Last time you saw dismissal again. Their petition deletion ಕೇಳಿದ್ರಿ, ನಾವು ಕೊಡೋದಿಲ್ಲ ಅಂತ ಹೇಳಿದ್ವಿ. They are already party, but last time you only sought to delete them. So we said, how many times you keep oscillating? ಈಗ ಅವ್ರ ವಕಾಲತ್ ಹಾಕಿದ್ರೆ ಇಲ್ವಾ ಇವನ್ ಇಫ್ ದೇ ಆರ್ ಪ್ಲೇಸ್ಡ್ ಎಕ್ಸ್ ಪಾರ್ಟಿ why we submit that appeal file the parole therefore their names may be deleted oral submission ಈಗ ನಾವು we are withdrawing that submission ಇವ್ರಿಗೆ ವಕಾಲತ್ ಹಾಕಿದ್ರ ನೀವು ಅಪೀಲ್ ಫೈಲ್ ಮಾಡ್ಬೇಕಾದ್ರೆ ಅದು ಆಫೀಸ್ ಸಬ್ಸೆಕ್ಷನ್ ಏನಾರ ಐತ ನೋಡಿ counsel submission with regard to office subsection that is appellant 5 and 6 have to execute the wakalat anta ಇದೆ ಅದರಲ್ಲಿ ಕಾಸ್ಟ್ ಹಾಕ್ತೀವಿ we'll impose cost correct then if you had no wakalat why did you show them as appellants party ಹೇಳಿದ್ರೆ you have a responsibility if somebody does not execute the wakalat how can you show them as appellants and once you come and say that delete their names now you say you are not pressing that prayer they should be parties before the court either as the appellants or as the respondents illadre appeal dismiss ಮಾಡಬೇಕು ಅಂತ ಆರ್ಡರ್ ಮಾಡ್ತೀವಿ ಅಷ್ಟೇ
See, the second time this issue is coming up before this court. Last time 21-3, same submission made resulted in an order. You don't comply with that order. And now we are practically 1 year after that order and you're making the same submission, appearing for a statutory body. You're complying in installments. If any further order is passed, the appellant will be entitled to proceed against you personally in the manner of prosecution of this appeal. Please be careful. You're a professional. You're treating this with the utmost casualty. After that 21-3 order, you've not applied your mind what is to be done. Now today the matter is listed, you just come and making some submission without realizing what is to be done. 21-3 order is very clear. Please read 21-3 order. You definitely don't have it.
You represent an organization. ಎಂತವ್ರಿಗೆ ಕೊಡ್ತಾರೆ ಅಲ್ಲ ಎಂತವ್ರಿಗೆ ಕೊಡ್ತಾರೆ ಅವರು
ಮುಂದೆ Precisely. So what were you supposed to do about it? Nearly 1 year has passed.
ಬಿಸ್ನೆಸ್ ಮಾಡಬೇಕು ಆರ್ಡರ್
Will impose costs payable to the legal service authority. You get any number of days. Only the zeros of the cost will increase. So you decide what you want to do.
ಇದಕ್ಕೊಂದು ಸಿಗ್ನೇಚರ್ ನಿಮ್ಮದ್ರಲ್ಲಿ ಸಿಗ್ನೇಚರ್ ಇದೆ ವಾಟ್ ಕೈಂಡ್ ಆಫ್ ಸಬ್ಮಿಷನ್ಸ್ ಆರ್ ದಿಸ್ ಡಸಂಟ್ ಇವನ್ ಬೇರ್ ದ ಸಿಗ್ನೇಚರ್ ಆಫ್ ಅಡ್ವೊಕೇಟ್ ಅಲ್ಲ ಮೆಮೋ ಅಂದ್ರೆ ಅದಕ್ಕೆ ಸಿಗ್ನೇಚರ್ ಬೇಡವ ಅಡ್ವೊಕೇಟ್ ಅಲ್ಲ ಇದು ಪ್ರೆಸೆಂಟೇಶನ್ ಫಾರ್ಮ್ ಬೇಡ ಅಲ್ಲ ವಕಾಲತ್ ಇದು ಏನ್ ಸಬ್ಮಿಟ್ ಮಾಡ್ತಾರಕ್ಕೊಂದು ಸಿಗ್ನೇಚರ್ ಮಾಡ್ಬೇಕಲ್ಲ ಮಿನಿಮಮ್ how long you are practicing advocate it is certainly not to humiliate you but responsibility ಇರಬೇಕಲ್ಲ ನಿಮ್ಗೆ ನೀವು ಅದಕ್ಕೆ ಕೇಳ್ತಾ ಇದ್ದೀವಿ ಎಷ್ಟು ವರ್ಷದಿಂದ ಪ್ರಾಕ್ಟೀಸ್ ಮಾಡ್ತಾ ಇದ್ದೀರಿ ಅಂತ ಎಷ್ಟು ವರ್ಷದಿಂದ ಮಾಡ್ತಾ ಇದ್ದೀರಿ 10 years ಪ್ರಾಕ್ಟೀಸ್ ಮಾಡಿ ಇದನ್ನ ಸಬ್ಮಿಟ್ ಮಾಡೋಗಿದ್ರ ಮೇಲೆ ಒಂದು ಸಿಗ್ನೇಚರ್ ಮಾಡ್ಬೇಕು ಅಂತ ಗೊತ್ತಾಗೋದಿಲ್ವಾ
Next time, at least you should have a better excuse.
ಇದಕ್ಕೊಂದು ಸೈನ್ ಹಾಕಿಸ್ಕೊಡಿ ಅವ್ರ ಹತ್ರ ನಾನು ಕಳ್ಸಿದ್ದೀನಿ appellant submits memo along with the copy of ಎಲ್ಲಿ ಡೆಪಾಸಿಟ್ ಮಾಡಿದ್ದು ಬರೀ ಡಿಡಿನ ಚೆಕ್ ಇದು ಡೆಪಾಸಿಟ್ ಡಿಡಿ ಅದು ಶುರು Proof of deposit of this, ಎಷ್ಟಿಲ್ಲ? ಎಷ್ಟು amount? 4,34,000. 43,24,000. Award ಎಷ್ಟಾಗಿದೆ? ಶಾಕ್ ಅವ್ರು ಹೊಡೆಸ್ಕೊಳ್ತಾರೆ, ಇವ್ರು ಹೊಡೆಸ್ಕೊಳ್ತಾರ ಅಂತ. ಎಲೆಕ್ಟ್ರಿಸಿಟಿ 28,28,940. ಬಹುಶಃ ಪೆನಾಲ್ಟಿನೂ ಹಾಕಿರ್ಬೇಕನ್ನ ನೋಡ್ರಿ.
ಅಲ್ಲ ಇಲ್ಲಿ advocate for appellants ಅಂತ ಇದೆ.
8,000 along with interest at 12% per annum. Response liable.
Presented by ಅಂತಿದೆಯಲ್ಲ.
ಮತ್ತೆ ಇದು ನೋಡಿ, ಇದು ಇವರಿಗೆ ಸಂಬಂಧಪಟ್ಟಿದೆ. ಅಮೌಂಟ್ ಬೇರೆನೇ ಇದೆ ಅಲ್ಲ ಇದರಲ್ಲಿ. ಡಿ ಅಲ್ಲಿ ಎಷ್ಟಿದೆ ಅಮೌಂಟ್? ಅದು ಡಿ ನಂಬರ ಇಲ್ಲ ಸರಿ 43 lakhs. ಬಟ್ ಕ್ಲೇಮೇ ಅಷ್ಟಿಲ್ವಲ್ಲ ಇದರಲ್ಲಿ ಅವಾರ್ಡ್ ಆಗಿರೋದು. 43 lakhs 24,827. ಅವಾರ್ಡ್ ಆಗಿರೋದು 23 lakhs. ಎಷ್ಟು ಅದು? 28 lakhs. ಅದಕ್ಕೆ ಪೆನಾಲ್ಟಿ ಏನಾದ್ರು ಹಾಕಿದ್ರೆ 12% interest. What is the case number before that?
They withdrawn the amount also.
Number 2 of 2018.
They withdrawn the amount. Then what's the use of this appeal?
Release ಆಗ್ಬಿಟ್ಟಿದೆ. No stay is operating. Court fee.
And what have you done after October?
They facilitated ಅಷ್ಟೇನೆ.
Combination is good. Combination is good, appellant and counsel. Correct. Complementing each other.
ಇದು ಯಾವ್ದಿಲ್ಲ? ಹೊಳೆ ನರಸೀಪುರ.
All right, they've released it. So therefore what is your submission thereafter?
What remains now?
What remains?
See, if really you are interested, whether you are a client or you are interested, you are not allowing for that withdrawal. You are pursuing the matter here. Or this is only,
Okay, now that they've,
or the appeal is only a show.
now they've brought it to your notice in October. Thereafter, what is your decision? What do you want to do now? Have you at least asked them on record officially what instructions, whether to prosecute the appeal?
23/7/2024. So you want to continue the appeal or not?
Only 50.
No. Peruse the office note and seen that amount is deposited and no stay is operating and court fee is paid. Hence, application is allowed. Office is directed to release the deposited amount in favor of the petitioner as per final order through RTGS theft.
Page number 6.
50% deposit. Page number 6 of
43 lakhs. Out of law. Page number 6 and out of that. ಮೊತ್ತ ಅದು ಕನ್ನಡದಲ್ಲಿ.
ಅಲ್ಲ ಅಲ್ಲಿ ಅದು ಮೊತ್ತ ಎಷ್ಟು ಇರ್ಲಿಲ್ಲ ರಿಲೀಸ್ ಮಾಡೋದಕ್ಕೆ ಅಮೌಂಟ್ FD is 21,62,400.
That is in terms of the impugned order. You're reading the office note. See the judicial order on the right hand side. Entire amount.
It's very strange, difficult to comprehend. Hold on, but what is this? There is Sescam, yavudidu? Sescam. Don't know how it's shocking. But and DD for rupees eಷ್ಟದು 43,24,827 and copy of the order sheet of the order sheet in ECA number 2 of 2018. The said records show that 21 ಅಂತ ಮಾಡಿದ್ದಾರೆ. Balance the amount is deposited and commissioner has even ordered for payment of the same. ಇದರಲ್ಲಿ operative portion of the order. ಅಲ್ಲ 50% ಕೊಟ್ಟು 50% ರಿಲೀಸ್ ಮಾಡಿದ್ರು ನೋಟಿಸ್ ಆಲ್ರೆಡಿ ರಿಲೀಸ್ ಅಷ್ಟೇ ಶಾಂತಿ ಸರ್ವೈವ್ ಆಗೋದಿಲ್ಲ ಅಲ್ಲ 50% ಇದೆ ಅಲ್ಲ ಇನ್ನು ದೇ ಕ್ಯಾನ್ ಫೈಟ್ ಟು ದಟ್ ಎಕ್ಸ್ಟೆಂಟ್ ದ ಕಾಸ್ಟ್ ಇಂಪೋಸ್ ಮಾಡಿದ್ದ ಅವಾಗ 18/1/2024 costs are not paid. Okay. Even the order dated 21/3/2024 is not compliant to ಮಾಡಿಲ್ಲ. What is ಏನೋ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ನೋ ಸ್ಟೇ ಅಂತ ಹೇಳಿದಾರಲ್ಲ ಅದರ
You filed this appeal 1.5 years back. Notice is not even ordered.
This is not in order. ಅಲ್ಲ ರಿಲೀಸ್ ಮಾಡಿಸ್ಕೊಳ್ಳೋದು
Obviously, in terms of
Very-
31.
very poor performance. ಅಂದ್ರೆ ಯಾವ್ದು ಸರ್ಕ್ಯೂಟ್ ವರ್ಕ್ learner council in your SESCOM no circuit works, no lines operate.
Deliberate.
24 regarding appellant number 5 and 6 is not complied. Request finally 10 days time is granted to comply the aforesaid office subsection and the order dated 21/3/2024. ಕಾಸ್ಟ್ ಕೊಡೋದಿದೆ 500 ರೂಪಾಯಿ ಕಾಸ್ಟ್ ಕೊಟ್ಟಿಲ್ಲ ಅಲ್ಲಿ 43 ಲಕ್ಷ ಕೊಟ್ಟಿದ್ದಾರೆ. Failing which the appeal shall stand dismissed. ಕಾಸ್ಟ್ ಹಾಕಿಲ್ಲ ನಮ್ಮ
Cell number 7, Jagdish Jr.
Including appellant 5 and 6 as correspondent, 6075.
What has happened in the judgment, there is no immediate mistake to be. The award that is been mentioned, that is one objection.
What is the name of the appellant?
No, there mentioned, but the
Harsha.
award,
Which appellant? Appellant number 2, na?
two,
Appellant number 2. Oh, in the award, what is her name?
award copy ಅಲ್ಲಿ R ಅಂತ ಇದೆ ಪಕ್ಕದಲ್ಲಿ.
No, appellant number 2 is Bhagya. Stated on
It is proper. The
Council-
award copy error by the.
award ಅಲ್ಲಿ ಏನು ಭಾಗ್ಯ ವೈಫ್ ಆಫ್ ಗೋಪಾಲ್ ಅಂತ ಇದೆ.
ಅಲ್ಲ ಅದೇ ಇಲ್ಲ ಮೇಲ್ಗಡೆ ಇನಿಷಿಯಲ್ ಇದೆ ಅದು ಭಾಗ್ಯ R ಅಂತ ಮಾಡ್ಬಿಟ್ಟಿದ್ದಾರೆ.
ಇದ್ರಲ್ಲಿ ಇದು ಜಡ್ಜ್ಮೆಂಟ್ ಅಲ್ಲಲ್ಲ ಅವಾರ್ಡ್ ಅಲ್ಲಿ ಇದೆ.
Award,
ಅವಾರ್ಡ್ ಅಲ್ಲಿ
judgment is proper.
ಹಾ.
Award ಅಲ್ಲಿ R ಅಂತ.
ಏನೋ ಮುಂದ್ ಕೈಯಿಂದ ಬರ್ದಂಗಿದೆ ಅದು
ಹಾ.
ಕೈಯಿಂದ ಬರ್ದಿದ್ದಾರೆ.
ಹೌದು.
ದಟ್ ಇಸ್ ಒನ್ ಥಿಂಗ್. ಮತ್ತೆ ಕೌನ್ಸಿಲ್ ವಿತ್ ರಿಗಾರ್ಡ್ ಟು ಆಫೀಸ್ ಸಬ್ಜೆಕ್ಟ್ ವೆಹಿಕಲ್ ನಂಬರ್ ಟು ಬಿ
Vehicle number, ಅದರಲ್ಲಿ issues ಅಲ್ಲಿ correct ಆಗಿದೆ. It
ಅಲ್ಲ
is
ನಂಬರ್ ಟು
properly
ಬಿ ಕರೆಕ್ಟೆಡ್
ಹಾ.
discrepancy in the vehicle number from page 2. What is page?
In page 12, yeah, internal page.
The page 2 of the award. What is page 2 of your appeal memo or award?
Appeal ಇದರಲ್ಲಿ para number 2, actually page 2 is para 2 of the award, para 2 of the award judgment.
Judgment is not in your appeal memo.
Para 2 of the judgment, it is mentioned as NT.
KA 03 NT 1537.
37. In next ಇದರಲ್ಲಿ issues ಅಲ್ಲಿ ಇದೆ. Issues ಅಲ್ಲಿ ಎರಡು ಕಡೆ ಇದೆ. Page 4 ಅಲ್ಲಿ page
MT ಅಂತ.
ಅದ್ರ MT is proper. MT is proper. ಅದು ಒಂದ್ ಕಡೆ NT ಅಂತ ಟೈಪ್ ಆಗೋದು. ಎರಡು ಕಡೆ MT.
ಇಲ್ಲೊಂದಿದೆ KA ಅದು ಇನ್ನೊಂದು ವೆಹಿಕಲ್.
ಇನ್ನೊಂದು offending vehicle, one which he was driving was MT.
Only in those
ಒಂದ್ ಕಡೆ ಮಾತ್ರ MT ಅಂತ ಆಗಿದೆ.
ಎಲ್ಲರಿಗೆ Correction ಮಾಡ್ಕೊಳ್ಳೋದು. For the appellant's counsel on office objection. The record show that the discrepancy has arisen because of the mistake committed by the tribunal in the order. Therefore, counsel submission is accepting the counsel submission, office objection is overruled. However, communicate this order copy to the trial court. ಹಂಗಂದ್ರೆ ನಮ್ಮ ವೆಹಿಕಲ್ ನಂಬರ್ ಅಷ್ಟೇ ಅಲ್ವಾ? Office objection regarding ಅಂತ ಬರ್ಕೊಂಬಿಡಿ. Regarding misdescription of payment number 2 in the award and the vehicle number of the vehicle bearing ಅಂತ ಹೇಳೋನಿಲ್ಲ. ಮತ್ತೆ K03 MT 1537.
MT ಬರ್ಬೇಕು ಒಂದ್ ಕಡೆ ಏನಿದೆ
1537. Accepting the counsel submission, office objection overruled. Communicate the copy of this order to the tribunal for needful. ಮತ್ತೇನಾಗ್ಬೇಕು ಇದರಲ್ಲಿ? Who is for the
payments of it.
ಏನು ಇನ್ಶೂರೆನ್ಸ್ ಕಂಪನಿ ಇನ್ಶೂರೆನ್ಸ್ ಇಲ್ವಾ?
Insurance ಇದೆ.
ಎಲ್ಲಿ ಪಾರ್ಟಿ ಮಾಡಿ?
But what the court has said is
ಅಲ್ಲ ಪಾರ್ಟಿ ಮಾಡಿಲ್ವಲ್ಲ ನಿಮ್ ಯಾವ್ದು ನೋ ಇನ್ಶೂರರ್ ಇಸ್ ಪಾರ್ಟಿ ಇಲ್ಲೇ ಇಲ್ಲ, ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲೂ ಇಲ್ಲ.
ಹೌದಾ? ಅಲ್ಲ, ಇದರಲ್ಲಿ ಇನ್ಶೂರೆನ್ಸ್ ಇರ್ಲಿಲ್ಲ ಅನ್ನೋದು ಒಂದು. ಎರಡನೇದು ಬಂದಿದ್ದೇನೆ ಆಕ್ಸಿಡೆಂಟ್ ವಾಸ್ ನಾಟ್ ಡ್ಯೂ ಟು
ರೈಟ್. ಬಟ್ ಇದ್ಯಾರ ಇನ್ಶೂರರ್ ಇದ್ರೆ ನೋಟಿಸ್ ತಗೊಳಕ್ ಹೇಳೋಣ ಅಂತ ನೋಡಿ.
ಇಲ್ಲ
ಇಶ್ಯೂ ನೋಟಿಸ್ ಟು ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 1 ಕಾಲ್ ಫಾರ್ TCS. ಲಿಸ್ಟ್ ಆಫ್ ರೆಸಿಪ್ಟ್ ಆಫ್ TCS. ಅಲ್ಲಿ ಡೇಟ್ ಕೊಡಿ. ಲಿಸ್ಟ್ ಆಫ್ ರೆಸಿಪ್ಟ್ ಅಂತ ಬೇಡ.
18/3.
18th.
much of it.
Seal number 8, Suresh Shad.
No objection to the cost title of the judgment of the operative portion. Date of disposal ತಪ್ಪು ಮಾಡಿದಾರ ಎರಡು ಕಡೆನಾ?
ಈ ಪೇಜ್ ನಂಬರ್ 41 ಅಲ್ಲಿ 24/22 ಅಂತ ಟೈಪ್ ಆಗಿದೆ. Presiding officer has signed on 17/10/2022.
Decided on 24/8/2022 ಅಂತ ಬರ್ದಿದ್ದಾರೆ.
ಹೌದು. ಸೈನ್ ಮಾಡಿರೋದು 17/10/2022 ಅಂತ. Because probably that could be award is amended at the page number 43. Award amended 17/10/22 ಆಗಿದೆ.
ಅಲ್ಲ ಅವಾರ್ಡ್ ಬೇರೆ ದಿವಸನೇ ಮಾಡ್ತಾರೆ ಅವರು. ಯಾಕಂದ್ರೆ ಮೊದಲು ಜಡ್ಜ್ಮೆಂಟ್ ಮಾಡಿ ಡಿಕ್ರಿನ ಇದಕ್ಕೆ ನೋಟಿಫೈ ಮಾಡಿ ಆಮೇಲೆ ಮಾಡಿರ್ತಾರೆ, ಅವತ್ತೇ ಮಾಡೋದಿಲ್ಲ. ಅದ್ರಲ್ಲಿ 17/10 ಇಲ್ಲೂ 17/10 ಇದೆ. ಪಿಟಿಷನ್ ಡಿಸ್ಪೋಸ್ಡ್ ಆನ್ ಇಲ್ಲೇ ನೋಡಿ, ಪಿಟಿಷನ್ ಡಿಸ್ಪೋಸ್ಡ್ ಆನ್ 24/8/2022, ಅವಾರ್ಡ್ ಆನ್ 17/10. Accepting the counsel submission, office objection is overruled. Condonation of delay ಇದೆಯಾ?
Insurance appeal as well.
ಮಾಡಿದಾರಾ? Which is that?
81 MFA 8179 of
There are two insurance company. Who has preferred the appeal?
United India Unit.
ಯಾರು
India Insurance.
ಅಡ್ವೊಕೇಟ್ ಯಾರು ಫೈಲ್ ಮಾಡಿದ? ಶಂಕರ್ ರೆಡ್ಡಿನಾ?
Please.
ಶ್ರೀ ಶಂಕರ್ ರೆಡ್ಡಿ, ಲಾಯರ್ ಸ್ಟ್ಯಾಂಡಿಂಗ್ ಕೌನ್ಸಿಲ್ ಫಾರ್ ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 2. ಇನ್ನೊಂದು ನ್ಯಾಷನಲ್ ಇನ್ಶೂರೆನ್ಸ್ ಕಂಪನಿ ಯಾರು?
Sure case appeared in that.
ಶ್ರೀಧರ್ ಕೇಸ್ ಅಂದ್ರೆ ಅವರ ಮೊದಲು ಬರ್ತಿದ್ರಲ್ಲ
DS Sridhar.
ಯಾರೋ ಹೀಸ್ ಅನ್ವೆಲ್ ಅಂತ.
Sridhar ಕೆ ಅವ್ರು ಬರೋದು. ಮೊನ್ನೆ ಒಂದು ಲೇಡಿ ಇದಾದ್ರಲ್ಲ.
ಹೌದಾ? ಅವ್ರಿಗೆ ಕೊಡ್ಬೋದಾ?
ಹ್ಮ್.
ಅವ್ರ ಇನ್ನೊಬ್ರು ಇನಿಷಿಯಲ್ ಏನು?
DS Sridhar.
DS.
K Sridhar.
And Shri K Sridhar for lawyer standing counsel for respondent 4 are directed to accept notice for the said respondents respectively. They are permitted to file the wakalat in the registry. ಅದೆಲ್ಲ ಹಾಕೊಳ್ಳಿ ನೋಡಿದ್ದಾರೆ. It is submitted that this matter is connected to MFA number so and so
8179.
817
of 22.
22. ಅದ್ರಲ್ಲೆಲ್ಲ ನೋಟಿಸು ರೆಕಾರ್ಡ್ಸ್ ಎಲ್ಲ ಆಗಾಗಿದೆ. ನೀವು ಅಪಿಯರ್ ಆಗಿದ್ದೀರಾ? ಓಕೆ. ಅದಕ್ಕೆ ನಾ ಆರ್ಡರ್ ಮಾಡೋದಕ್ಕೆ ಇಶ್ಯೂ ನೋಟಿಸ್ ಟು ರೆಸ್ಪಾನ್ಸ್ 1 and 3.
RP also appeared in the connected matter.
ಹಂಗಂದ್ರೆ ಇಶ್ಯೂ ನೋಟಿಸ್ ಮೇಡ ಲಿಸ್ಟ್ ಬೋತ್ ಮ್ಯಾಟರ್ಸ್ ಟುಗೆದರ್. ಅಲ್ಲ ಮೊದಲು ಅದು ಲಿಸ್ಟ್ ಆಗ್ಲಿ. ಅವ್ರು ಅಡ್ವೊಕೇಟ್ ನೋಟಿಸ್ ತಗೊಳ್ತಾರೆ ಅಂದ್ರೆ ಅವ್ರಿಗೆ ಡಿಸ್ಪೆನ್ಸ್ ಮಾಡಿ ಒಬ್ಬರಿಗೆ ಇಶ್ಯೂ ಮಾಡ್ಬೋದು. ಲಿಸ್ಟ್ ಆನ್
12/2.
12.
Seal number 9, Suresh Latur, Mahalingappa.
You know, the LRs of the deceased. Who is dead? Abhay Devang. Appellant number 2 is dead. Appellant number 2, claimant number 2 was Abhay Devang. Minor represented by his mother. You have shown 2 names, Murthy. ಯಾರು ತೀರೋದವ್ರು ಯಾರು ಅದರಲ್ಲಿ? ಮತ್ತೆ ಅವ್ರನ್ನ ಯಾಕೆ ಡಿಲೀಟ್ ಮಾಡ್ತೀರಾ? ಗಾರ್ಡಿಯನ್ ಚೇಂಜ್ ಮಾಡ್ಬೇಕಷ್ಟೇ. ಮೂರ್ತಿ ವಾಸ್ ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 3. ಸಾರಿ, ಕ್ಲೈಮೆಂಟ್ ನಂಬರ್ 3 ಮೂರ್ತಿ ವಾಸ್. ಅವ್ರ ಹೆಸರು ಬರೆದು ಅವ್ರದ್ದು ಡಿಲೀಟ್ ಮಾಡ್ಬೇಕಾಗಿತ್ತು. ಇಲ್ಲಾಂದ್ರೆ ಆಫೀಸಲ್ಲಿ ಒಂದು ನೋಟ್ ಹಾಕ್ಬೋದಿತ್ತು ಅಷ್ಟೇನೆ. ಇದು ಅಪೀಲ್ ಮೆಮೋ ಕಾಸ್ಟ್ ಟೈಟಲ್ ಅಲ್ಲಿ. ಇಲ್ಲ ಇಟ್ ಪೇರ್ಸ್ ಈ ಸರ್ವೈಡ್ ಬೈ ಈ 70 years. ಫಾದರ್ ಅವರು. ಇಲ್ಲ, ಅವ್ರ ಹೆಸರು ತೋರಿಸಿ ಅವರು ಈ ಸರ್ವೈಡ್ ಬೈ ಹೂಮ್ ಅಂತ ತೋರಿಸ್ಬೇಕು. ಅದ್ರ ಕಾಸ್ಟ್ ಟೈಟಲ್ ಫ್ರೀ ಅಂತ ಬರ್ದಿದ್ದಾರೆ. ಬರೆದು ಮತ್ತಿಲ್ಲಿ ಅದನ್ನ ವೈಟ್ನರ್ ಹಾಕಿದ್ದಾರೆ. one Murthy HK was claimant number 3 before the tribunal. ಅಲ್ಲೇನೋ ವೈಟ್ನರ್ ಯಾಕೆ ಹಾಕಿದ್ರಿ 3 ಅಂತ ಬರೋದು? ಯಾರು ಹೇಳಿದ್ರು ರಿಮೂವ್ ಮಾಡಂತ? ಅವ್ರು ಟ್ರಿಬ್ಯುನಲ್ ನಲ್ಲಿ ಇರ್ಬೇಕಾದ್ರೆ ತೀರೋಗಿರ್ಲಿಲ್ಲ. ವೇರ್ ಇಸ್ ಡೆತ್ ಸರ್ಟಿಫಿಕೇಟ್? Before the tribunal, his death was not reported. Though it is submitted that he died after the impugned award, nothing is produced in proof of the same. And it is not even stated he is survived by whom. Therefore, counsel submission is rejected. Needful shall be done within 2 weeks. Yes.
Cell number 10, Andral Lingappa, Krishna Kishore for R2.
Notice. Yes. All right. R1.
Only on quantum, sir.
Only on quantum. He was expert also.
Oh, before the tribunal.
Learned counsel for the appellant submits memo for dispensation of notice to respond number 1. The records show that respond number 1 had not contested the matter before the tribunal. Under the impugned award, liability to pay compensation is fastened to respond number 2, the insurer. Therefore, notice to respond number 1 is dispensed with as paid for. As requested by both sides, matter is delay ಇದೆ ಅಂತ as requested by both sides. ಎಷ್ಟು ದಿವಸ ಇದೆ? 122 days.
ಮಾಡಿ
Orders are number 1 of 2024. There is a 122 days delay in filing the appeal. Learned counsel for the second response fairly concedes for continuation of the delay. Considering the same and the reasons assigned, delay of 122 days in filing the appeal is condoned in the interest of justice. IA 1 of 2024 is disposed of accordingly. As requested by both sides, matter is referred to local.
Cell number 11,
ಇವತ್ತು ಕೊಟ್ಟಿದ್ದಾರೆ ಸರ್, ವಕಾಲತ್ ಹಾಕಿರಲಿಲ್ಲ, ಇವತ್ತು ಕೊಟ್ಟಿದ್ದಾರೆ, ಹಾಕ್ತೀನಿ
ಕಾಪಿ ಕೊಟ್ಟು.
ಪ್ಲೀಸ್.
ಅಲ್ಲ, ನಾವೇನು ಕಾಪೀಸ್ ನಾಟ್ಸ್ ಫರ್ನಿಶ್ಡ್ ಅಂತ ಬರ್ದಿದ್ದಾರೆ? ಇಲ್ಲ. PF was very first respondent ಮಾತ್ರ, ನಿಮ್ದು ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಇಲ್ಲ.
Sridhar Narayan Hegde, cell number 11.
ಅದೆಲ್ಲ ಹೋಗಿ ಬಂದಿದೆ, ನೋ ಸಚ್ ಪರ್ಸನ್ ಅಂತ ಹೇಳಿ. Have to request 2 weeks time is granted to the. Yes. If needful is done, issue notice to respondent, list on
19-3.
19th. You pay the process in the office.
Cell number 12, Shankar Narayan Bhatt, Geeta Raj.
Which is that connected matter?
1815 of 24.
That is also claimant's appeal.
Yes, so there are seven claim petitions clubbed together and common order of part.
ಇಲ್ಲಿ ಎರಡೇ ಇದೆ ಅಲ್ವಾ? 124 and 130. You said 7 claim petitions were clubbed. In this appeal, there were only 2 claim petitions.
And of course, in this appeal only 2 claims.
Huh.
And
You are seeking the
passenger,
appeal against respondent 1 is dismissed anta agide. So dispense ಮಾಡಬಹುದು.
driver, he said driver. And driver was dismissed. Against the owner and the insurance company, award has been passed.
Memo ಕೊಡಿ. Response 2 and 3 are jointly and severally liable. Respondent number 3 is directed to deposit the amount. Bರ್ತದೆ. Now counsel for the appellant submits memo for dispensation of notice to respondents 1 and 3, 1 and 2. 1 and 2. The records show that respondent number 1,
ಮೆಮೊ ಕೊಡ್ಬೇಕು ಅವ್ರಿಗೆ 2 ಶೀಟ್.
number 1. I'm sorry, the claim petition against respondent number 1 was dismissed.
Connected matter number.
And under the included award, liability to pay the compensation is fastened to respondent number 3, the insurer. Therefore, notice to respondent number 1 and 2 is dispensed with as paid for. Okay. File the memo. Yaar other side yaar appear agide.
ಸರ್ ತಕ್ಷಣ ತಂದ್ಕೊಡ್ಬೇಕು.
I am for R3 minutes. I have not received the copy. Copy kotre I will file what all.
9 days delay ಇದೆ ಬರೀ.
Can be condoned.
Copies ಕೊಡಿ ಅವ್ರಿಗೆ. Why have you not given the copies? ಅದೇನು ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ರೇಸ್ ಮಾಡಿಲ್ಲಲ್ಲ 18/6 ಅದು ಅವ್ರಿಗೆ ಗೊತ್ತಾಗೋದಿಲ್ಲ ಸರ್ ಮಾಡಿ. ನಾನು ಸ್ವಲ್ಪ ಆರ್ಡರ್ಸ್ ಐ ನಂಬರ್ ಎಷ್ಟು 1/24. Case of death.
ಇದೊಂದು ಫೈಲಿಂಗ್ ಫೋಟೋ.
Considering the reasons assigned to explain the delay, delay of 9 days in filing the appeal is condoned in the interest of justice. I 1/2024 is disposed of accordingly. What is the error here? ಇದೇನಾದ್ರು ಲೋಕ ಅದಾಲತಲ್ಲಿ ಸೆಟ್ಲ್ ಆಗೋ ಚಾನ್ಸ್ ಇದೆಯಾ ಅಥವಾ ಇಲ್ಲಿದ್ದು 2 ಕೇಸ್ ಇದು ಇನ್ನೊಂದಕ್ಕೂ ಅಪೀಲ್ ಹಾಕಿದೀರಾ?
ಹೌದು, 7 appeal ಇದೆ.
ಅಲ್ಲ ನಾನು 124 there were 2 claim petitions 124 and 130. This appeal is against 130. 124 ಅಲ್ಲಿ ಏನಾದ್ರು ಅಪೀಲ್ ಫೈಲ್ ಮಾಡಿದ್ದಾರೆ? It is submitted that this matter is connected. ಯಾವ್ದು ಕೊಡಿ?
Number 8, furnished.
MFA number 7. So list all the matters together on 2 weeks ಬಿಟ್ಟು ಕೊಡಿ. ಕಾಪಿ ಸರ್ ಮಾಡಿ ಸರ್.
17/2. 19/2. Number 13. ಸುರೇಶ್ ಲಾತೂರ್ ಮಹಾಲಿಂಗಪ್ಪ.
ಆಮೇಲೆ ಇಂಜುರಿ ಕೇಸ್ ಇದ್ರೆ ಮಾಡೋದಲ್ಲ ಡಿಸಬಿಲಿಟಿ ಕ್ವಶನ್ ಅಲ್ಲಿ
ಕಾಪಿ ಕೊಟ್ಟಿದ್ದಾರೆ, ಫಾರ್ವರ್ಡ್ ಮಾಡಿದೀನಿ ಸ್ವಾಮಿ ಕಂಪನಿಗೆ.
ಕಡಿಮೆ ಮಾಡೋದು.
ಸೆಟಲ್ಮೆಂಟ್ ಆಗುತ್ತೆ, ಕೈಂಡ್ಲಿ ರೆಫರ್ ಟು ಲೋಕದ
2895 ಮೆಮೋ ಫಾರ್ ಡಿಸ್ಪೆನ್ಸೇಷನ್ ಆಫ್ ನೋಟಿಸ್ ಟು R1 ಅವ್ರು ಹಾಕಿದಾರಾ? ಯಾವ ಫೈಲ್ ದ Audits and memo. The record show that respondent number 1 contest ಮಾಡಿದ್ರ ಅಲ್ಲಿ? 1 and 2 are jointly, however, respondent number. Under the included our liability to pay the compensation is fastened to respondent number 2, the insurer. And respondent number 1 had not contested the matter before the tribunal. Therefore, notice to respondent number 1 is dispensed with as paid for. As requested by both sides, matter referred to local.
ಕಂಡಮ್
Application 1 of ಹನ್ನೊಂದು ಮಾಡ್ಬೋದಾ?
ಮಾಡಿ.
ಮೈನರ್ಸ್ ಇದಾರೆ ಇಲ್ಲಿ 175 ಅನ್ಕಂಡೀಷನಲಿ ಕಂಡೋನ್ ಮಾಡ್ಬೋದಾ?
ಮಾಡಿ.
Submission now consider for respondent to concedes for condonation of delay. Considering the same delay of 175 days in filing the appeal is condoned in the interest of justice. IA 1/2024 is disposed of accordingly. That will, as requested by both sides, matter referred to local.
Still number 14. Venkatesh Kamath BR.
Yes, sir. Okay. 8 January.
R1 and R. ಡೆಪಾಸಿಟ್ ರಿಸಿಟ್ ಹೇಳ್ಕೊಳ್ಳಿ ಸರ್. R1 and R2 ನೋಟಿಸ್ ತಗೋಬೇಕು. ನಾನು ಕನ್ಸಿಡರ್ ದ ಅಪೆಲೆಂಟ್ ಸಬ್ಮಿಟ್ಸ್ ಮೆಮೊ.
ಇಲ್ಲ ಮೆಮೊ ಕೊಡ್ತಾ ಇಲ್ಲ ಅವ್ರು ಬರೀ
ಅಲ್ಲ ಅದ್ರೊಳಗೆ ಏನಾರ ಇದೆಯಾ ಇದರಲ್ಲಿ? ಏನಿದೆ? ಚೆಕ್ ಡೆಪಾಸಿಟ್ ಮೆಮೊ
ಹಾಕಿದ್ದೀರಾ ನೀವು?
ಇದಕ್ಕೊಂದು ಪ್ರಾಪರ್ಲಿ ಪಿನ್ನರ್ ಮಾಡ್ಕೊಡ್ಬೇಕಲ್ರಿ?
ಅವ್ರ ಕಾಪಿ
Yeah, already deposit. Non-consider for the appellant, 8th January 2000. Non-consider for the appellant submits that he has submitted the proof of deposit in the registry on 8/1/2025. Registry shall verify. At request 2 weeks time is granted to do the needful in respect of this phone number 1 and 2. ಅದನ್ನ ಕೊಡಿ, ನಾ ಇಲ್ಲೇ ಕೊಡ್ತಾ ಇದ್ದಾರೆ ಅನ್ಕೊಂಡು.
Seal number 15, Ramesh VK, Satish S.
My lord, appearing for the respondent here. My lord, appearing for the respondent.
Yes. Yes.
My lord, last date, this honorable court has ordered the appellant to deposit 10 lakhs rupees for extension of stay, but they have not complied with the order of this honorable court. Therefore, the stay may be vacated.
Yeah, automatic. If they are not deposited, it stands vacated. You can execute the order.
ಆಗ್ಬೋದು ಸ್ವಾಮಿ. ನಾಳೆ ಇದೆ ಎಕ್ಸಿಕ್ಯೂಷನ್ ಕೇಸ್, ನಾಳೆ ಇದೆ ಫ್ಯಾಮಿಲಿ ಕೋರ್ಟ್ ಅಲ್ಲಿ.
You are not deposited.
The-
Where is that proof? ಕೊಡಿ ನಾವು ಅದರ್ಸ್ ನೀವೇನ್ ಕೊಟ್ರು ಅದರ್ ಸೈಡ್ ಕಾಪಿ ಸರ್ವ್ ಮಾಡ್ಕೊಡ್ಬೇಕಲ್ವಾ? Have you served the copy of whatever you have filed in the registry? And even before us, it is not put up. ಇವತ್ತು ಹಾಕಿದ್ದಾರೆ.
My colleague is there in the court hall, my lord. My colleague is there in the honorable court hall.
ನಿಮ್ ಕೊಲೀಗ್ ಇದ್ರೆ leave something to him to do.
ಇಲ್ಲ ಸ್ವಾಮಿ, the appellant has come before the honorable court with unclean hands.
Right? When your colleague is here, let him boost his confidence. Yes. ಡೆಪಾಸಿಟ್ ಮಾಡಿದ್ದಾರೆ ಅಂತ ಹೇಳ್ತಾರೆ. ಇದು ಡಿಡಿ.
But ನಮ್ಗೇನು ಇನ್ಫಾರ್ಮೇಶನ್ ಇಲ್ಲ ಸ್ವಾಮಿ.
That's what we are telling her. You should serve the copies ಅಂತ ಹೇಳಿ. ಎಲ್ಲದ್ರಲ್ಲೂ ಕನ್ಫ್ಯೂಷನ್ ಆಯ್ತು. ಅದಕ್ಕೆ ಸಾಲ ಕೊಡ್ಲಿಲ್ಲ, ಇದನ್ನ ಕಾಪಿ ಕೊಡೋದಕ್ಕೇನು ಅದರ್ ಸೈಡ್ಗೆ? ಎಲ್ಲದಕ್ಕೂ ಎಕ್ಸ್ಕ್ಯೂಸ್ ಹೇಳಿದ್ರೆ ಕಾಸ್ಟ್ ಹಾಕ್ತಿವಿ ಅಷ್ಟೇನೆ.
We are
Madam, there is some limit.
10:30 we are standing
Limit
here.
for everything. He is sitting here.
ನನಗೆ 10.
Copy ಕೊಡಕ್ಕೆ sir. You didn't know how to serve on him. ಎಷ್ಟು ವರ್ಷ ಪ್ರಾಕ್ಟೀಸ್ ಮಾಡಿದ್ದೀರಿ? ಎಷ್ಟು? 20 years. 20 years ಸರ್ವಿಸ್ ಮಾಡಿದಿರಿ. ಅವ್ರು ಕಾಪಿ ಸರ್ವ್ ಮಾಡ್ಬೇಕಂತ ಗೊತ್ತಿಲ್ವಾ? We'll impose cost. ನೀವು ಲೇಟ್ ಆಗಿ ಡೆಪಾಸಿಟ್ ಮಾಡಿದ್ದಕ್ಕೂ ಕಾಪಿ ಸರ್ವ್ ಮಾಡದೇ ಇರೋದಕ್ಕೂ and these kinds of irresponsible submissions.
Morning only we submitted the copy to the office. That's why I hurry I came here. I'll give a copy.
ನಿಮ್ ಕೊಲೀಗ್ ಇಲ್ಲೇ ಕುತ್ಕೊಂಡಿದಾರಲ್ಲ ಅಷ್ಟೊತ್ತಿನವರ್ಗುನು. ಈಗಾದ್ರೂ ಒಂದು ಕಾಪಿ ಇಟ್ಕೊಂಡ್ ಬಂದಿದ್ರೆ ಕೊಡ್ತಿದ್ರಿ ಅವ್ರಿಗೆ.
ಮೇಡಮ್ ನಾನು ನಿಮ್ ಜೊತೆ ಮಾತಾಡಿದ್ದೀನಿ. ಅಪಿಯರ್ ಆಗಿದ್ದೀನಿ. ಪ್ಲೀಸ್ ಅದೆಲ್ಲ ಹೇಳ್ಬೇಡಿ ಮೇಡಮ್, ಪ್ಲೀಸ್.
It is always, my lord, the conduct of the appellant is always like that.
ನಾನು ಜೊತೆಲಿ ಇದೀನಿ, ನಾನು ಮಾತಾಡ್ತೀನಿ ಎಲ್ಲ.
ನಾವು ಚಾರ್ಜ್ ಮಾಡಿ ಚಾರ್ಜ್ ಮಾಡಬೇಡಿ.
ಲಾಸ್ಟ್ ಗೆ ನೀವು ನಾವು ಜೊತೆಲೇ ಅಪಿಯರ್ ಆಗಿದ್ದೀವಿ.
Always, my lord, making false submissions.
Lord Consider the appellant submits that she has submitted the proof of deposit today in the registry. Lord Consider the respondent submits that the copy is not served on him. Even there is delay in depositing the amount. Depositing the amount. ಏನು ನೀವು ವಿತ್ಡ್ರಾವಲ್ಗೆ ಏನಾದ್ರು ಪರ್ಮಿಷನ್ ಕೇಳಿದಿರಾ?
My lord, this is not, there is no.
My lord, permission may be given to withdraw, my lord.
ರಿಲೇಶನ್ಶಿಪ್
Because-
ಏನಾದ್ರು ಡಿಸ್ಪ್ಯೂಟೆಡ್?
ಇಲ್ಲ sir. There is-
Illa Swami.
2 children was there.
Deposited before the this court. There are 2 children.
Respondent was present before, sir.
One is married also.
ಅವ್ರು ಕುತ್ಕೊಳಕ್ ಹೇಳಿ, ಇಲ್ಲಿ ನಿಂತು ಅದೆಲ್ಲ ಮಾಡಿದ್ರೆ ನಮ್ಗೆ ಏನ್
ಕೂತ್ಕೊಳ್ಳಿ.
ಅರ್ಥ ಆಗುತ್ತೆ?
ನೀವು ಕೂತ್ಕೊಳ್ಳಿ.
One was her petition and another was his petition.
Yes, ma'am.
Section 9, another one is section. Maintenance was awarded intermittent. This is arrears
ma'am.
of
Yes,
intermittence.
So, sir, totally the interim, as on the date is 17,000 is was pending money. 17 lakhs.
17 lakhs.
Awarded in the
17 lakhs.
17 lakhs was pending.
awarded in the matrimonial
Award in the CMIS case.
case.
Criminal miscellaneous.
125.
120, yes, ma'am.
What happened? That order attained finality or
Attend the finality.
finality?
Yes, ma'am. So-
Because ಅವ್ರು retired ಆಗಿದ್ದಾರೆ job ಇಂದ, ಅವ್ರು pension ಬರಕ್ಕೆ ಇವ್ರು document ಕೂಡ ಕೊಡ್ತಾರೆ.
Those, yes,
Considering the overall facts and circumstances, the children were with her only.
yes, ma'am.
The respondent is permitted.
Major act.
ಕ್ಯಾಲ್ಕುಲೇಷನ್ ಬಗ್ಗೆ ಏನು ಡಿಫರೆನ್ಸ್ ಇಲ್ವಾ ಇದು?
ಇಲ್ಲ, sir.
ಇದೆ ಸ್ವಾಮಿ, ನಾವು ಆಲ್ರೆಡಿ ಕಟ್ಕೊಂಡು minus ಆಗಿಲ್ಲ.
Minus.
Memo of qualification also before.
ಅದ್ರಲ್ಲಿ ತುಂಬಾ ಅಲರ್ಟ್ ಇದೀರಲ್ಲ, ವಿಜಿಲೆಂಟ್ ಇದೀರಿ.
ಸ್ವಾಮಿ ಕಟ್ಟಿದ್ದು 2,000 ಫಸ್ಟ್ ಆಗಿದ್ದನ್ನ ಕಟ್ಟಿದ್ದೀವಿ. ಈಗ ಅವರು announcement ಹಾಕೋದು 15,000 ಮಾಡಿದ್ರು ಸ್ವಾಮಿ.
See, according to them, 17 lakhs was due.
ಈ
It
ಒಂದು
is 17 lakhs, my lord. Criminal miscellaneous 391 of 2015. Criminal miscellaneous 391 of 2015.
To digitally release the amount in deposit to the respondent and furnishing the required documents. ಏನಾಗ್ಬೇಕು ಮುಂದೆ?
permit me to withdraw the amount.
ಆಯ್ತಲ್ಲ, ಆರ್ಡರ್ ಆಯ್ತು.
Much.
ಇನ್ನೊಂದ್ರಲ್ಲಿ IA 1 of 2015 ಸ್ಟೇ ಪೆಂಡಿಂಗ್ ಇರೋದು ಯಾವ್ದು?
Call for the LCR act.
ಅಲ್ಲ, ಫಸ್ಟ್ ಮ್ಯಾಟ್ರ್ ಅಡ್ಮಿಟ್ ಆಗಿ ಆಗ್ಲೇ ಕಾಲ್ ಫಾರ್ ಆಗಿದೆ. 3464.
Connected matter, my lord. It is connected matter.
Divorce.
This is divorce petition, MC 800 of 2016. Both matters were clubbed.
ಕರೆಕ್ಟ್, ಒಂದ್ರಲ್ಲಷ್ಟೇ ಸ್ಟೇ ಬೇಕಲ್ವಾ?
ಹೌದು, sir.
Restitution, which is against restitution 800. MC 800 was
MC 800 of 2016 was for divorce,
Divorce.
filed by the appellant.
then
Which got
if
dismissed.
The petition is there, dismissed. What is there to stay?
MC.
ಹಾಕಿದಿರಲ್ಲ IA 1 of 2024 ಅಂತ.
ಹೌದು ಸ್ವಾಮಿ. ನಮ್ ಕಾಪಿ ಕೊಟ್ಟಿಲ್ಲ ಸ್ವಾಮಿ.
ಅದನ್ನೇನು ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಅಲ್ಲಿ ರೇಸ್ ಮಾಡಿಲ್ಲ. ಬರ್ದಿದ್ದಾರೆ 800 ಅಂತ. This appeal is preferred. Connected. This appeal is preferred challenging the dismissal of the appellant's petition.
MC 800 of 2016.
Petition in MC 800 of 2016 for a decree of divorce. Since the petition is dismissed, there is nothing to stay. IA 1 of 2024 for stay is misconceived and dismissed. ಅದರಲ್ಲಿ ರೆಕಾರ್ಡ್ಸ್ ಬರ್ಬೇಕಾ? ಲಿಸ್ಟ್ ಆಫ್ಟರ್ ದ ರಿಸಿಪ್ಟ್ ಆಫ್ TCRs. ಓಕೆ.
Seal number 16,
Much.
Sandesh TV.
Much obliged, my lords. Much obliged.
ಸಂದೇಶ್ ಟಿವಿ ಯಾರು ರೂಲ್ಸ್ ಇಲ್ಲ. Yes, you have to take notice to respond number 1 and 2.
Stay application business.
When you are seeking dispensation of notice to them, ಹಾಗಾದ್ರೆ ಮೊದಲನೇ ಸರಿ ಯಾಕೆ ನೋಟಿಸ್ ಮಾಡಿಸ್ಕೊಂಡ್ರಿ? 1 and 2. ಅಲ್ಲಂದ್ರೆ ಅಲ್ಲಿ ಏನಾಗಿತ್ತು ಅಪಿಯರ್ ಆಗಿದ್ರ? They had appeared through somebody. Liability ಯಾರ ಮೇಲಿದೆ?
Insurance company.
Respond number 3 shall deposit. You file a memo first for dispensation of notice. Now counsel for the applicant submits memo for dispensation of notice for respond number 1 and 2. Under the impugned award, liability to pay compensation is passed to respond number 3, the insurer. Therefore, notice to respond number 1 and 2 is dispensed with as per part. Delay condonation ಏನ್ ಮಾಡಲ್ಲ? 427. Delay
427 days ಇದೆ. ಕಾಪಿನೂ ಕೊಟ್ಟಿಲ್ಲ, ಕಾಪಿ ಕೊಟ್ಟು ಆಮೇಲೆ.
ಕಾಪಿ ಕೊಟ್ಟಿಲ್ವಾ ನೀವು ಇನ್ನೂ ಅವ್ರಿಗೆ? Now counsel for respondent number, he submits that the copies are not served on her. Okay. It is submitted that this matter is connect to MFA ಯಾವುದು? ಬರ್ಕೊಡಿಲ್ಲ. MFA number so and so list both the matters together. ಯಾವತ್ತು ಒಂದು date after 2 weeks.
19-2.
19.
Seal number 17,
Great.
E. Lakshmi Shra.
ಕಾಪಿ ಕೊಟ್ಬಿಡ್ಬೇಕಲ್ಲ ಒಂದ್ಸರಿ ಅವ್ರು ನೋಟಿಸ್ ತಗೊಳ್ಳೋ.
Audit the activity started.
ಅಲ್ಲಿ ಯೂಸ್ ಕೊಡ್ಬೇಕಲ್ಲ ಏನಾದ್ರು ಒಂದು ಕಾಪಿ ಇರುತ್ತೆ. Yes, awaiting service of notice of R1 and R2. What is that office note? ಏನಾದ್ರೂ connected matter ಇದೆಯಾ? Note vehicle number stated in page 5 is K1107. However, page 7 ಅವ್ರಿಗೆ mistake ಅಲ್ಲ. As per the office note, there is error in the award in mentioning in the award page number 5 and 7. 7 in mentioning the vehicle number. However, there is no dispute about the identity of the vehicles. ನಿಮ್ಮದೊಂದು ಇನ್ನೊಂದು ಯಾವ್ದು ವೆಹಿಕಲ್? ಒಂದೇ 2 ವೆಹಿಕಲ್. Correct, but liability is only against bus.
ಸರಿ ಮಾಡಿ.
Car, ಇನ್ನೊಂದು ವೆಹಿಕಲ್ ಕಾರ್.
ಲಕ್ಷ್ಮಿ.
There is no dispute regarding the identity of the vehicles. Therefore, office note does not survive. ಇನ್ನೊಂದು ಏನಾಗುತ್ತೆ? List on date notice ಬರ್ಬೇಕು.
22.
20.
Seal number 18 adjourned. Seal number 19, Ravish Benny, N. Woodley for R1.
We served the copy on the council for the aviator. Immediately after presentation.
ಹೌದು. ಅವ್ರು ಬರ್ತಾ ಇಲ್ವಾ?
ನೀವೇ ಸರ್ವ್ ಮಾಡಿ 2 ಕಾಪಿ
Having served the copy and the acknowledgement ಕೊಡ್ಬೇಕು, ಹಾಕಿದ್ದೀರಾ?
ಇಮಿಡಿಯೇಟ್ಲಿ ಆಫ್ಟರ್ ಪ್ರೆಸೆಂಟೇಷನ್. ನಾವು ಫೋನ್ ಮಾಡಿದ್ದೆ ಬೇರೆ ಕಡೆ ಇದ್ದೀನಿ ಇನ್ನೊಬ್ಬರು ಹೇಳಿದ್ರು ಅವ್ರು ಕ್ಲರ್ಕ್ ರಿಸೀವ್ ಮಾಡಿದ್ರು.
ಕಾಪಿ ರಿಸೀವ್ಡ್ ಇಲ್ಲಿದೆ ಅಲ್ಲ.
ಆರ್ ಎನ್ ಮುರಳಿ.
Accepting the council submission, office subsection regarding service of notice and aviator is overruled. ಏನಿದೆ ಅದರಲ್ಲಿ?
aforesaid 100% agreement part of the regular to motor.
2 vehicles were in. Was it pillion driver?
50% liability ಬರುವುದಿಲ್ಲ. 8,79,320.
You are the insurer of tractor, huh?
Deposit is not.
ನಿಮಗೆ 50% ಮಾಡಿದಾರ?
6%.
1 and 3 are in.
I'm seeking the dispensation to the 2 and.
We are disputing the negligence.
100%.
ಇಲ್ಲಿ ಆದ್ರೆ 100% ನಿಮ್ಮ ಮೇಲೆ ಇದೆ.
ಬಂದು ಎಡಗಡೆ ಬಂದು ನಮ್ಮ ಆ ಕಡೆ ಮೈಸೂರು ರೋಡ್ ಬೆಂಗಳೂರು ರೋಡ್ ಬಂದು
Dispensation to respond number 3.
may I pass it to the state please ma'am?
Right. Who is respond number 3? You are seeking dispensation to.
What about the vehicle?
owner of the vehicle had contested or not contested?
It appears before the tribunal.
Shivananda case, no?
Ramesh, SNR appeared. Not liability, only negligence. 100%. Therefore, I'm seeking the dispensation with the author.
Owner counsel for the appellant subjects memo for dispensation of notice to. He was also examined as RW. Notice to respondent number 3. On the ground that the appellant is not disputing the liability, but only question of negligence is in issue. Considering the same, notice to respondent number 3 is dispensed with as paid for. Delay in area.
Appeal is in there.
Appeal is in there. How much is awarded? 49 lakhs 69,000.
Some liability income higher income there is no proof for that. Income to be taken is not as per the.
Third admit, admit money.
Of the.
Third admit call parties says issue notice to response 1 and 2. Interim stay of execution of the impelled award. 1 and 2. Give it to them.
Parents.
Sorry. Now it's issue notice. Third admit call for TCR. Interim stay of execution of the impelled award in further orders. Subject to appellant depositing 50% of the award amount before the tribunal within 4 weeks from the date of the receipt of copy of this order. I-1 of 25 to disposed of accordingly. List after the receipt of TCS.
What is the amount?
50% of the award amount.
Before High Court.
Paid only deposit money.
Hearing on IA, seal number 20, O Mahesh.
And if alpha with TCR.
I tell.
Vijay Kumar SC for R6.
I appear for the appellant, my lord. 5 days delay may kindly be condoned, my lord.
Vijay Kumar.
Delay may be condoned. I am for asking.
2018 ago. 18. ಯಾಕೆ ಇಷ್ಟರವರೆಗೂ ಇನ್ನೂ ಡಿಲೇ ಕಂಡೋನೇಷನ್ ಎಲ್ಲ ಪೆಂಡಿಂಗ್ ಇದೆ?
ಅಲ್ಲಿ ನೋಟಿಸ್ ಸರ್ವ್ ಆಗಿಲ್ಲ, ಪೇಪರ್ ಪಬ್ಲಿಕೇಶನ್ ಎಲ್ಲ ತಾಂಡಿದ್ದಾರೆ, ಅದಕ್ಕೆ ಲೇಟ್.
ನಿಮಗೆ ಸರ್ವ್ ಆಗಿರಲಿಲ್ಲ?
ಅಲ್ಲ, ಬೇರೆ ಕ್ಲೈಮೆಂಟ್ಸ್ ಗೆ ಸರ್ವ್ ಆಗಿದೆ.
ಕೋಡಿ ರೆಸ್ಪಾನ್ಸ್.
ಕ್ಲೈಮೆಂಟ್ಸ್ ಗೆ ಪೇಪರ್ ಪಬ್ಲಿಕೇಶನ್ ಸರ್ವ್ ಆಗಿದೆ.
ನೀವ್ಯಾರೇನು ರಿಪ್ರೆಸೆಂಟ್?
ನಾನು ಓನರ್ ಗೆ R4, R6.
ರೆಸ್ಪಾಂಡೆಂಟ್ಸ್ ಸರ್ವ್ಡ್ ಅಂಡ್ ರೆಪ್ರೆಸೆಂಟ್. ಯು ಆರ್ ಫಾರ್ R6.
ಪ್ಲೀಸ್.
ಮತ್ತೆ ಇದರಲ್ಲಿ R1, R2 and 3 ಮೈನರ್ಸ್ ಅಂತ ಇದೆ ಅಲ್ಲ? Or court guardian appointment.
Represented, my lord.
Correct, but she has not turned up.
Claimants are served by substituted survey. R1, 4 and 5.
Record show that response 2 and 3 are.
2 and 3 are minors represented by R1.
Their mother, their guardian / mother. Tribunal nalli yaran madidru? She was the guardian. Petitions 1 to 5 represented by the natural mother, that is petition. Their mother / guardian, that is respondent number 1, has not turned up to protect their interest. Therefore, appellant shall file necessary application for appointment of court guardian for respondent number 2 and 3 within 10 days. Our application upon failing which appeal against response 2 and 3 shall stand dismissed. List on 10 days are later.
Pardon me?
You have to file application for court appointment of court guardian for them.
Please, please.
11-2.
Within 10 days you have to file application.
Yes.
Seal number 21, Pawan Chandrasekhar.
There is a conditional order by default non-compliance of office objection.
8/6/2023. 8/6 and 8/6
was granted, however, because of qualified reason, we are not complied.
Comply the office objection now.
Yes, madam. Before the protocol was. Before then.
Correct. Now we'll permit you to comply the office objections pending consideration of this. The office objection no? Page number 17 and 18 to be removed in judgment since filed twice. Court fee of ₹15 to be made good. 15 ರೂಪಾಯಿ ಕೊಡ್ಬೇಕಲ್ರಿ? Pending as precondition for consideration of I number 1 of 2023. Pending office objection shall be complied within 10 days. Al martira within 10 days. List on 10 days.
11-2. Seal number 22, Srinivas IIA, H.S. Lingraj for R2.
Yes. Substituted service to R1 by way of paper publication. Who is R1? Owner of the vehicle.
Twice on the left, no such person.
Left, no such person. Yes. Trial totally ex parte. Your petitioner is entitled to so and so compensation. Respond number 2, insurance company shall deposit the award amount. Liberty to recover the same from respond number 1 anta idea. Order summary number 1 of 24. Heard satisfied that service on of notice on respond number 1 in the ordinary process is not probable in the near future. Therefore, the appellant is permitted to take notice to respond number 1 by publication in Kannada Prabha, Kannada Daily Newspaper, Bangalore edition. As prefer, notice should be published on or before
25-2,
notifying the hearing date as
20th March.
23. List on 20. IA 1 of 24 should be discussed accordingly.
Seal number 23, Mushtaq Ahmad.
And the list on anta bantala. List on 20. Once 69 days in recalling application. Indian objection even. 2022. 7 office objection ಇದೆ ಅಂತಲ್ಲ. ಕೋರ್ಟ್ ಫೀನ ಕೊಡೋದಿಲ್ಲಲ್ರಿ ಇದ್ರ 15 ರೂಪಾಯಿ ಕೋರ್ಟ್ ಫೀ ಇರುತ್ತೆ. Dead person not to be made party. Natural guardian details to be stated. Council's signature on the second set of the as pre-consideration for as precondition for consideration of I number 1 and 2 of 2023. Pending office objection shall be complied. Idinu 2023 all hakidira. Shall be complied within 10 days. Failing which IA 1 and 2 of 2023 shall stand dismissed. List on 10 days only.
11-2. Seal number 24, Vilas Rangnath Datar, Vijay A.M.
The report of mediation center taken on record. As per the said report, matter is not settled. Yes. Other additional evidence, bring subsequent evidence. They have to be heard along with the main matter. Amendment of
and therefore, I would like to leave the ground of human desertion because there is no.
pending case and desertion.
Then you will have staying separately.
I have to note what is that subsequent development. You have to file any objections to
I filed my objections.
objection and
For addition to the.
first I wanted to see what is IA to go one by one. See, IA 1 of 2024 shall be considered along with the main matter.
Why I am saying.
That is production of additional evidence.
Yes.
Has to be considered along with the main matter. Order 41 rule 27.
Recording of a video recording.
So I have only registered for the consideration of this honorable
And
court.
first,
If the lordship uses, I will take a copy to them.
copy kodi or we are not furnished them copy. I have one of the
It is in pen drive.
whatever it may be, whatever materially.
Without the permission, reports I cannot, because I have not for the court. And therefore.
No. See, order 41, rule 27. Whatever evidence he adduces before the court, you are required to serve the copy and then.
Because this is a personal matter, very certain recording.
Right. He is a party. It is between them.
I want the written this one.
Hmm.
In IT, whatever has transferred, I have given it a copy of it. But then, so far as the pen drive is concerned, the permission of report, I thought.
So you want us to consider this, no pen drive. And unless you produce this, how can we consider? Sir, the ಕೊಡ್ಬೇಕಾಗತ್ತೆ. You can't say it's. That is one.
That is for additional evidence. Subsequent development, what has happened is.
To bring the
When we are put to the mediation. In the mediation, we wanted to really so the mediator that what were our terms, because there are some terms which were exchanged during the mediation when we were not there. And subsequently, after that, when they came out, they met and then they made certain proposals. It is that those proposals which we made, those subsequent events were very by the whole debate. But here, what has happened is that.
Correct, 1 second. Even that also, this is a family court matter, alva? How can you bring it here, conciliation events there? Huh.
That is, when they met, at that stage, certain conversation to bring or certain things that we are trying to bring it. That because and we wanted to in regard to that, we wanted to give a counter proposal in the mediation. That has not been considered at all. So this one, which we gave before the mediator, that has not been considered.
Correct, ಅದನ್ನೇ ನಾವು ಹೇಳ್ತಿರೋದು. ನೀವು ಏನೇ ಕೊಟ್ಟರು that cannot be family courts act ಕೊಡಿ, ಅದ್ರಲ್ಲಿ ಏನೋ ಒಂದು ಪ್ರಾವಿಷನ್ ಇದೆ ನೋಡಿ. ಕನ್ಸಿಲೇಷನ್ ಅಲ್ಲಿ ಏನಾಗಿರುತ್ತೆ ಅದನ್ನ ಕನ್ಸಿಡರ್ ಮಾಡಬಾರ್ದು ಇದ್ರಲ್ಲಿ ಅಂತ.
My lord, there is a Supreme Court judgment.
ಅದನ್ನ law ಹೇಳಿದೆ. There is a rule, conciliation rule allo family courts somewhere there is a provision. We remember having referred to that earlier. Conciliation provision ಯಾವ್ದ್ರಲ್ಲಿ ಬರುತ್ತೆ ಅದರಲ್ಲಿ? Matter should be first conciliation ಆಗ್ಬೇಕು ಅಂತ ಇದೆ. ಅಥವಾ ನಮ್ಮ ಕರ್ನಾಟಕ ಹೈಕೋರ್ಟ್ ಕನ್ಸಿಲೇಷನ್ ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಆಫ್ ಜಡ್ಜಸ್ ಕೌನ್ಸಿಲರ್ ಕನ್ಸಿಲೇಷನ್ ಇದೆ. ನಮ್ಮೊಂದು ಹೈಕೋರ್ಟ್ ರೂಲ್ಸ್ ಇದೆ ನೋಡಿ, ಹಿಂದೆ ಯಾವುದೋ ಸಮ್ ಮ್ಯಾಟರ್ ಐ ಹ್ಯಾವ್ ರೆಫರ್ಡ್ ಟು ದಟ್. ಯು ಕ್ಯಾನಾಟ್ ಬ್ರಿಂಗ್ ಇಟ್ ಇನ್ ಟು ದ ಮೆರಿಟ್ಸ್ ಆಫ್ ಎ ಕೇಸ್ ಅಂತ. ಹಿಂದೆ ಬೇರೆ ಇನ್ನೊಂದು ಯಾವುದೋ ಕೇಸಲ್ಲಿ ನಾವು ರೆಫರ್ ಮಾಡಿದ್ವಿ ನೋಡಿ, ನಮ್ಗೆ ಹೈಕೋರ್ಟ್ ಇಲ್ಲಿ ಕನ್ಫರ್ಮೇಷನ್.
My lord, in 2010. My lord, in 2010.
Basic rules ಎಲ್ಲ ಇದೆ. 2010.
The Supreme Court has held, my lord, whatever transpires in the mediation, my lord, cannot become part of court proceedings.
We only have written a judgment on that, not but ನಮ್ಮದೇ ಇದರಲ್ಲಿ ನಮ್ಗೆ that is mediation was part of conciliation only.
No, my lord, during the course of mediation.
Rules ಇದೆ ನೋಡ್ರಿ, ಅದು ಕೊಡಿ ಆಯ್ತು ಒಪ್ಕೊಳ್ತೀವಿ. But when there is a specific rule or provision in our own.
My lord, during the course of mediation, husband and wife, my lord, they sit and try to settle the matters. Whatever transpires between them cannot be brought on record. There is a clear bar.
ಇಲ್ಲಿ section 9 in every suit the endeavor shall be made in the first instance where it is possible to consist of answer. If any suit proceeding at any stage occurs only because the
The second page, my lord, the judgment.
Family court rules ಮಾಡಿದ್ದಾರೆ. rules ಮಾಡಿದ್ದಾರೆ. ಆ rules ಅಲ್ಲಿ ಆ provision. What up, sir?
Yes.
ಅದೊಂದು ನಮ್ಮ ಇದರಿಂದ ಒಂದು ರೂಲ್ಸ್ ಮಾಡಿದ್ದಾರೆ. ಆ ರೂಲ್ಸ್ ರೆಫರ್ ಮಾಡಿದ್ದೆ. ಫ್ಯಾಮಿಲಿ ಕೋರ್ಟ್ ರೂಲ್ಸ್. ಆರ್ ಇಮಿಡಿಯೇಷನ್ ರೂಲ್ಸ್ ಅಂತ ಇದೊಂದು ಜಜ್ಮೆಂಟ್ ಅಲ್ಲಿ ನಾವು ರೆಫರ್ ಮಾಡಿದ್ದೆ. ಅದನ್ನ ನೋಡಿ ತರಿಸ್ಕೊಳ್ತೀನಿ. In this judgment page.
My lord, second page of the judgment. The second paragraph, my lord, in this connection, we would like to state the mediation proceedings are totally confidential proceedings. This is unlike proceedings in court which are conducted openly in public gaze. If the mediation succeeds by both parties to the court without mentioning what transpired during mediation proceedings, if the mediation is unsuccessful, then the mediator should write only one sentence in his report and send it to the court stating mediation has been unsuccessful. Beyond that, the mediator should not write anything which was discussed, proposed, or done during mediation proceedings. This is because in mediation, very often offers, counter offers, and proposals are made by the parties, but until and unless the parties reach to an agreement signed by them, it will not amount to any concluded contract. If the happenings in the mediation proceedings are disclosed, it will destroy the confidentiality of the mediation. And my lord, so therefore, my lord, certain negotiations have happened during the course of mediation. Now, my lord, he wants to bring that on record. My lord, which there's a specific bar.
Right.
The Supreme Court says that it can
Bar there is a court only.
rules, my lord, yes.
Family courts, section 9 of the Family Courts Act ಕೆಳಗೆ
ಇಲ್ಲ mediation rules ಅಲ್ಲ ಇದೆ.
not mediation, maybe ಅದನ್ನು ಇರ್ಬೋದು. But section 9 of the Family Courts Act ಅಲ್ಲಿ under that some rules are formulated by our High Court. In that rules it is there. We are aware because we have written it in another judgment.
We will look into
ಕೊಡ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಏನು ಎಜ್ಜನ್ ಏನ್ ಮಾಡೋದಿಲ್ಲ, ನಾವೇ ತರಿಸ್ಕೊಂಡು ಮಧ್ಯಾಹ್ನ ನೋಡಿ why. And what is this amendment of the petition?
amendment, my lord, what he is seeking, my lord, he wants to include the ground of desertion. The reason is, he says after the decree, my lord, the divorce petition was dismissed. The other side is saying, I have not filed a counter petition for restitution. Therefore, he wants to amend the petition. Lord, that cannot. Irretrievable breakdown by itself is not a ground, my lord, under the Hindu Marriage Act.
And she has categorically stated that I have been, evidence that I have been staying away from the husband for last 8 years. And it not be considered now. I want the entire evidence number. When her statement before the court itself is that we have been staying away for last 8 years.
ಇಲ್ಲ ಇದೆಲ್ಲ ನಂಗೆ ಗೊತ್ತಿದೆ. ಫ್ಯಾಮಿಲಿ ಕೋರ್ಟ್ ರೂಲ್ಸ್ ಏನೇ ನಾವೇ ನಮ್ಮ ಹೈಕೋರ್ಟ್ ನಿಂದ ಫ್ರೇಮ್ ಮಾಡಿದ್ದಿದೆ ಅದು ತರಿಸ್ಬೇಕು. ಈಗ ಸೇಮ್ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಜಡ್ಜ್ಮೆಂಟ್ ಇಲ್ಲಿ ಏನು ಹೇಳಿದ್ದಾರೆ ಅಪ್ಲಿಕೇಶನ್ ರಿಸರ್ವೇಷನ್ಗೆ ಕನ್ನಡ ಆಮೇಲೆ ಅಪ್ಲಿಕೇಶನ್ ಇನ್ನೊಂದು ಡಿಸ್ಕಸ್ we'll discuss for an apple that cannot be bought into here and here. Orders on A number?
No. The evidence to the extent where she herself says the evidence that being a part of last 8 years.
See, learned counsel, any evidence that has to be considered along with the main matter, any evidence you produce. So we say this application I number 1 of 2024 and this amendment also has to be considered along with the main matter. These two matters application shall be considered along with the main matter.
One,
IA 1 of 2024 is for reducing additional evidence, and IA 3 of 2024 is for amending the pleadings at the appellate stage. Both, it is settled law that both such applications shall have to be heard along with the main matter. Therefore, those applications are deferred for hearing along with the main matter. 2 of 2023, you want to bring this 2 of 24. Subsequent event is that is mediation central ಆಗಿರೋದಾ?
That is what your lordships are pointing out at the rule, my lord. They go through the rule and may I make a submission.
ಹಾಗಾದ್ರೆ ಪಾಸ್ ಓವರ್ ಮಾಡ್ತೀವಿ ಮಾಡಿ ಬರೀ ಅಪ್ಲಿಕೇಶನ್ ಸಲುವಾಗಿನೇ ನಾವು ವಿ ಕಾಂಟ್ ಲಿಸ್ಟ್ ಕೀಪ್ ಆನ್ ಲಿಸ್ಟಿಂಗ್ ದ ಮ್ಯಾಟರ್ಸ್ ಅಗೇನ್ ಅಂಡ್ ಅಗೇನ್. First time or second time, when you file an application, you should be aware of the law. What is the law? It is the duty of an officer of the court to first know the law and then file applications. Now we'll pass it over. ನಾವೇ ತರಿಸ್ಕೊಳ್ತೀವಿ ನೀವು ಕೊಡ್ಲಿಲ್ಲ ಅಂದ್ರೆ. It is very unfortunate that the advocates do not assist the court. ಅದೇ ಪಾಸ್ ಔಟ್ ಮಾಡೋದು ತರಿಸ್ಕೊಳ್ಳಿ ರೂಲ್ಸ್. Who has moved it? Portal moved. You have moved it. ಯಾರು ಮೂವ್ ಮಾಡಿದ್ರಿ ಇದನ್ನ? ಯಾರೋ somebody has moved.
No, I have not.
ನೀವೇ ಮೂವ್ ಮಾಡಿ ನೀವೇ ಟೈಮ್ ಕೇಳ್ತಾ ಇದ್ದೀರಾ? Okay.
In fact, my lord, because there is a equitable effect on lord, but last 10 years they are saying.
Then ನಾವೆಲ್ಲ
The lordships may kindly-
learned counsel that we have to hear you on the main matter, then we have to take a call about that. And even otherwise, Supreme Court has said that irretrievable breakdown is not a ground for to grant decree for the trial court and the high court. Only under Article 142 it can be granted. And
But what is happening?
next first, ಆಯ್ತು ಬರಲಿ ಅದು file.
Number 25, D. Vijay Kumar, Mushtaq Ahmad, M.R. Giri Method.
My lord, I am for the appellant, my lord.
Correspond number 5.
Insurance company appeal, my lord. I have sought for withdrawal of the amount deposited by the company before the tribunal, my lord. Deposit ಆಗಿದೆ amount.
Yes.
My lord, we have disputed the liability, my lord. There is no insurance policy. Sorry, there is no driving license to the driver of the lorry. And also 3 persons were traveling in the motorcycle. Therefore, my lord, the liability is in question, my lord. The records may be called for. It can be disposed of at any time. Petitioners cannot be permitted to withdraw them.
ಏನ್ ಹೇಳ್ತೀರಾ? What is it?
They deposited before the tribunal.
Hmm.
Liability is
They say you were traveling with 3 people ಅಂತ ಎರಡು ಡಿಸ್ಪ್ಯೂಟ್ ಮಾಡಿದೀವಿ ಅಂತ ಹೇಳ್ತಾರ.
yes.
Records are not called for.
Call ಆಗಿಲ್ಲ. Kindly call for records.
Finally 2 weeks. That request ಇಲ್ಲ ಏನೋ ಇವ್ರು ಕಂಪ್ಲೈನ್ಸ್ ಮಾಡಿರ್ಲಿಲ್ಲ ಹಾಗಾಗಿ.
ಅಲ್ಲ ಅಮೌಂಟ್ಸ್ ಆಲ್ರೆಡಿ ಡಿಪಾಸಿಟೆಡ್.
Deposit ಆಗಿದೆ sir.
ಆಗಿದೆ. In both the cases.
ಆಗಿದೆ ಅದ್ರ ಸಲುವಾಗಿ ಇಷ್ಟು ದಿವಸ ಮುಂದೆ.
Both are connected matter.
ಕಾಲ್ ಫಾರ್ ರೆಕಾರ್ಡ್ಸ್ ಅಂತ ಹೇಳ್ತೀನಿ. ಯಾಕೆ ಬಂದಿಲ್ಲ? ಕಾಲ್ ಫಾರ್ ಆಗಿದೆ ಇದು ಯಾವತ್ತು ಅಂದ್ರೆ ನಾನು 15/2/2024 ಅವತ್ತು TCRs ಕಾಲ್ ಫಾರ್ TCRs ಅಂತ ಆಗಿದೆ.
My lord, one submission, my lord, office has not noted in the connected matter.
ರೆಕಾರ್ಡ್ಸ್
So
ಬಂದಿದೆ.
ಬಂದಿದ್ರೆ kindly post for final hearing.
ಫೈನಲ್ ಹಿಯರಿಂಗ್ 2024 ಏನ್ ಪೋಸ್ಟ್ ಮಾಡಕ್ಕಾಗಲ್ಲ. ಆಯ್ತು ನೀವು ರೆಕಾರ್ಡ್ಸ್ ಬಂದ್ರೆ ಅಪ್ಲಿಕೇಶನ್ ಕನ್ಸಿಡರ್ ಮಾಡಬಹುದು ಅಂತ ಹೇಳಿದ್ರಲ್ಲ. ವಿಲ್ ಕನ್ಸಿಡರ್ ಕೊಡಿ ರೆಕಾರ್ಡ್ಸ್ ಇದೆ.
ಅಲ್ಲ ರೆಕಾರ್ಡ್ಸ್ ಬಂದ್ರೆ can be finally disposed of ಅಂತ. Because we have disputed the liability. There is no driving license. We have examined our officer.
ಇನ್ನೊಂದು ಮ್ಯಾಟರ್ ಇದೆ ಅಲ್ಲ ಅದೇನು ಅರೈಸಿಂಗ್ ಔಟ್ ಆಫ್ ದ ಸೇಮ್.
Both are same.
Why to appeal if that is the same ಕೊಡಿ ನೋಡೋಣ.
Different claimants.
One is for the deceased.
ಅಲ್ಲ ಇದು MSC
ಎರಡು ಜಡ್ಜ್ಮೆಂಟ್ ಆಗೋಗಿದೆ.
ಬೇರೆ
Two different judgments.
ಸೆಪರೇಟ್ ಆಗ್ಬಿಟ್ಟಿದೆ ಅಷ್ಟೇ, ಬಟ್ ಸೇಮ್ ಆಕ್ಸಿಡೆಂಟ್.
accident may be same but 2 judgments common judgment ಅಲ್ಲ.
And my lord, there are 2 connected matters, my lord, 2 more connected matters.
185.
MFA 7817/24 and 7868/24. Kindly post along with those matters.
ಅದು ಯಾವ ಕೇಸ್ ಇದು?
ಅದು ಅವ್ರ ಕ್ಲೈಮೆಂಟ್ಸ್ ಹಾಕೊಂಡಿದ್ದಾರೆ.
ಮೈ ಅಪೀಲ್ಸ್ ಆರ್ ಸೊ ದೇರ್.
You have also.
Yes.
Yes.
Then we can consider all.
Yes, my lord. Together it can be considered of, right? It can be finally disposed of.
But I will permitted to deposit, withdraw the amount, my lord, deposited by the
Correct.
company.
He is saying that this is MEC 184 and 185.
MFA, my lord, 7817/24 and 7868/24. My lord, kindly see, my lord, one submission.
ಅದ್ರಲ್ಲಿ ರೆಕಾರ್ಡ್ಸ್ ಬಂದಿದೆಯಾ ಇನ್ನೊಂದು ಕನೆಕ್ಟೆಡ್ ಅಲ್ಲಿ ಅಲ್ಲ ಇದಲ್ಲ ಇನ್ನೂ ಎರಡಿದೆ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದಾರೆ.
ಹಾ,
ಹೌದು
7817 7868/24.
ಅಂತ ಹೇಳಿದ್ರೆ ಬರ್ಕೊಡಿ. ಇದೆರಡು ಬರ್ತಾರೆ. ಇಟ್ ಇಸ್ ಸಬ್ಮಿಟ್ ದಟ್ ಎರಡು ಗುಬ್ಬಿ ಸೇಮ್ ಟ್ರಿಬ್ಯುನಲ್ ಇಸ್ ಸೇಮ್ ಬಟ್ ಬೇರೆ ಬೇರೆ ಜಡ್ಜ್ಮೆಂಟ್. It is submitted that these two matters are connected to MFA number
7817.
And the negligence and liability of the insurer is in dispute in these cases. Okay. List all the matters together on date.
Madam. 19-2.
My lord, one submission, my lord. We have taken the direction that there is no driving license. Mr. M.R. Hiremata is appearing for the board.
Records put up agli. Let the all other matters be listed together.
Please. My submission is
25-26.
if the owner produces the driving license, my lord, one issue will be cleared. Because owner is appearing before the court.
ಡ್ರೈವಿಂಗ್ ಲೈಸೆನ್ಸ್ ಇಲ್ಲ ಅಂದ್ರೆ ಪೇನ್ ರಿಕವರ್ ಇದೆ ಸ್ವಾಮಿ.
ನೋಡೋಣ ಕೇಸ್ ಆಲ್ರೆಡಿ ಅಡ್ಜೆಂಟ್ ನೆಕ್ಸ್ಟ್
ಮೇಡಮ್
ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಬೇಕು.
ಎರಡು ಸ್ವಾಮಿ 25.
Seal number 27, M.V. Maheshwarappa, D. Vijay Kumar for R3.
My lord, I am for the appellant in the connected matter. My lord, in this, my lord, we have deposited the award amount, 50% of the award amount on 29/1/24. My lord, in most of the matters, my lord, office is not verifying and simply making the note that the amount is not deposited.
ಎಲ್ಲಿ ಡೆಪಾಸಿಟ್ ಮಾಡಿ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ನಲ್ಲಿ ಡೆಪಾಸಿಟ್ ಮಾಡಿದ್ರೆ ಹೈಕೋರ್ಟ್ ರಿಜಿಸ್ಟ್ರಿಗೆ ಏನು ಕನಸು ಬೀಳುತ್ತಾ? ನೀವು ಯು ಶುಡ್ ಪ್ರೊಡ್ಯೂಸ್ ದ ಪ್ರೂಫ್.
Hello, even we have filed the acknowledgement also. My lord, we have filed the acknowledgement before this honorable court on 20. One minute, my lord.
ಯಾವತ್ತು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದಿರಿ?
29/1.
29/1.
29/1/2024. I have
in
see the
which
acknowledgement,
case,
my lord.
out of these two cases, in which case you have produced the acknowledgement?
In my appeal, my lord.
In your appeal?
In my appeal.
That
Yes,
is,
my lord.
7307. ಅವರೇನ ಕೊಟ್ಟಿದೀವಿ ಅಂತ ಹೇಳ್ತಾರೆ.
Even in the previous case also, office is raising the same objection.
When
Though
did
we
you
have
file
deposited.
that? You go and complain before the registrar judicial. You
My
cannot
lord, my lord, we can convince your lordship. Go on complaining means there will be lot of
all right, learned
this thing will be
counsel.
there.
If you were telling that frequently they are doing it. You go and report before the registrar judicial. Don't reduce us to the registry.
Please, my lord.
ಒಟ್ಟು ಒಂದು ಏನಾರು ಹೇಳ್ತಾನೆ ಇರ್ಬೇಕು ಆ ಕಡೆಯಿಂದ.
ಅಲ್ಲ. No, because there is a note, my lord. I have to convince.
ಇದರಲ್ಲಿ ಹೇಳಿದ್ದಕ್ಕೆ ಎಲ್ಲದರಲ್ಲೂ ಹಾಗೆ ಮಾಡ್ತಾರೆ ಅಂತ ಹೇಳಿದ್ರಿ. ಇದು
ಅಲ್ಲ previous case also.
Even assuming that they have done it, are doing it, go and complain before the registrar judicial. ಎಲ್ಲಿದೆ ಅದು acknowledgement ಇದೆ?
Yes, this is the acknowledgement.
ಕಾಣ್ತಾ ಇಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ. ಅಲ್ಲಿ ಫೈಲ್ ಆಗಿದ್ದಕ್ಕೆ ಏನು ನೀವು ಅಲ್ಲಿ ಕುತ್ಕೊಂಡು ತೋರಿಸೋದಲ್ಲ, ಇಲ್ಲಿ ಬಂದು ಕೊಡ್ಬೇಕು ಅದನ್ನ ಕಾಪಿನ ಕೊಟ್ರೆ.
My lord, this is before high court, my lord. This is an acknowledgement. Presentation form.
ಕರೆಕ್ಟ್. ನಮ್ಮ ರೆಕಾರ್ಡ್ ಅಲ್ಲಿ ಇಲ್ಲಿ ಬಂದಿಲ್ಲ, ನೀವು ಹಾರ್ಡ್ ಕಾಪಿ ನಮ್ಗೆ ಕೊಟ್ರೆ ಗೊತ್ತಾಗುತ್ತೆ. then we can ask them, but anyway in this case he is saying you have deposited, then we can take that into consideration. ಇದರಲ್ಲಿ ನಿಮ್ಮದ್ರಲ್ಲಿ
Delay may be condoned and records may be called for.
ಅವರದ್ರಲ್ಲಿ ಎಷ್ಟಿದೆ? 55 days ಇದೆಯಾ?
210 days.
ನಿಮ್ದು 210
ಅವ್ರದಲ್ಲಿ 210 days without interest.
1 ಅಲ್ಲಿ ಬರ್ಕೊಳ್ಳಿ.
Without interest.
Respondent 1 to 5 submits that the amount is deposited. Therefore, office objection in that regard should complied. 27 and 27.1 ಒಟ್ಟಿಗೆ ತಗೊಳ್ಳಿ. Considering the reasons assigned to explain the delay, case of death. 627. Minors idara 627 ಅಲ್ಲಿ? 8 years, 6 years. Reasons assigned to explain the delay. Delay of 210 days in filing MF number 627 of 2024 and 55 days in filing MF number 7307 of 2023 is condoned in the interest of justice. IA 1 of 2024 and 1 of 2023 in the above cases respectively are disposed of accordingly. Records ಬರ್ಬೇಕಾದ್ರಲ್ಲಿ admit ಆಗಿದೆ. Admit ನಿಮ್ದ್ರಲ್ಲಿ ಏನು ನೋಷನಲ್ ಇನ್ಕಮ್ ಏನಿದೆನ ಅವ್ರದ್ರಲ್ಲಿ ಲಯಬಿಲಿಟಿ ಡಿಸ್ಪ್ಯೂಟ್ ಮಾಡಿದ್ದಾರೆ.
ಲಯಬಿಲಿಟಿ ಡಿಸ್ಪ್ಯೂಟ್ ಮತ್ತೆ ಇದರಲ್ಲಿ 4 ಜನ ಮೋಟರ್ ವೆಹಿಕಲ್ ಹೋಗ್ತಾ ಇರೋದು.
Admit call for TCS, list of TCS. ಬರ್ಲಿ ಬಿಡಿ, TCS ಬಂದ್ಮೇಲೆ ಲಿಸ್ಟ್ ಮಾಡಿ ಅಂತ ಹೇಳ್ತಿದ್ವಿ.
Till number 28 SPP Archana KM amicus curiae.
The delay of 182 days in filing an appeal, 302.
Mm. 182 days.
182 days, ma'am.
Sent a mail to them. Or they did not have handed one, case also called me back. I spoke to the accused. If they get back, that process will be like.
Anyway, you can proceed, we can, you are appointed now as amicus curiae. Instructions in file irutte adನ್ನ ನೋಡಿ ಮಾಡಿ. Bail application. See, you can bring it on record that despite your, because even if you file a bail application, if you succeed, the surety has to be furnished by them. So, until they come, we can continue. Bandre nodana, you are doing in, seeing in all other cases, if they come, we ask them to pay our fees and wait ಮಾಡ್ಕೊಂಡಿರಕ್ಕೆ. Amicus curiae submits memo reporting that she contacted response 1 to 3 regarding the bail suspension, bail application, regarding filing of the bail application, but they have not responded. Under the circumstances, the matter she can proceed in the matter. Hearing ಮಾಡಬಹುದು. ಅಲ್ಲಿ ಹಿಂಗ್ ಮಾಡಿ. The said memo is taken on record. She is permitted to proceed in accordance with law. ಇದರಲ್ಲಿ ಬರ್ಕೊಳ್ಳಿ. 142 ನಿಮ್ಗೆ ಕಾಪೀಸ್ ಕೊಟ್ಟಿಲ್ವಾ? IA copy segment. ಇದರಲ್ಲಿ what is they are acquitted for 302 34.
302, ma'am.
34. ಇಲ್ಲೇನೋ 50,000 ಬಾಂಡ್ ಎಕ್ಸಿಕ್ಯೂಟ್ ಮಾಡ್ಬೇಕು ಅಂತ ಇದೆ 437 ಏನಲ್ಲಿ. ಅದನ್ನು ಮಾಡಿದ್ರೋ ಇಲ್ಲ, ನಾವು ಆರ್ಡರ್ ಬರೆಯುವಾಗ ಬರ್ದಿದೀವ, ಅದನ್ನು ಎಕ್ಸಿಕ್ಯೂಟ್ ಮಾಡಿಲ್ಲ ಅಂತ. ಇದ್ರೆ ಅದನ್ನೇ ರಿಕವರ್ ಮಾಡ್ಕೊಂತಿದ್ರು ಅವ್ರ ಎಕ್ಸಿಕ್ಯೂಟ್ ಮಾಡಿದ್ರೆ 100%. ರೈಟ್ ಕೋರ್ಟ್ ರೆಕಾರ್ಡ್ಸ್ ಇನ್ನೂ ಬಂದಿಲ್ವಲ್ಲ, ಬಂದ್ರೆ ಗೊತ್ತಾಗ್ತಿತ್ತು ಅವ್ರು 437A ಬಾಂಡ್ ಏನಾದ್ರು ಎಕ್ಸಿಕ್ಯೂಟ್ ಮಾಡಿದ್ರೆ ಅಟ್ಲೀಸ್ಟ್ ದಟ್ ಶ್ಯೂರಿಟಿ ಫಾರ್ಫಿಟ್ ಮಾಡಿ ಸ್ವಲ್ಪ ಪೆನಾಲ್ಟಿ ಹಾಕಿ ರಿಲೀಸ್ ಆದ್ರೂ ಮಾಡ್ಬೋದಿತ್ತು. ಅದೇ ಡಿಲೇ ವಿಲ್ ಕಂಡೋನ್ ಸ್ಟೇಟ್ ಅಪೀಲ್ ಅದೆಲ್ಲ. Case is based on direct evidence or circumstantial?
Eyewitness, ma'am. Wife is eyewitness.
Wife is
Eyewitness.
There was any delay in filing the complaint?
There is no delay, my lord. Its complaint was filed.
On what ground now acquittal is granted?
Acquittal, my lord, it's they suspected the evidence of PW2 with a wife, and they say that some of the witnesses have turned hostile.
What
There is no detailed discussion.
wife?
Wife witness evidence has been doubted by the trial court. And the son's witness evidence also been doubted by the trial court. She speaks about the incident, my lord, then she says,
expeditiously burned orders and I1 of 2024 heard both sides. Considering the reasons assigned to explain the delay of 142 days in filing the appeal is condoned in the interest of justice. I1 of 2024 is disposed of accordingly. Matter requires detailed consideration. Admit. All for TCRs, just 182 days here. All for TCRs, paperwork shall be prepared within paperwork ಆಗೋದಕ್ಕೆ ಸ್ವಲ್ಪ time ಬೇಕಾಗುತ್ತೆ within 8 weeks. List after 8 weeks.
Number 29. SPP.
the delay of 142 days, my lord.
Yes.
302.
ಇದರಲ್ಲೂ ಕಸ್ಟಡಿಯಲ್ಲಿದ್ದಾರಾ?
Yes, madam.
This respondent accused failed to appear before the court in execution of warrant.
They are also custody, madam.
He is in custody. Sole accused, huh?
Yes, madam.
What do you say, 142 days delay? 31 years. Only 18 years ಅಂತ ತೋರಿಸಿದ್ದಾರೆ. What are the charges?
302, my lord.
302 reading section 34. But sole accused ಅಂತ ತೋರಿಸಿದ್ದಾರೆ, ಇದೇನು split up case ಆಗಿತ್ತಾ?
Alex is sole accused, madam.
ತಪ್ಪೇನೋದು ಎಲ್ಲ ಒಂದ್ ಕಡೆ 34 ಅಂತ ಓದಿದೆ, ಇಲ್ಲಿ 302 ಅಷ್ಟೇ ಇದೆ, not 34. This case is based on
Circumstantial evidence.
circumstantial.
Yes, ma'am. He was staying together with the deceased. And then post commission of crime, he comes and informs the landowner. Subsequently, the complaint has been filed by the landowner. And based on his statement that the recovery of clubs which bloodstains are found in the clubs, and that matches with the bloodstains of the deceased. And the clothes of the accused also matches with the bloodstains of the deceased. Of course, there is no discussion in the entire judgment about either the club which was recovered at the instance of the accused.
So FSL report had come.
Yes, ma'am.
Extrajudicial confession was proved.
Extrajudicial confession is proved and FSL report corroborates with extrajudicial confession. There is a recovery, and that in the entire judgment, my lord, there is trial court has not discussed about anything about this recovery and FSL report.
Heard both sides. Orders and I number 1 of 2024. 24. Considering the reasons assigned to explain the delay of 142 days in filing the appeal is condoned by the interest of justice. IA 1 of 2024 is disposed of accordingly. Matter requires consideration, detailed consideration. Admit call for TCRs. Paperwork shall be prepared within 8 weeks. List after 8 weeks.
Number 30, SPP.
13, my lord, is 490 and 304.
Here, madam. Oh, correct, you are right. Brother was asking, only if in same case, same accused, for one offense he is acquitted, for another offense, or he is convicted for a minor offense. So suppose 3-4 is one offense, minor offense ge convict ಮಾಡ್ತಾರೆ. ಅವಾಗ ಅಂದ್ರೆ adequacy of the sentence and acquittal ಎರಡು ಸೇರಿ ಒಂದೇ ಅಪೀಲ್ ಹಾಕೋಬೇಕಲ್ವಾ? ಎರಡೆರಡು ಅಪೀಲ್ ಹಾಕ್ತಿರೋ ಸ್ಟೇಟ್ ನಿಂದ ಯಾಕೆ ಅಂತ?
Provisions are different, my lord, for both.
Provision ಬೇರೆ ಇದ್ರು ಎರಡು ಒಟ್ಟಿಗೆ ಹಾಕ್ಬೋದಲ್ಲ, 372, 378 ಅಂತ ಎರಡೂನು.
That unfortunately, that procedure which I have been told, my lord, is followed is that the
procedure, we didn't find any law for that.
And that based
Bar at least.
appeals have been filed based on the GO, my lord. GO is issued for the purpose of
GO ನಿಮ್ಮ
our
government purpose.
government GO.
ಇರೋದು ನಮ್ಗಲ್ವಲ್ಲ. Why there is duplication of what?
No, there is one,
Legislature made conflicting decisions.
I think there's one judgment, my lord, which I've been told that,
ಹೇಳೇ ಇಲ್ಲ ಅವ್ರು ತಂದು ಕೊಡ್ಲೇ ಇಲ್ಲ.
I'll have a look at it, my lord.
We have already passed an order in that. Single appeal has to be filed. ಅಂತ. ಯಾವ್ದು ಇದ್ರಿ ನೀವು ಹುಡುಕಿದ್ರೆ ತಂದ್ಕೊಡಿ ನೋಡೋಣ.
I'll verify.
ಇಲ್ಲ ಜಜ್ಮೆಂಟ್ ಇಸ್ ಬೇಸ್ಡ್ ಆನ್ ವಾಟ್ ಅನ್ನೋದು ಅಷ್ಟಿಲ್ಲ. ನಮ್ಮ ಹೈಕೋರ್ಟ್ ಇಂದ
This court judgment.
ಇದ್ರೆ ಹುಡುಕಿ ತಂದ್ಕೊಡಿ ನಾವು ಕೋರ್ಟ್
Yes.
Number 30.
ಸಿಂಗಲ್ ಅಪೀಲ್ ಅಂದಾಗ ನಮಗೆ ಸಿಂಗಲ್
No, but now single appeal has been held. So next time don't file two appeals.
No, that is
I think there is
It
a
is
judgment,
subject
my
to
lord, and
correct.
I'll verify the judgment, my lord. based-
Any variation you can.
That's correct.
there is any other view, he was not able to show us any judgment. We granted considerable length of time. ಸುಮಾರು 1 ವರ್ಷ 6 ತಿಂಗಳು ಇದ್ರಲ್ಲೇ ಹೋಗಿದೆ ಈಗ.
No, I've been told, my lord, I thought that it's been submitted to your lordship, and I'll verify my lord.
ಇದ್ರ ನೀವಿದ್ರ ಕೊಡ್ಲಿಲ್ಲ ಅಲ್ಲ ಇವ್ರು SPP ಅವರೇ ಬಂದಿದ್ರು ಬಟ್ ಆ ಜಡ್ಜ್ಮೆಂಟ್ ಕೊಡ್ಲಿಲ್ಲ ಸಿಗ್ಲಿಲ್ಲ ಅಂತ ಹೇಳಿದ್ರು.
I'll verify.
ನಮ್ಮ ಹೈಕೋರ್ಟ್ ರೂಲ್ಸ್ ನಮ್ಮ ಹೈಕೋರ್ಟ್ ರೂಲ್ಸ್ ಎಲ್ಲ ತೆಗಿಸ್ ನೋಡಿದ್ವಿ ನಾವು ಅದೇನು ಸಿಗ್ಲಿಲ್ಲ ನಮಗೆ.
I'll verify.
Yes. All right, if they are under two different provisions, ನೀವು ಅಪೀಲ್ ಮೆಮೊದಲ್ಲಿ ಅಂಡರ್ ಸೆಕ್ಷನ್ 370
Along with
ಎರಡೂ ಬರೀಬಹುದು. Yes.
with 498A, 304B, my lord. 498A has been convicted. 304B has been acquitted. And the conviction also, my lord, has been challenged.
Convicted,
498 has been convicted.
Delay is also there. Issue notice to them.
Literally, this matter also has to be connected with criminal appeal 162 of 24, my lord.
They have also preferred.
Yes.
appeal. ಯಾವ್ದದು?
162 of 24.
Victims appeal or?
No, the accused appeal, ma'am. 498A has been convicted.
Accused 498 ಗೆ he is convicted ಅಂತ ಅದಕ್ಕೆ he has ಅದು ಬಹುಶಃ ಸಿಂಗಲ್ ಜಡ್ಜ್ ಬಂದಿರಬೇಕು.
Yes, yes.
It is
Sentence has been suspended.
ಕೊಡಿ ಅದು ಯಾವ್ದು
Yes.
number. This matter is connected to criminal appeal number
162 of 24.
So answer list both the matters together on date. Notice ಇಲ್ಲ ಬರೀ
Notice has to.
Seal number 31, KT Gurudev Prasad, PC Shivanegowda.
ಹೌದು, ಚೆನ್ನಾಗಿ ಮಾಡ್ತಾರೆ. ನೀವು ಅದನ್ನ ರೀಸೆಲೆಕ್ಟ್ ಮಾಡ್ಕೊಂಡಿದ್ದೀರಿ. ಎಸ್ ಗುರುದೇವ್ ಪ್ರಸಾದ್ ICIC ಶಿವನೇಗೌಡ್ರ ಇದಲ್ಲ ಬರೀ ಒಂದೇ ಆಗ್ತಿದೆ ನಿಮ್ದಷ್ಟೇ ಇದೆ. ವಾಟ್ ಇಸ್ ಪಿಟಿಷನ್ ಇಸ್ ಅಲೋಡ್ ಆರ್ ಡಿಸ್ಮಿಸ್? ಡಿಸ್ಮಿಸ್ ಕೇಸ್ ಆಫ್ ಡೆತ್. ನೋ ನೆಕ್ಸಸ್ ಬಿಟ್ವೀನ್ ದ ಡೆತ್. ಡಾಕ್ಟರ್ ಎವಿಡೆನ್ಸ್ ಅಲ್ಲಿ ಬಂದಿತ್ತಾ? ಡಾಕ್ಟರ್ ಸೆಟ್ ಇಬ್ರು ಡಾಕ್ಟರ್ ಎಕ್ಸಾಮ್ ಮಾಡಿ. ಹೌದು ಶಿವನೇಗೌಡ್ರು ಇಲ್ವಲ್ಲ? ಎಸ್ ಲಿಂಗರಾಜ್ ಅವರು ಡಿಲೇ ಕಂಡನ್ ಮಾಡ್ತೀವಿ. ಶಿವನೇಗೌಡ್ರಿಗೆ ಹೇಳಿ ಇನ್ಶೂರೆನ್ಸ್ ಕಂಪ್ನಿ there is delay of 36 days dismissal. Heard. Accepting the reasons assigned to explain the delay 73 years. Delay of 36 days in filing the appeal is condoned in the interest of justice. I 1 of 2024 is disposed of accordingly. Matter request details consideration. Admit call for TCRs. List after the receipt of TCRs.
Seal number 32, Manjula Tejasvi.
For the appellant's counsel. He is ready, insurer. Guaranteeing the fund of. Case of death.
Only fund.
Riding the motorcycle and dashed against a stationary lorry. It acted as a. The message is taking contribution with 10%, but the charge sheet itself is again.
Issue notice to the respondents. If you are disputing only negligence, why the notice should go to the owner of the vehicle?
I'll ask the counsel to file.
File ಅಂತ ಬರ್ಕೊಳ್ಳನ್ನು. ದಿಲ್ಶಾದ್ ಫೈಲ್ ಅಂತ ತಗೊಳ್ಳೋಣ. Suspension of notice to respond number 3. The appellant has a challenge only the quantum of compensation and negligence. Respond number one, owner of the vehicle had not contested the matter before the tribunal, considering the same. Respond number one and respond number three, real three and one. Considering the same, notice to respond number three is dispensed with as paid for. Issue notice to respond number one and two. Interim stay of execution of the impugned award till next hearing date, subject to appellant depositing 50% of the award amount before the tribunal within 4 weeks from the date of receipt of the copy of this order. List on
19.3. Seal number 33, D. Vijay Kumar.
My lord, this appeal is by the insurance company. It is an ex parte judgment, my lord. My lord, the tribunal holds, my lord. The people, local people told that this office is not in this locality. And that statement, they placed the insurance company ex parte. And ex parte judgment is passed. We have disputed the negligence and involvement of the vehicle and the accident between the three vehicles. Our lorry was parked on the extreme left side of the road. The motorcycle came from behind and dashed against our vehicle. And thereafter, it
yes.
opposite vehicle car came and dashed against ran over the deceased. But entire negligence is on our side. Ex parte, and they have filed EP also, my lord.
Correct. Other deposit money. Sir, issue notice to the respondents. Interim stay of execution of the impugned award till next hearing date, subject to appellant depositing 50% of the award amount before the tribunal within 4 weeks from the date of the receipt of copy.
And the said amount may kept in any nationalized bank.
19.3.
Deposit money. Yes.
19.3. Number 34, D. Vijay Kumar.
My lord, this appeal is by the insurance company, my lord, challenging the negligence and the liability. It's a case of self-fall, my lord. There was no accident. And the false implication of the vehicle. Apart from that, my lord, though the climate is fully well, they have played a fraud on the court saying that he is mentally ill.
Subject to appellant depositing 50% of the award amount before the tribunal within 4 weeks from the date of the receipt of copy.
Much obliged.
List on
19.3.
and notice. Yes.
Much
For
obliged.
admission, seal number 35, Vishwanath Pujari, SV Hegde Mulkum.
My lord, Vishwanath Pujari has not given the copy to SV Hegde. He has not filed the wakalat. He requests 1 week's time to file wakalat.
Yes. Wakalat haklidraleno case dismissed or
ಅದೇ ಅಪೀಲ್ ಬಿ ಮನೆ ಕೊಟ್ಟಿಲ್ಲ ಅಂತೆ
ಕೊಡ್ಲಿ
ಹೆಗಡೆ ಅವರಿಗೆ
ಕಾಪಿ ಕೊಟ್ಟಿಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ. Is that so? Processal. We had directed him to take notice, it seems. He served the copies on him. The claim petition is partly allowed. Respond number 2 being the insurer is liable to pay. Okay. Admit list for final hearing on 2015 matter. 2015 ಇನ್ನು ಕಾಪಿ ಕೊಟ್ಟಿಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ. ಯಾವಾಗ when he had taken notice SV ಹೆಗ್ಡೆ ಲೋಕ ಅದಾಲತ್ಗೆ ಹೋಗಿ ಬಂದು PD ಸುಬ್ರಹ್ಮಣ್ಯ and even before notice was taken ಅಲ್ಲ ರಾಜಗೋಪಾಲನ್ ಲರ್ನರ್ ಕೌನ್ಸಿಲ್ ಇಸ್ ನೋ ಮೋರ್ ರಿಜಿಸ್ಟರ್ ಇಸ್ ಡೈರೆಕ್ಟ್ ಕ್ವೆಶ್ಚನ್ ನೋಟಿಸ್ ಟು ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 2 ಅದಾದ್ಮೇಲೆ ಸರ್ವಿಸ್ ಆಗಿತ್ತು ಅವ್ರಿಗೆ ಸರ್ವಿಸ್ ಹೆಲ್ತ್ ಸಫಿಶಿಯಂಟ್ ಅದಾದ್ಮೇಲೆ ಇದು
Rajgopalan is dead, my lord. He is no more. Therefore, my lord, he has been dead.
they were served and unrepresented, therefore we had directed them to take notice.
Anyway, Hegde is out of station. He is in native, function ಇದೆ ಅಂತ ಹೇಳಿ.
Admit list for final hearing on
6-2.
6. You want it on 13? 13. Old matter ಇದೆ ಅವ್ರಿಗೆ ಕಾಪಿ ಬೇಕು ಅಂದ್ರೆ ಕೇಳಿದ್ರೆ ಕೊಡಿ ಅವ್ರಿಗೆ.
Seal number 36, HS Lingraj, Raghavendra EP, for R1.
Memo for dispensation of notice to R2. Area of airport.
Yes. In this case, my lord.
ಅದರಲ್ಲಿ we were directed to take notice. ಕಾಪಿ ಸಾರು ಮಾಡಿದೆ. Already you were directed to take
And
it.
file for-
A dispensation on
Yeah, partner, partner.
one. ಮೊದಲು ಅದು ಡಿಸ್ಪೆನ್ಸ್ ವಿತ್ ಮಾಡೋಣ 36.1 ಕ್ರಾಸ್ ಅಬ್ಜೆಕ್ಷನ್.
My lord, it is,
Respondent number 2. ಏನಾಗಿತ್ತು ಟ್ರಯಲ್?
yes, he has suffered 89%
What?
whole body injury and he was a scientist.
ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ
And it is,
who had not contested.
So this- this, in on appeal by the insurer.
Hmm.
So it's demanded.
Yes.
Then the amount of compensation and the medical expenses.
ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಸುಪ್ರೀಂ ಕೋರ್ಟ್
no,
ರಿಮೈಂಡೆಡ್.
High court
This court remanded to the trial court after trial.
I'm the cross objector and I have filed the difference of 60 lakhs to be paid to me for the compensation.
This dispensation will consider. Under the income award, the liability to pay compensation is fastened to respond number 1, the insurer. Record show that respond number 2 had not contested the matter before the tribunal. Therefore, notice to respond number 2 is dispensed with as paid for. ಇದರಲ್ಲಿ so detail ಆಗಿ ಆಗ್ಬೇಕಾಗುತ್ತಲ್ಲ ಎರಡು.
My lord, it is 14 years old case, so earliest date ಕೊಡಿ so.
Here, the officer is very fine, but under would they register and all of it, what's there?
ಅಡ್ಮಿಟ್ ಲಿಸ್ಟ್ ಅಂದ್ರೆ ರೆಡಿ ಇದ್ದೀರಾ ಈಗ?
And the
ನೀವು ರೆಡಿ ಇದ್ದೀರಾ?
Already.
ಪಾಸ್ ಓವರ್ ಮಾಡಿ ಆಮೇಲೆ ತಗೊಳ್ಳೋಣ.
ಮಧ್ಯಾಹ್ನ ನನಗೆ ಮ್ಯಾಟ್ರಿಕ್ಸ್ ಇದೆ ಸ್ವಾಮಿ.
next
Then-
week.
Next week.
Some other day. Admit list for final hearing on. ಹೇಗಿದ್ರು 2015 it comes ಮೇಲೇನೆ ಬರುತ್ತೆ ಲಿಸ್ಟ್. ಫಸ್ಟ್ ಆಯ್ತು.
First, 1, 2. Bill number 37,
Much
D. Vijay Kumar, Mahesh.
My lord, I am for
Sharma.
the appellant, my lord.
Appear for.
Records may be, records was called, my lord.
In this matter, I filed the application for withdrawal of the amount. They question the quantum.
ರೆಕಾರ್ಡ್ಸ್ ಬಂದಿದೆ ಅಲ್ಲ. ನಾನ್ ಫೈಲಿಂಗ್ ಆಫ್ ಪೇಪರ್ ಬುಕ್ಸ್ ಅಂತ ಹೇಳಿ ಪೇಪರ್ ಬುಕ್ಸ್ ಡೈರೆಕ್ಟ್
ಬಂದಂಗಿಲ್ಲ ಪುಟ್ಟಪ್ಪ.
ಅಲ್ಲ, ಇದರಲ್ಲಿ ಯಾರು ಮಹೇಶ್ ಉಪ್ಪಿನ ಅವ್ರ ಕೊಲೀಗ?
To
My
file
lord?
paper book containing copies of claim petition, statement of objection and exhibits. ನಿಮಗೆ ಡೈರೆಕ್ಷನ್ ಕೊಟ್ಟಿದ್ರಲ್ಲ 31/2024. You are directed to file
30.
paper book containing claim petition, statement of objection, depositions and exhibits. ವಿಜಯ್ ಕುಮಾರ್ ಅವರು ನಿಮಗೆ
My lord, I'll do it, my lord. I'll do it because I am not aware of the, I'm sorry. I'm not, I'll do it.
ಶ್ರುತಿ ಎನ್ಒಸಿ ಹಾಕಿದೆ.
ವಕಾಲತ್ ಇಲ್ಲಿ ವಕಾಲತ್
ಎನ್ಒಸಿ ಹಾಕಿದ್ದಾರೆ. ಶ್ರುತಿ, ಮೈ ಕೊಲೀಗ್ ನೇಮ್. Kindly show the name of.
come with no objection of the previous concern.
ಶ್ರುತಿ ಅವ್ರ ಬೆಳಿಗ್ಗೆ ಅಡ್ಜಸ್ಟ್ಮೆಂಟ್ ತಗೊಳ್ತೀನಿ ಅಂತ ಹೇಳಿದ್ರು. She called me.
ನಿಮ್ದು ಇಲ್ವಾ ವಕಾಲತ್ತು?
ನಂದಿಲ್ಲ, ನನ್ನ ಕೊಲೀಗ್ ಇದೆ. ನೋ ಪ್ರಾಬ್ಲಮ್. ಶೋ ಅವರ್ ನೇಮ್.
ಬೇಕಾದ್ರೆ ಹಾಕ್ತಿವಿ.
ಅಲ್ಲ, ಶೋ ಅವರ್ ನೇಮ್.
Registry has placed ವಕಾಲತ್ of learned counsel Shruti SP na?
ಹೌದು.
SP for response 1 to 3. One minors ಇದಾರಾ ಇದ್ರು?
ಇಲ್ಲ ಇಲ್ಲ.
ಇಲ್ಲ 1 to 3 ಅಂತ
Death of bachelor and parent.
ಡೆತ್ ಕೇಸ್.
Okay, 1 to 3. Therefore, only her name shall be shown for response 1 to 3, henceforth in the cause list. Okay. Records ಬಂದಿದೆ ಇದು. Paper book ಕೊಟ್ಟು.
PCR received.
ಅದೇ ಅಲ್ಲಿ ಹೆವಿ ಇದೆಯಾ? Why the paper book was ordered to be filed? ತುಂಬಾ ಬಲ್ಕಿ ಇದೆ ರೆಕಾರ್ಡ್ಸ್. PW 1 to 3, exhibit P1 to P31. Admission card, etc. Paper book ನಮಗೆ ಹಾಕಿದ್ದಾರೆ. ಏನ್ ಮಾಡೋಣ?
I think it may not be required.
We can paper books ಜಾಸ್ತಿ ಇಲ್ಲ. We saw that
ಅಲ್ಲ, ರೆಕಾರ್ಡ್ಸ್ ಬಂದ್ರೆ ಸಾಕು.
records ಬಂದಿದೆ. ಅದು ರೆಕಾರ್ಡ್ಸ್ ಬರಕ್ಕಿಂತ ಮೊದಲು ಮಾಡಿದ್ರ ಆರ್ಡರ್?
ಹೌದು.
Since the records are already received, ಅದು 31/2024 ಮಾಡಿದ್ರು. 24 ಆರ್ಡರ್ ಮಾಡಿದ್ದೇವೆ. By that time records ಬಂದಿತ್ತಲ್ಲ. So filing of the paper books is dispensed with. Yes, ಆಯ್ತು ಹೇಳಿ. You have filed for withdrawal.
ಹೌದು.
Yes,
Yeah.
what do you say for?
My lord, we
withdrawal?
have totally disputed the negligence on the part of the driver of the bus. My lord, the deceased was traveling in the bus from Shantinagar. He get into the bus and he wanted to go to Majestic. And when he asked about the conductor that where the bus is going, he said bus is going to Shivajinagar. Then, my lord, after listening that the bus is going to Shivajinagar, he jumped out of the bus on his own, fell down and sustained injury and died. You could have requested the driver or conductor to stop the bus and get down.
No, it's automatic door. It's
It's not the question of automatic door. He is a doctor. He is a well-known person, educated person.
Right, he fell from the bus and died. That is not disputed.
No, it is not fell from the bus. He jumped out of the bus.
Whatever it may be.
My lord, it makes lot of difference, my lord.
Involvement of the bus was not disputed.
No.
Then section 163A. Then section 163A.
Related to him. Wife
Parents,
and-
sir.
Wife.
Parents.
Parents and
What is his name? Chintan. Chintan. And then, whereas claimant number 3 is brother.
brother.
Oh, brother. He is not dependent.
He was unmarried.
Yes.
He was unmarried.
And even they have produced
One
all
is the mother.
fabricated documents,
Shobha,
false and
mother.
fabricated documents.
Who is? Father is there. Shobha.
2 and 3.
Shobha, wife of
Father.
Quotation.
All parents are bro.
2 is
Parents.
the father. 1 and 2 are the parents.
Yes,
1
ma'am.
and 2 are the parents. 3 is the brother.
What is the number? 1 of.
My lord, Shruti, today morning she told me that she is going to take adjournment. I don't know how my learner. I don't know how my learner friend is making submission. It is totally
Why you have the objection
confusing.
for that? If at all, who has to object? We have to object.
Because I am not prepared.
The wakalat is put up.
Correct.
You argued already. You
ಇಲ್ಲ,
argued
ಇಲ್ಲ,
already saying that.
ಅಲ್ಲ ನೀವು ಅಷ್ಟಕ್ಕೆಲ್ಲ ಆರ್ಗ್ಯುಮೆಂಟ್ ಅಂತ ಆದ್ರೆ ಅಷ್ಟೇ ಕತೆ ಇನ್ನ ಅಲ್ಲ 1,35,00,000 ಅವಾರ್ಡ್ ಆಗಿದೆ ತಾವು ಇಷ್ಟೇ ಆರ್ಗ್ಯುಮೆಂಟ್ ಸಾಕು ಅನ್ನೋದಾದ್ರೆ ವೇರ್ ಪಾರ್ಟಿ ಶುಡ್ ಗೋ ಮೈ ಲಾರ್ಡ್.
The above application like it for a madalala. Third matter request detail consideration admit call for TCRs record ಬಂದಿದೆ ಅಲ್ವಾ? admit call admit ಅಂತ ಇಲ್ಲ ಅಂದ್ರೆ ನಾನು IML ಮಾಡಿ ಆಮೇಲೆ admit orders and I number 1 of 2023. Okay. Under the above application, the response are seeking permission for withdrawal of the amount deposited by the appellant in compliance.
Lord, I have got serious objection regarding the withdrawal of
Stay order granted by the granted by this court. Shri D. Vijay Kumar, Lawyers Council, submits that the appellant has contended that the entire negligence was on the part of the deceased. This is the therefore the liability cannot be fastened to the appellant. The records show that charge sheet our mele ide alva. The charge sheet was filed against the driver of the bus was also not made party illa. The driver of the BMTC bus alla
ಹೌದು.
BMTC bus in question. The fact that when victim Chintan was traveling in the said bus, there was an accident and he died is not disputed. under the circumstances, appellants 1 and 2 are the aged parents of the deceased. Considering the aforesaid facts and circumstances, the tribunal is hereby directed digitally release 50% of the amount in deposit to
40%. 40%.
our deposit ಮಾಡಿದ್ರಲ್ಲಿ 50% ನಿಮಗೆ ಕೊಡ್ಲಿ ಅಂತ ಹೇಳ್ತಾರೆ. 50% of the amount in deposit for 1 and 2.
My lord, they have produced some fraud documents, my lord. He is showing that he is working in 2 places, sir. Other prakara, the income is taken double, more than double they have taken.
Petitioner number 1 is entitled to our amount ಮಾಡಿದ್ದಾರೆ instead of percentage ಮಾಡಿದ್ದಾರೆ.
A small amount may be permitted to withdraw. Otherwise, it will be very difficult for us to recover that amount, huge amount.
In the ratio of 70% to claimant number 1 and 30% to claimant number 2, and furnishing the required documents. IA 1 of 2023 is disposed of accordingly. List for final hearing on subject to the result of this appeal. List for final hearing on TCS ಬಂದಿದೆ, admit ಆಯ್ತು. TCS ಬಂದಿದೆ ಅಂತ ಬರೆದಿದ್ದಾರೆ. ಅಲ್ಲಿಗೆ ಹೋಗ್ಬೇಕು. ಅವ್ರು ಹೇಳೋದಕ್ಕೆ ಕರೆಕ್ಟ್ ಅಲ್ಲ. Return the TCS to the tribunal to facilitate the release of the amount. Soon after the purpose is over, the TCS shall be resubmitted. List on 4 weeks.
11/3.
Okay. Let them furnish security, my lord.
Subject to result of the appeal ಅಂತ ಹೇಳಿದ್ದೀನಿ. This next question.
Seal number 38 adjourned. Seal number 39 G. Lakshmi Shra.
That's created. Alamore. Yes. They are Ella's wife and children, no? They are wife and children.
Wife and children.
Issue notice. For yaar appear agilla na inu. What is you are on which point?
The point of negligence. Postmortem report also from very narrow curvature road at 12 feet came and collided with the bus.
Where the accident took place? Shumagade. Okay. KSRTC bus number so and so. He was traveling on bike. He was riding the bike. Admit call for TCS, issue notice to the respondents. Interim stay of execution of the included award till further order, subject to appellant depositing 50% of the award amount before the tribunal within 6 weeks from the date of this order. List on before the tribunal. IA 1 of 24 stood disposed of
19/3. Seal number 40 Patil Dayananda Subraya Gowda. Dayanand here much.
I represent for respondent in this case.
They are contested. Consent deed. Only this was relied. Petitioner is directed to pay. Yes.
Lords, the trial court has laid upon exhibit P4, my lords. But since my lords, P4 is not before a lordship, my lords, I'll take your lordship's consideration towards page number 14 of the judgment, my lord. At page number 19, my lord, my lord friend has Adrali,
Yes.
may be permitted to read that ಪ್ಯಾರಾಮಿಲರ್. ನಿಪಿ 4 ದಾಖಲೆಯಲ್ಲಿ ಸಹಿ ನನ್ನದೇ ಇರುತ್ತದೆ. ಸದರಿ ದಾಖಲೆಯಲ್ಲಿ ಏನು ಬರೆದಿದೆ ಎಂದು ಸರಿಯಾಗಿ ನನಗೆ ಗೊತ್ತಿಲ್ಲ. ಸದರಿ ದಾಖಲೆಗೆ ನಾನು 2022 ಜೂನ್ ಜುಲೈ ತಿಂಗಳಿನಲ್ಲಿ ಸಹಿ ಮಾಡಿದ್ದಿರಬಹುದು. ಆ ಸಮಯದಲ್ಲಿ ನನ್ನ ತಾಯಿ, ತಮ್ಮ, ಯದುದಾರನ ತಂದೆ ತಾಯಿ ಮತ್ತು ಕುಟುಂಬದವರು ಇದ್ದರು. ಅರ್ಜಿದಾರನ ಮನೆಯವರು ನಮ್ಮ ಕುಟುಂಬದವರನ್ನು ಕರೆಸಿದ್ದರಿಂದ ಅಲ್ಲಿಗೆ ಬಂದಿದ್ದರು. ಯಾವ ಕಾರಣಕ್ಕೆ ಅವ್ರನ್ನ ಕರೆಸಿದ್ದರು ಎಂದು ನನಗೆ ಆ ಸಮಯದಲ್ಲಿ ಗೊತ್ತಾಗಿರಲಿಲ್ಲ. ಆದರೆ ನಂತರ ಗೊತ್ತಾಗಿದ್ದು ದಾಖಲೆಗೆ ಸಹಿ ಮಾಡಿಸಲು ಕರೆದಿದ್ದರು ಎಂದು ತಿಳಿದಿತ್ತು. ನಮ್ಮ ಕುಟುಂಬದವರನ್ನು ನನ್ನ ಮತ್ತು ಅರ್ಜಿದಾರನ ದಾಂಪತ್ಯದ ವಿಷಯವಾಗಿ ಮಾತನಾಡಲು ಕರೆಸಿದ್ದರು. ಅರ್ಜಿದಾರನ ಮನೆಯವರು ನನ್ನ ಮನೆಯವರಿಗೆ ನಾನು ಅವರ ಅವರೊಂದಿಗೆ ಹೊಂದಾಣಿಕೆ ಆಗುತ್ತಿಲ್ಲ ಎಂಬ ಆಪಾದನೆಯನ್ನು ಮಾಡಿದ್ದರು. ನನ್ನ ಮೇಲಿನ ಅರ್ಜಿದಾರನ ಮನೆಯವರು ನನ್ನ ಮನೆಯವರಿಗೆ ದೂರು ಇದ್ದಿದ್ದರಿಂದ ಅದನ್ನು ಬುದ್ಧಿವಾದ ಹೇಳಿ ಸರಿಪಡಿಸುವಂತೆ ತಿಳಿಸಲು ನನ್ನ ಕುಟುಂಬದವರನ್ನು ಕರೆಸಿದ್ದರು ಎನ್ನುವುದು ನಿಜ. ಅರ್ಜಿದಾರನ ಮನೆಯಲ್ಲಿ ನಾನು ಅರ್ಜಿದಾರನ ಮತ್ತು ಅವರ ಮನೆಯವರ ಇಚ್ಛೆಯ ಪ್ರಕಾರ ವಾಸಿಸುತ್ತಿರಲಿಲ್ಲ ಎನ್ನುವುದು ಸರಿ. ದಿಸ್ ಇಸ್ ಇಂಪಾರ್ಟೆಂಟ್ ಆಸ್ಪೆಕ್ಟ್. ಪೇಜ್ ನಂಬರ್ 15. ನಿಪಿ 4 ದಾಖಲೆಯಲ್ಲಿ ನನ್ನ ತಾಯಿ ಮತ್ತು ಸಹೋದರ ಸಹಿಯನ್ನು ಮಾಡಿರುತ್ತಾರೆ. ಅವರು ಸಹ ಅದನ್ನು ಓದಿ ತಿಳಿದುಕೊಂಡಿರುತ್ತಾರೆ. ಸದರಿ ದಾಖಲೆಯಲ್ಲಿ ಏನು ಬರೆದಿದೆ ಎಂದು ನನ್ನ ತಮ್ಮನನ್ನು ಕೇಳಿ ತಿಳಿದುಕೊಂಡಿದ್ದೇನೆ. ನಾನು ಈಗ ನೋಡುತ್ತಿರುವ ವಿಡಿಯೋದಲ್ಲಿ ಕಾಣುತ್ತಿರುವ ಚಿತ್ರಣವು ಸದರಿ ದಿವಸ ನಡೆದ ಮಾತುಕತೆ ಸಂಬಂಧಪಟ್ಟಿದ್ದು ಇರುತ್ತದೆ ಎಂದು ಸಾಕ್ಷಿಯು ಅರ್ಜಿದಾರನ ಟ್ಯಾಬ್ನಲ್ಲಿ ಇರುವ ವಿಡಿಯೋವನ್ನು ನೋಡಿರುತ್ತಾರೆ. ನಿಪಿ 4 ದಾಖಲೆ ನಾನು ಆತ್ಮಹತ್ಯೆಗೆ ಪ್ರಯತ್ನಿಸಿದ್ದ ಕಾರಣ ಮುಂದಿನ ದಿನಗಳಲ್ಲಿ ಅಂತಹ ಪ್ರಯತ್ನಗಳನ್ನು ಮಾಡಬಾರದು ಎಂಬ ಕಾರಣಕ್ಕೆ ನನ್ನ ಕುಟುಂಬದವರ ಸಮಕ್ಷಮದಲ್ಲಿ ಸದರಿ ದಾಖಲೆಯನ್ನು ಮಾಡಿಸಿಕೊಂಡಿದ್ದರು ಎನ್ನುವುದಕ್ಕೆ ಸಾಕ್ಷಿ ಇರಬಹುದು ಎನ್ನುವುದು ಹೇಳುತ್ತಾರೆ. Nipi exhibit P4 is that document wherein this wife attempted to commit suicide on 19th March 2022 by taking pills. ಅದಕ್ಕೋಸ್ಕರ ಈ ಒಂದು ಡಾಕ್ಯುಮೆಂಟ್ ಅನ್ನು ಅವರು ಸೈನ್ ಮಾಡಿಸ್ಕೊಂತಾರೆ. ಯಾರು? ಹಸ್ಬೆಂಡ್ ಮತ್ತೆ ಹಸ್ಬೆಂಡ್ ಫ್ಯಾಮಿಲಿ ಅವರು ಸೈನ್ ಮಾಡಿಸ್ಕೊಂತಾರೆ. ಆ ಸೈನ್ ಮಾಡಿಸ್ಕೊಳ್ಳೋ ಸಂದರ್ಭದಲ್ಲಿ ಅದನ್ನು that has been videographed and when the same was confronted to the wife, she says that yes, it had.
Because this is the first appeal, we have to secure the records and.
No, my lords, before securing, my lords, if a wife commits a suicide, I am a government person, I work for a government department. If an FIR is came to be filed, I am working as a manager in Metro, my lords.
Right now.
Right now, I am presently working.
Right. So no such threat is there now because there is already.
My lords, in this case, my lord, in the case in the hand, my lords,
We'll
wife.
examine the records, we'll secure the records and examine that. This
As a-
judgment, whether this is correct or not, whether this was unequivocal admission. and
ಯಾಕೆಂದ್ರೆ
whether
ಇಲ್ಲೊಂದು
this,
ಎರಡು ಜಡ್ಜ್ಮೆಂಟ್.
I mean confronted.
No, my lord.
65 is.
Having said this, my lords, ಇಲ್ಲಿ ಎರಡು ಜಡ್ಜ್ಮೆಂಟ್ ಇದೆ. ಆ ಜಡ್ಜ್ಮೆಂಟ್ ಅಲ್ಲಿ ಅದೇ ಹೇಳ್ತಾರೆ, if wife threatens to commit suicide, then this amounts to cruelty. So without
Yeah.
looking into the facts, then
We have to read the overall evidence, to consider whether it amounts to unequivocal admission.
as your lordship says.
What admit, call for PCRs. ನೀವೇ ಬೇಕಂದ್ರೆ ಏನು ಮದ್ವೆ ಮಾಡ್ಕೊಳ್ಳೋದಿಲ್ಲ ಅಂತ ಅಂಡರ್ಟೇಕಿಂಗ್ ಕೊಟ್ರೆ ಜಸ್ಟ್ ಏನು ಕೊಡೋದಿಲ್ಲ ನಾವು. Permanent alimony, when he has enjoyed that, he has.
I have not sought for any permanent alimony, my lord. ನಾನು
Permanent alimony.
no, wife has not sought. ಕೊಟ್ಟಿದ್ದಾರೆ ಅದನ್ನ.
Awarded to her. ನೀವೇನಾದ್ರು ಡೆಪಾಸಿಟ್ ಮಾಡಿದೀರಾ ಇಷ್ಟೊತ್ತಿಗೆ?
ಮಾಡಿಲ್ಲ, my lords.
ಮಾಡಿಲ್ಲ ಮತ್ತೆ. If you want to enjoy the fruits of the decree, you have to deposit that. ಅದನ್ನು ಮಾಡಿಲ್ಲ.
I will.
He says your witness has admitted that. We have to. ಅಲ್ಲ, ಇಲ್ಲಿ ಒಂದ್ ಕಡೆ ಹೇಳಿದ್ದಾರೆ, ಇರಬಹುದು ಅಂತ ಹೇಳಿದ್ದಾರೆ.
ಕೇಸ್ಗೋಸ್ಕರ ಹೆಂಗ್ ರೆಡಿ ಮಾಡ್ಕೊಳಕ್ಕಾಗತ್ತೆ?
See, both of you are submitting. We have to see the evidence. ಅಲ್ಲಿ ಒಂದ್ ಕಡೆ ಎಲ್ಲ ಇರಬಹುದು ಅಂತ ಹೇಳಿದ್ದಾರೆ. Let me call for TCRs. Then we'll grant interim stay of the impugned decree till further orders. A1 of 2025 is disposed of.
Lords, if your lordship directs me.
So far it relates to.
Lords, if your lord. That's one submission. If your lordship directs me, I'm ready to deposit the amount. But stay.
Direct record ಬರ್ಲಿ ಬಂದ್ಮೇಲೆ ನೋಡೋಣ.
ಆಯ್ತು.
ಈ ಪಿಟಿಷನ್ ಯಾವ ಇಯರ್ ಇದ್ದು?
ಇದು 2023 ಮೇಲೆ.
ಹೇಳಿದ್ವಿ ನಿಮ್ಗೆ ಅಂಡರ್ಟೇಕಿಂಗ್ ಮಾಡಿ ಹಾಗಾದ್ರೆ ಮದುವೆ ಆಗೋದಿಲ್ಲ ಹಿಯರಿಂಗ್ ಆಗೋವರೆಗೂ ಅಂದ್ರೆ ನಾವು ಕೊಡ್ತೀವಿ ಅಂತ. ಯು ಆರ್ ನಾಟ್ ರೆಡಿ ಫಾರ್ ದಟ್ remarriage. This petition was of 2022. ನಮ್ಮಲ್ಲಿ 2014 ಅಪೀಲ್ ಪೆಂಡಿಂಗ್ ಇದೆ ಇನ್ನು.
ಆಯ್ತು.
ಬೇಡ till further orders. I 1 of 2025 is disposed of accordingly. List after the receipt of TCRs.
Much obliged.
Number 41, D. Vijay Kumar.
My lord, I am for the appellant, my lord. This appeal is by the insurance company my lord, denying the very involvement of the vehicle in the accident. It's a
214
self-accident, my lord, false implication of the vehicle and also no DL. I am ready to deposit 50% of the award.
Admission delay idre admission list ಅಲ್ಲಿ ಯಾಕೆ ಬಂದಿದೆ ಅಂದ್ರೆ ಅವ್ರು ಕೇಳಿ ನೋಡಿ ಈ ತರ ಯಾಕೆ ಮಾಡ್ತಾರೆ ಅಂತ ಅಲ್ಲ ಅವ್ರು ಬರೋದ್ರೆ ಇವ್ರು ನೋಡ್ಬೇಕಲ್ಲ. Issue notice to the respondents. Interim stay of execution of the impugned award till next hearing date, subject to deposit of 50% of award amount paid for the tribunal. This one, interim order till next hearing.
19-3.
Much obliged.
For further hearing, seal number 42, Gopal Krishnayan, HC Betsur.
I pay for appellant in this case, my lord. My lord, we've inquired with the CC of the criminal case of the judgment, my lord. They've not produced any copies, my lord. Kindly, I pray for 2 weeks' time, my lord.
Non-submitting of copy of judgment in the criminal case, Betsur. Yes, you got it?
I have not received that.
Yes, madam.
My lord, even we have not received, my lord. We have inquired with the trial court advocate. He sought for 2 weeks' time, my lord. Kindly.
2 weeks, sir. And now Haki's crime number Haki trial court crime number ಹಾಕಿದ್ರೆ ಆ ಮ್ಯಾಜಿಸ್ಟ್ರೇಟ್ ಕೋರ್ಟ್ ಎಲ್ಲಿಗೆ ಬರುತ್ತೆ ಅಲ್ಲಿ ಹಾಕಿದ್ರೆ ಸಿಗುತ್ತೆ. ಒಂದು ಸ್ವಲ್ಪ ಅಲ್ಲಿ ಬಂದಾಗ ನೆನಪು ಮಾಡಿ ನಮ್ಗೆ ಲಾಕ್ both counsels seek time to produce the document. ನೀವು ಟ್ರೈ ಮಾಡಬಹುದಲ್ಲ ಇನ್ಶೂರೆನ್ಸ್.
Even I have intimated to the insurance company, my lord.
Based on crime number they can trace. ಅಬ್ಬಾ ಅವ್ರಿಗೆ ಅಲ್ಲಿ ಲೋಕಲ್ ಬ್ರಾಂಚ್ ಕೇಳಿದ್ರೆ ಗೊತ್ತಾಗುತ್ತೆ. They can produce.
Even I too have sent a mail in that regard.
ಚೇಂಬರ್ ಕಳ್ಸೋವಾಗ ನೆನಪು ಮಾಡಿ.
5-2.
My lord, any date after February 22nd, my lord. My senior.
We'll try to find out.
Yes, ma'am.
February. ಸಿಗ್ಲಿಲ್ಲ ಅಂದ್ರೆ ನೋಡೋಣ. If we are not able to get from the website of that magistrate court, then we will grant one more adjournment.
Yes,
Because we have heard this matter. No?
Yes, my lord. Very for disposal.
5-2.
Much obliged, madam.
5-2. For final hearing, seal number 43, Meenakshi K. Natation, HR Renuka Paraga.
Serial number 40. This is the first one. Our motor accident case ಯಾಕೆ ಬಂದ್ರು ಅಂತ. Yes.
I had a problem because
No.
everybody was associated with the case. I got married in the deputy office. Ultimately,
No, we were wondering. ಅದು ಯಾವ್ದೋ ಬೇರೆ MSc ಬಿಟ್ಟು ಬೇರೆ ಇರ್ಬೋದು ಅಂತ ನೋಡ್ಕೊಂಡು again we got it out and checked the list. All right, yes.
So, my lord, in case I commit some error, not my normal. Point here is, my lord, the young girl working somewhere, educated. He's trying to get into the bus, driver closes the door and starts the bus. Take this attitude. This is the background. The trial court.
How much percentage of disability was taken?
80%. My lord, what impact, sometimes I felt so careless.
Her age was.
She can get from Jaipur, like, and put it on the foot and walk.
Right. Date of accident is 3/2/2010. 2010. At 7:50 p.m.
Negligence. Who's 25 years old, software engineer.
25 ಅಂತಾನೆ ತಗೊಂಡಿದಾರ. How much is considered? Correct.
Which
Now
page in the
calculate ಮಾಡೋದಕ್ಕೆ.
Which page in the judgment, the finding regarding the age and the
Page 21.
internal,
Page 21, paragraph 4.
Page 20.
the finding of the tribunal.
Because they have not preferred any appeal, no? So if that is, whatever is taken by the tribunal, we have to accept that now. Unless you dispute regarding age and other.
I think at para 25 of the tribunal, type page.
The lordship comes to.
Para 25.
Page 23 page.
Income.
Para 80.
Age.
before this tribunal that due to the accident, petitioner sustained grievous injuries. Issue number 1 in the affirmative. Page 30.
Correct, that finding is not under challenge.
Then next, my lord.
Age ಬಗ್ಗೆ ಈಗ ನೋಡಿ 25. The petitioner is 25 years. 25 years. Age is 25 years.
25, there is nobody is doing any of those.
And disability spoken, injuries, where is the injuries mentioned? Short ಇದ್ರಲ್ಲಿ ಹೇಳಿದ್ರು. ಅಲ್ಲ ಇವ್ರ ನೋಟ್ಸ್ ಇದ್ರಲ್ಲಿ ಸಿನಾಪ್ಸಿಸ್ ಎಲ್ಲ ಏನಾರ ಹೇಳಿದ್ರೆ
But para 22 is the lord to see.
ಕರೆಕ್ಟ್ ಅದೊಂದೇ ಇದೆಯಾ ಮತ್ತೆ
By examining the medical after petitioner reports over time, 80% disability whole body. Left leg above the knee was amputated. The question of assessing the percentage of disability.
PW, doctor is PW?
PW2.
PW2 doctor.
The petitioner has awarded compensation.
He assesses the disability at 80%.
But
Doctor has assessed at 80%. 80%. She is a software engineer.
Software engineer. Well, please come to page number 37, para 23, where the judge says there cannot be any dispute that he had permanent disability to the whole body to the extent of 70 to 80%.
ಎಷ್ಟು?
Page 37, paragraph 23.
23.
Last 4
Yes,
lines.
72 disability, the whole body at 70 to 80%. Yes. Yes.
He gets some compensation from the company. That is at page number 39, para 26.
Now, except this amputation, there were no other injuries.
Amputation.
Doctor evidence PW2. Doctor evidence not below. Left thigh deglowing injury with left femoral condylar fracture and injury to popliteal artery with confusion of left artery or fracture segment. So these were the injuries and the pain and suffering for the then
The major portion of the
I submit patient has suffered 80% disability to the whole body. Yes.
The major portion of the compensation was regarding the artificial limb. We had examined a doctor at Mark, he said that it would cost for an ortho limb 16 lakhs and has to be done about once in 6 or 7 years, it has to be replaced. That was the major portion because we said that she was software engineer at a young age and the judge says, no, she can have the Jaipur leg and walk around. That was not the...
So, no compensation is awarded on the head of loss of future earnings because she continued in the said job.
She continued after she resigned because she couldn't work. She used to travel around growing.
What was her position in her company?
Software engineer.
Software engineer
Nothing very high position. She just started work.
Employer fitness trainer.
Mindtree company. Mindtree company. She was a senior engineer.
ಅದೇ ಅವ್ನು ಕೊಡೋದಕ್ಕೆ ಎಷ್ಟು ಸರ್ತಿ ಆಗುತ್ತೆ ಎಷ್ಟು ಸರಿ ಹಾಕಿಸ್ಕೋಬೇಕು ಅನ್ನೋದ್ರ ಬಗ್ಗೆ ಆಗುತ್ತೆ how many times they need ಓನರ್ ಯಾರು ಇದು ಸರಿ employer is examined.
She resigned after a year.
Correct, she was earning this much or she was terminated.
I produced subsequently 4127 only. I was able to get some paper from the employers. They produced to
You could have examined the employer, summoned and examined him.
Mindtree has got this case.
She resigned the job and. Allah, this is appointment letter. Appointment letter. No, like lot of future admins. Continuous job, very mentally. ಅವಾಗ ನಾವು ಅಮ್ಯುನಿಟೀಸ್ ಮತ್ತು ಇದರಲ್ಲೆಲ್ಲ ಕೊಡಬೇಕು. Income they are not.
Exhibit P10 is the pay slip which I have.
Okay. All right, you can submit it. We got, yes. No, now, what was the error? 80% of disability, and they have not awarded anything on the head of loss of future earnings. ಅದಕ್ಕೆ loss of future earning ಆಗಿದೆ ಅಂತ ತೋರಿಸಕ್ಕೆ you not.
What more is for a prosthesis?
Prosthesis,
That was, well, and the learner just says she could have bought and worn it. If I had so much of money, I wouldn't even be running around like this.
How much?
He produced the.
This quotations.
Doctor. They said 16 lakhs some thousand. And they said once in 7 years, you might have to replace it. And every year, maybe 1 or 2 years at a time, you'll have to do some adjustments because of the continuous movement of the knee area. And that has not.
Yeah, Dr. PW, he says PW4 is PR Sudarshan. PW2 is Dr. Nagaraj.
Dr. Nagaraj.
PW2 has spoken that she needs once in 7 years.
Yes. He says that lot of sees PW2.
By the time the case was disposed of, she was fixed with this prosthesis first time.
No.
At that time.
Some local.
Correct. Anywhere, something was fixed. I mean, one prosthesis was fixed.
But then what happened? You see the doctor's thing. Please see.
Other the quotation quotidra, whatever was fixed to her pending this petition, that that bill was given. That bill which she had adopted one other bill quotidra.
Nominal cost.
Other bill quotidra, at least other the.
Modular 4,29,835. Exhibit P33.
We gave Miss Adel on 34 year PW4. This is I submit that on 34 2010. We gave him a fitment proposal. The auto box. Let's do this. Quotation of 18 lakhs.
Score was remanded back and then we marked exhibit P33.
P33. Invoice. Invoice.
4,29,835.
Oh, that which one she had bought? 4 lakh.
Patient using PF process in so and so. Total cost is 6,03,000. You receive full and final payment.
I didn't care. P33. Once.
P34, 35, 33, 34, 35.
33 is invoice. 4,43,000.
Auto box is 34. Payment details for transfemoral prosthesis for Hema Subhash.
Just. P33, no? P33.
33, 34, 35.
Invoice.
And
Invoice for 4,29,800. 4,29,835 after discount. The rate after discount. One niche. The accessory is very 4,43,200. 200 is fast. Next to the name.
The bill. Invoice. The bill is for payment details. Apart from the process, certain other appendages.
Exhibit P34.
430.
P34 bill. Prosthesis. What the total list again is 6,03,703. 6,03,700.
That's what we paid.
This was on. ಅಲ್ಲ ಬಿಲ್ ಅಂತಾರೆ ರಿಸಿಟ್ ಕೊಟ್ಟಿದ್ದಾರಲ್ಲ ಅದಕ್ಕೆಲ್ಲ
There are several dates, ma'am.
ಯಾವ ಡೇಟ್ಗೆ ಇದು
Several dates, 10th June 2010.
ಪೇಮೆಂಟ್ ಆಗಿದ್ದು ಬೇರೆ ಬೇರೆ ದಿವಸ ಆಗಲಿ ಅಂದ್ರೆ ಅವ್ರು ತಗೊಂಡಿದ್ದು ಪೇಮೆಂಟ್ ಮೇ ಬಿ ಆನ್ ಡಿಫ್ರೆಂಟ್ ಡೇಟ್ಸ್.
On different dates, payment.
What is the date of exhibit P34?
That fixing was on which date? 2011. But anyway, it is in 2011. ಇದು ಮುಂದಿನ ಮೇಂಟೆನೆನ್ಸ್ ಇರ್ಬೇಕು. ಮೇಂಟೆನೆನ್ಸ್ ಇರ್ಬೇಕಲ್ಲ.
There's a finding on exhibit P34 in the remand order, Melo. At para 9 may kindly be seen.
ಡಾಕ್ಯುಮೆಂಟ್ ನೋಡಿ ಮುಗಿಸ್ಬಿಡಿ.
2014, left hand top corner. 2014 date ಬರ್ತಾ ಇದೆ.
October. Dated 21/10/2014. ಅಷ್ಟೊತ್ತಿಗೆ ಫಸ್ಟ್ ಟೈಮ್ ಡಿಸ್ಪೋಸ್ ಆಗಿತ್ತಾ? 21/10. So after disposal of this case, ಅದ್ ಹೆಂಗ್ ಅಲ್ಲಿ ಮಾರ್ಕ್ ಆಗುತ್ತೆ? ಇದು 19th June 2000. ಅಲ್ಲ ರಿಮೈಂಡ್ ಆದ್ಮೇಲೆ ಅಂದ್ರೆ ಇಟ್ ವಾಸ್ ಲಿಮಿಟೆಡ್ ಪರ್ಪಸ್ ಎವಿಡೆನ್ಸ್ ರೆಕಾರ್ಡ್ ಮಾಡಿ ನಮಗ್ ಕಳ್ಸೋದಕ್ಕೆ ಮಾಡಿ ನಾಟ್ ಫಾರ್ ಎಡ್ಜುಡಿಕೇಶನ್ ಬೈ ದ ಟ್ರಿಬ್ಯುನಲ್. ಅಲ್ಲ ಇಲ್ಲ ರಿಮೈಂಡ್ ಆಗಿರೋದು ಓನ್ಲಿ ಫಾರ್ ಲಿಮಿಟೆಡ್ ಪರ್ಪಸ್ ಅಂತ ಹೇಳ್ತಾರೆ ಎವಿಡೆನ್ಸ್ ರೆಕಾರ್ಡ್ ಮಾಡಿ ಕಳ್ಸೋದು. ನಮ್ಮ ಆರ್ಡರ್ ಶೀಟ್ ಅಲ್ಲೇ ಇರುತ್ತಲ್ಲ ಹಾಗೆ ನಮ್ಮ ಆರ್ಡರ್ ಶೀಟ್ ಅಲ್ಲೇ ಇರುತ್ತಲ್ಲ ಹಾಗಿದ್ರೆ ರಿಮೈಂಡ್ ಮಾಡಿದ್ದು
20th of January 2020 Melo. Remand order.
20th January 2020. 21 or 22? 16/10/2020 ಒಂದು ಆರ್ಡರ್. Directing the parties to appear before. No, that was 16/10/2020. Records along with the order is said to have been received by the learned judge of the tribunal on 4th in view of closure of the case. Either extension of time. Extension to record evidence. 1960.
21/20 order.
ಇದರಲ್ಲಿ ರೆಫರೆನ್ಸ್ ಇರಬಹುದು ಅಂತ ಆರ್ಡರ್ ವ್ಯವಸ್ಥಿತ ಅಂತ
21/20/2020 order of this court.
Yes,
This is the order on by
20th January 20.
Yes.
1 of 2017.
Yes.
That is additional evidence. Oh, let's see.
1 of 2017.
21/20.
That is the date of order. Where they say that the order of termination of service receiving letter have come into existence after the passing of the award, and therefore we are sending it back while retaining says in.
We direct the tribunal to record the finding regarding. Oh, finding record ಮಾಡೋದಕ್ಕೆ ಹೇಳಿದ್ದಾರೆ, not just recording the evidence and sending back. So after this finding is returned. ಇದು ಒಂದು ಇನ್ನೊಂದೇ ನೋಡಿ 34 ಆಗಿ 35 ಒಂದು ನೋಡಿದ್ರೆ we can
ಬಗ್ಗೆ ಮಾಡಿಲ್ಲ, ಯಾವುದು ರೆಸಿಗ್ನೇಷನ್ ಬಗ್ಗೆ ಮಾಡಿಲ್ಲ, ಬರೀ ಮೆಡಿಕಲ್ ಬಿಲ್ಸ್ ಅಷ್ಟೇ.
Finding ಬಗ್ಗೆ medical resignation ಬಗ್ಗೆ ಏನು ರೆಕಾರ್ಡ್ ಮಾಡಿಲ್ಲ.
ಮಾಡಿಲ್ವಾ? ಬರೀ ಎವಿಡೆನ್ಸ್ ರೆಕಾರ್ಡ್ ಮಾಡಿ ಹೊರಗೆ ಕಳಿಸ್ಬಿಟ್ಟಿದೆ.
ಇಲ್ಲ ಮೈ ಲಾರ್ಡ್, ಪ್ಯಾರಾ 9 ಅಲ್ಲಿ
ಅಲ್ಲ ಇಷ್ಟೇ.
only on 6 lakhs my lord, the medical bills ಬಗ್ಗೆ.
Petitioner has proved exhibit P34 medical bill, but the same was reimbursed by the insurance company, whereas petitioner has failed to prove exhibit P35 estimation for future medical expenses. This is the finding given by this court as per the direction of the Honorable High Court. With respect to additional documents produced, office is thereby directed to submit. ಇಷ್ಟೇ ಫೈಂಡಿಂಗ್ ಇಷ್ಟಿದೆ ಅದ್ರ
ಮೆಡಿಕಲ್ ಬಿಲ್ಸ್ ಬಗ್ಗೆ ಮಾತ್ರ ಅಷ್ಟೇನೆ. ಅದು
ಅದರಲ್ಲೇನೂ ಕೂಡ the tribunal has held that proved 34 ಅಂತ ಹೇಳ್ತಾರೆ, 35 ನಾಟ್ proved ಅಂತ ಹೇಳ್ತಾರೆ.
34 ಇಸ್ ರಿಯಂಬರ್ಸ್ ಆಗಿದೆ.
ಅಲ್ಲ ರಿಯಂಬರ್ಸ್ ಆಗಿದ್ರು ಕೂಡ ಅದು ಬಿಕಾಸ್ ಆಫ್ ದ ಕಾಂಟ್ರಾಕ್ಟ್ ಅಂತ ಈಗ ಸೆಬಾಸ್ಟಿಯನ್ ಲಾಕ್ರಾ ಕೇಸಲ್ಲಿ ದಟ್ ಕೆನಾಟ್ ಬಿ ಕನ್ಸಿಡರ್ಡ್ ಅದರಲ್ಲಿ, ಬಟ್ cannot be considered ಅಂದ್ರೆ your liability is still there to pay that.
Melod, they cannot.
Because it is a contractual benefit ಅಂತ ಹೇಳಿದ್ದಾರೆ.
Melod, there are two things, my lord, because if you lost this.
34 ಒಂದೇ ಪ್ರೂವ್ ಆಗಿದೆ ಅಂತ ಹೇಳಿದ್ರೆ 34 is 6,03,700.
Yes, madam. That is reimbursed.
Take that this is the finding of the tribunal.
Yes.
Enhanced by 6,03,700.
My lord, that's also, my lord, reimbursed by the insurance company, my lord.
Correct, madam. Madre, Sebastian Lacroix judgment ಅಲ್ಲಿ it is held that if the claimants get some benefit because of the contractual obligation, they pay premium for that. So that
But
cannot have
this
been set
honorable
off.
court has held, my lord, the division bench of this honorable
Well,
court
no,
has held.
Supreme Court judgment we have to follow.
My lord, by referring to Sebastian case, my lord, it has been held that if they cannot have dual benefit anta.
Correct, but see, ಅವ್ರು ಪೇಮೆಂಟ್ ಮಾಡಿರ್ತಾರೆ, ಅವ್ರು ಪೇಮೆಂಟ್ ಮಾಡಿರೋದಕ್ಕೆ ಅವ್ರಿಗೆ ಬೆನಿಫಿಟ್ ಬಂದಿರುತ್ತೆ. ಅದು ಗ್ರಾಚ್ಯುಟಿಯಸ್ ಆಗಿ ಬಂದ್ರೆ
My lord, I will make, my lord, I'll put it this way, my lord, I'll make, I will make payment, my lord, subject to production of original bills, my lord. The original bills are with the insurance company. My lord, it's always,
they
my
have
lord,
still grievance because only 6,03,000.
34,000, my lord.
6,03,703 is enhanced.
They say that we can't really put this prosthesis unless you remove the skin graft, it will cost 4 lakhs rupees, is 35. It's only an estimate saying that it will cost so much, until it is expert 35, you cannot succeed.
And there's one more finding, my lord, in para 9.
Reasoning, this is
Till
reasoning.
today, she has not undergone surgery.
Where's the money?
14 years agide.
Whether you got the copy of this order, subsequent finding, ನೀವು ಯಾರು ತಗೊಂಡಂಗ್ ಕಾಣ್ತಿಲ್ಲ.
My lord, ನಾನು
ಇಲ್ಲಿ order sheet ಅಲ್ಲಿ 15 January to
my lord, I've seen, I made notes, my lord, by reading.
seen. ನೀವು ನೋಡಿಲ್ಲ ಅಂತ ಕಾಣಿಸುತ್ತೆ. Reasonings ಕೊಟ್ಟಿದ್ದಾರೆ ಅವರು ಅದಕ್ಕೇನೋ ಸ್ವಲ್ಪ.
ನಾನು ಲಾಸ್ಟ್ ಟೈಮ್ ಬಂದಾಗ LCR ತಗೊಂಡೆಲ್ಲ ನೋಟ್ಸ್ ಮಾಡಿದ್ದೀನಿ.
ಸರಿ, ನೀವು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿ. ಏನ್ ಹೇಳಿದ್ದಾರೆ 35 ಬಗ್ಗೆ? If you have the ಬರೀ ನೋಟ್ಸ್ ಮಾಡ್ಕೊಂಡಿದ್ದೀರಾ?
Exhibit P35 not examined doctor to prove that he requires
ಇದು ನೋಡ್ತಿದ್ರೆ you can go through this.
Continue the after.
This witness cross-examined by counsel for respondent wherein the she categorically admits that as per exhibit P35 she has not undergone operation at Sparsh Hospital till today. She further admits that Autobac hospital medical expense was already paid by the insurance company. Witness volunteers that thereafter whatever medical expense incurred by her have not been reimbursed. To show that except P34 she has not produced document. ಅದನ್ನ ನೋಡಿಬಿಡಿ, ಇದು ಈ ತರ
I produce an estimate saying that for further operation. You don't give me money. I don't do the operation. At least you could have said that do the operation, let them pay me some money and do the operation and show you the bills. Well, I am not in a position to do anything. You destroy my life and now come and argue on all these things. These are not people who come here and make false claims.
Correct. Now, let us know what are the points for consideration now. Are you on the point that loss of future earnings should have been given?
First of all, my basic medical treatment.
Andre, we can go accordingly. If you are not on that point, then we can medical expenses, pain and suffering, etc. we can consider. First, make it clear whether you are challenging the award on the ground that
medical treatment, hospitalization has not been fully considered.
So challenge is medical expenses, medical expenses. Matte?
Loss of future earnings.
ಅದನ್ನೇ ಕೇಳ್ತಾ ಇದ್ವಿ ನಾವು, because that is the main point.
Loss of future earnings, future medical expenses, in view of the peculiar nature of my injury.
ಅದು next. First, loss of future earnings ಇದೆ ಅನ್ನೋದನ್ನ ಪ್ರೂವ್ ಮಾಡಿದ್ಮೇಲೆ ಅವ್ರು ಹೇಳಿಲ್ಲ ಅಂದ್ರೆ we have to add to that because 80% disability is spoken.
Pain and suffering and trauma. A girl of 25 losing her leg and seeing that there's no leg is 75,000 rupees. I understand that.
Pain and suffering, loss of marriage prospects ಕೊಟ್ಟಿದಾರ? She was married or unmarried?
1,25,000 has been awarded.
Supreme Court judgment 3 lakhs ಕೊಟ್ಟಿದ್ದಾರೆ ಕಾಜಲ್ and ಇದರಲ್ಲಿ.
Yes.
Loss of marriage prospects
1.25.
Not ಬರ್ಕೊಳ್ಳಿ.
Pain and suffering.
ಈಗ see, future medical you are on the point now as you say, future medical expenses, pain and suffering, loss of marriage prospects and loss of future earnings.
Loss of future earnings.
Future earnings, whether anything is awarded on loss of amenities?
1 lakh.
Are you challenging that also?
Loss of amenities also.
ಏನ್ ಕಡಿಮೆ ಆಯ್ತು ಅಂತನಾ?
And loss of earning during laid up period has been awarded, my lord, for 5 months at the rate of 34,000 per month.
Loss of amenities, I paid 3 lakhs, the court awards me 1 lakh. But these are not, I'm not saying that do it with mathematical precision. The point remains, look at the age of the girl, her qualifications, her life is destroyed. Least KSRTC rules to give her a limb to walk. 20 years or over, limb is not
ಅಲ್ಲ
available.
ಆಯ್ತು, ಅದನ್ನ ಹೇಳಿದ್ರಲ್ಲ, ಪ್ರೊಸೆಸಸ್ ಫ್ಯೂಚರ್ ಮೆಡಿಕಲ್ ಎಕ್ಸ್ಪೆನ್ಸ್. ಸಿ
Sometimes, maybe I don't
those-
do these cases often, but it really offends.
ಅದಕ್ಕೆ ನಿಮ್ಗೆ ಕಷ್ಟ ಆಗ್ತಾ ಇದೆ. ಈಗ ನಾವು ದಿಸ್ ಆರ್ ಆಲ್ ಸ್ಟ್ಯಾಂಡರ್ಡೈಸ್ಡ್. ಈಗ ಓನ್ಲಿ ನಿಮಗೆ ಮೇಜರ್ ಬರೋದು ಯಾವ್ದ್ರಲ್ಲಿ ಅಂದ್ರೆ, ಇಫ್ ಎಟ್ ಆಲ್ ಇಟ್ ಇಸ್ ಹೆಲ್ಡ್ that there is loss of future earnings because of her disability, then substantially increase ಆಗುತ್ತೆ. ಅದಕ್ಕೆ you have to prove that there is loss of future earnings because her job was software engineer. ಈಗ ಡ್ರೈವರ್ ಆದ್ರೆ ಬೇರೆ.
She has attended conferences, she has go from place.
ಅದಕ್ಕೆ ಎವಿಡೆನ್ಸ್
She
ಏನಿದೆ?
continued her employment or she has? Is there evidence on record for that? Can point out to that.
You said you have not examined the employer.
Yes, we have produced a certificate saying she's been relieved effective 4th July 2014.
Exhibit?
Exhibit ಎಷ್ಟು?
Oh, no,
It's not marked.
Because of
Mark ಆಗಿಲ್ಲ.
Agilva. Now, with regard to employment, what are the exhibits?
There's otherwise finding, my lord, if your lordship could see page 21 of the judgment, my lord.
21.
Page 21.
Typed page?
No, judgment page 21, my lord.
Judgment page.
Turn at page 21.
Judgment page 21, fourth line, my lord. The petitioner who was,
One has specifically admitted in para 12 of her cross-examination that she has continued to work in the same post even after the accident. This would indicate, indicate that because of the accident or disability caused due to the injury sustained in the accident, she had no future loss of income.
What happened? Time control, then they said, come back. Tirga, I went back. I told the truth, I went back. to
Correct
work.
ಆದ್ರೆ ಪ್ರೂವ್ ಮಾಡ್ಬೇಕಲ್ಲ.
After the
ಎಂಪ್ಲಾಯರ್ ಅನ್ನು ಎಕ್ಸಾಮಿನ್ ಮಾಡ್ಬೇಕಿತ್ತು ನೀವು. She was terminated because of her disability ಅಂತ ಹೇಳಿ. I mean, some these companies they do not terminate, but they make her to leave on their own. ಆ ತರ she was unable to perform her recording of ACR. That performance was reduced. Therefore, appraisal. Performance was reduced. ಅಂತ ಅದನ್ನ ಏನಾದ್ರು ಎವಿಡೆನ್ಸ್ ಆಗ್ಬೇಕಿತ್ತು.
Can't really say performance is reduced, but opportunities disappear. A man without a leg, opportunities disappear.
ಅಲ್ಲ, that is other part. Whether she could move about, career prospect is reduced. ಅದಕ್ಕೆ ಫ್ಯೂಚರ್ ಪ್ರಾಸ್ಪೆಕ್ಟ್ಸ್ ಕೊಡ್ತೀವಲ್ಲ, ಅದ್ರ ಮೇಲೆ ಹಾಕೊಡೋದಿದ್ರೆ.
May I request her to have it tomorrow, I'll see the evidence also.
ನೋಡಿಲ್ವಾ ನೀವು ಎವಿಡೆನ್ಸ್?
Like I said.
You see this finding also. Orders evidence ನೋಡಿದೀರಾ? Depositions.
What I mean.
No, that's after remand, TW1 further evidence is there.
ನಾನು ಓದಿ ಮಾರ್ಕ್ ಮಾಡಿದ್ದೀನಿ.
ನಾವ್ ಯಾರು ಇಬ್ರು ಅಪ್ಲೈ ಮಾಡಿಲ್ಲ.
Judgment of cross examination, chief examination. ಅಲ್ಲ, ಅದು cross. I have not undergone operation. But I'm in the job. She was examined after this remand. Ali, it seems whether she has said that she is relieved because of this chief examination photo record ಮಾಡಿದೆ. Affidavit ಅಲ್ಲ. Ali, it seems you have not elicited that. After remand, she is relieved from the job ಅಂತ ಹೇಳಿ.
ಏನು ಇಲ್ಲ ಸರ್.
After remand, the further evidence is limited only to future medical expenses and not about employment.
But still they could have.
Even the order also was only on that, my lord, medical bills ಬಗ್ಗೆ. But ಅವ್ರು ಮಾಡಿಲ್ಲ.
ನೋಡಿ ಎವಿಡೆನ್ಸ್ ನೋಡಿ. ಸೊ ಕೇಸ್ ತಗೊಂಡವರೆಲ್ಲ ಮದುವೆಯಾಗಿ ಹೋಗ್ತಾರೆ ಅಂತಂದ್ರೆ ಅಲ್ಲ ಕರೆಕ್ಟ್. We have to send some other eligible bachelor for it.
Contacting her.
ಅಲ್ಲ ಕರೆಕ್ಟ್. We have to send to your office another eligible bachelor to keep in charge of this case. So that you can go through that. ಓದಿ ನೋಡ್ಕೊಂಡು. ಏನೇನೋ ಹಾರ್ಡ್ ಇನ್ ಪಾರ್ಟ್. ನಾವು ಹಾರ್ಡ್ ಇನ್ ಪಾರ್ಟ್ ಅಂದ್ರೆ ಮತ್ತೆ For further hearing, heard Shri Vatsa Leonard Senior Counsel for so and so advocate on record for the appellant in part. For further hearing, as requested, list on
Monday,
Monday.
3-2. 3-2. Monday.
Is that a?
Tuesday.
Yes, list on.
4-2.
4. ಇದು ಎಲ್ಲ ಹ್ಯಾಂಡಲ್ ಮಾಡೋದು ನಮಗೂ ಕಷ್ಟ ಆಗುತ್ತೆ. ಡಿಪೋಸಿಷನ್ ಕಾಪೀಸ್ ಅದೆಲ್ಲ ಇದ್ರ ಒಂದು ಸೆಟ್ ಮಾಡಿಕೊಟ್ರೆ ಅನುಕೂಲ ಆಗ್ತದೆ.
Like a regular appeal, I will get it put together.
Cell number 44 adjourned. Cell number 45. RB Sudarshlekha.
Non-furnishing of particulars in respect of R6. Who is R6 here?
I'm representing R6.
But the plaintiff is also may not the wife of the first respondent. The matter pertains to may not the entitlement of the family pension. The second wife. But the statute permits, first respondent also admits may not during the course of the, he was the first dependent. The plaintiff is the wife of the first dependent.
R6.
Married the sixth dependent also.
ಏನ್ particulars ಕೊಡಕ್ ಹೇಳಿದ್ರು? ಇಲ್ಲ ನಮ್ಮ ಮಾಡ್ರಲ್ಲ ಇದು. ಇಲ್ಲ last paper is alive. Oh, ಅವ್ರು
She's alive. Respond number 6 is alive.
ಮತ್ತೆ ನೀವೇ ಯಾರೋ submission ಮಾಡಿ. Though this court had ordered in the sense directed the learning council person to keep present respond number 6 for instruction, we would submit that whereabouts of this case is not known. Our learning council for appeal service said he would furnish the information, if any, about the particulars of respond number 6. If so, re-notify.
He is alive, may not, but that may not where she is residing even
ಅಲ್ಲ ನೀವು you represent respond number 6.
Yes, my lord, I'm representing.
ಮತ್ತೆ ಅವ್ರನ್ನ ಪ್ರೆಸೆಂಟ್ ಇಡಿ ಅಂತ ಹೇಳಿದ್ದಾರೆ ಅಂತ.
She is not available today. I will check with my senior and we will make her to present in next date, my lord.
She did not agree.
I don't know, my lord. I need to check with as
agreed, may not see her name entered in the service register.
she's a first wife, so
She is alive.
Yes, yes, my lord. She's alive.
ಮತ್ತೆ why did you submit like that?
Last time inspection address
Who submitted that she is not alive? ಅಲ್ರಿ ಹಿಂದೆ ಯಾರೋ she is dead ಅಂತ ಹೇಳಿದ್ದಕ್ಕೆ ಮತ್ತೆ she should be physically present etc. ಯಾರಿ but on whose submission it was recorded like that? ನೀವು ನಿಮ್ಮ ಪಾರ್ಟ್ ಅಲ್ಲೇನೆ.
No, we only inform she is alive. So how we can tell like she's not alive?
ಅಲ್ಲ we are asking you on whose submission. Meanwhile, our consultant is directed to keep present ಇದಾಯ್ತು. On whose submission it was recorded that she is dead? Be present before the ಎಲ್ಲ ತುಂಬಾ ಹಿಂದೆ ಹೋಗ್ತಾ ಇದೆ ಅಂತ ಕಾಣಿಸುತ್ತೆ. ಸೆಟಲ್ಮೆಂಟ್ ಹೇಳಿದಾಗ ಹಾರ್ಡ್ ಅಡ್ಮಿಟ್ ಅಂತೆಲ್ಲ ಆಗಿದೆ ಮುಂದೆ ನಮ್ಮ ಮುಂದೆ ಯಾವಾಗಲೂ ಆಯ್ತು ಈಗ ಬೋತ್ ಕೌನ್ಸಿಲ್ ಸಬ್ಮಿಟ್ ಇದೆ ಬಟ್ ಹೌ ಅಲ್ಲಿ ರೆಕಾರ್ಡಿಂಗ್ ಹೇಗೆ ಬಂತು ಅಂತ ವಿತ್ ದಿಸ್ $1,000 ಕ್ವಶನ್ ಹೂ ಸಬ್ಮಿಟೆಡ್ ದಟ್ ಶಿ ಇಸ್ ನಾಟ್ ಅಲೈವ್ ಗೊತ್ತಿಲ್ವಾ ಇಬ್ರು ಏನಾದ್ರು ಕೋರ್ಟ್ ನಿಂದ ನೋಟಿಸ್ ಹೋಗಿದ್ದು ರೆಕಾರ್ಡ್ ಮಾಡಬಹುದು. Both counsel submit that respond number 6 is alive. ಇಲ್ಲ ಅದು ಯಾರಿಗಾರ ಡೌಟ್ ಬಂದಿತ್ತು ಅಂತ ಬೆನಿಫಿಟ್ ಮತ್ತೊಬ್ರು ಯಾರ ತಗೊಳ್ತಾ ಇದಾರೆ ಆಕೆ ಹೆಸರಲ್ಲಿ ಅಂತ. ಇದ್ರೆ ಎಲ್ಲಿದ್ದಾರೆ ಅಂತ ಗೊತ್ತಾಗ್ಬೇಕಲ್ಲ. ಯಾವ್ದು 25/10/2024 ಅಲ್ಲಿ she was ordered to be produced.
She agrees, my lord, I am also entitled 50% of the family pension. The sixth respondent has not agreed. ಅದಕ್ಕೆ ಅವ್ರನ್ನ ಪ್ರೆಸೆಂಟ್ ಇಡಿ ಅಂತ ಹೇಳಿದ್ರು.
ಅದಕ್ಕೆ ಪ್ರೆಸೆಂಟ್ ಇಡಿ.
Statute also permits, my lord, under the KPT regulations, my lord, even the claim to copyright title equal mention.
ಏನೋ ಇದ್ರಲ್ಲಿ ಕೇವೆಟ್ ಹಾಕಿದ್ರ ಹೇಗೆ ಹೌದೇ ಕೇಮ್ ವಕಾಲತ್ ಫೈಲ್ ಈಗ ದೇ ಆರ್ ಅಗ್ರಿಯಬಲ್ ಫಾರ್ ಸೆಟಲ್ಮೆಂಟ್ ಇಲ್ಲ ಅವ್ರು ಬರ್ತಿಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ.
I will check with the senior, my lord. As I instructed, she is alive. And today she is not available to come to court.
The further submission made, the proposal that was thought of was if appellant would get 50% and respondent number 6 would agree for 50%, whether she is agreeable for this proposal as a settlement.
I will check.
On that point also, you have to get instruction.
Yes. Will check.
ಇಲ್ಲ ಇದನ್ನ ಕಾಸ್ಟ್ ರೇಟ್ ಎಲ್ಲ ಅಮೆಂಡ್ ಮಾಡಿ
ಫಸ್ಟ್ ರೆಸ್ಪಾಂಡೆಂಟ್, my lord, husband.
ಫಸ್ಟ್ ರೆಸ್ಪಾಂಡೆಂಟ್ ಇದು ಅದ್ರ ಬಗ್ಗೆ ಅಲ್ಲ. ಆಯ್ತು. Both counsel submit that respondent. Counsel for respondent 6 seeks time to keep respondent 6 present. Both counsel for the appellant proposes for a settlement. Counsel for respondent number 6 seeks time to take instruction in the matter. ಇದು 2016
Yes, ma'am.
Serve the copies on advocate for R4. ಏನದು ಯಾವ ಕಾಪಿ ಸರ್ವ್ ಮಾಡ್ಬೇಕಿತ್ತು? R4 ಪ್ರಶಾಂತ್ ಪಂಡಿತ್. ಇದಾರ ಅವ್ರಿಲ್ಲ. ನೀವ್ಯಾರು ರಿಪ್ರೆಸೆಂಟ್?
I represent notes R2, R3 and R5.
Padmavat. Non-filing of response to memo along with documents filed by advocate R2, 3 and 5. ನೀವೇನ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಹಾಕಿದಿರಿ?
Minutes, we have produced the service nomination along with the memo. Yes. Nomination is in name of my lords, the
Respondent number 6.
respondent number 6.
KPTCL ನವರಲ್ಲ?
ಹೌದು.
ಎಸ್ ಇದೇನು ರೆಸ್ಪಾನ್ಸ್ ಹಾಕಿಲ್ಲ ಅಂತ ಇದೆ ಅಲ್ಲ. They also admit that she was shown as the nominee.
It is admitted.
ರೆಕಾರ್ಡ್ ಮಾಡಿದ್ರಿ ಇದೊಂದೆಲ್ಲ ಆಗ್ಲಲ್ಲ.
ಹಾ.
Now counsel for the appellant considers that in the service records of deceased respondent number 1, respondent number 6 was shown as a nominee.
Yes, ma'am.
Nominee, therefore office objection number 4. An office note regarding the same does not survive. Okay. An office note regarding the memo filed by counsel for response 2, 3 and 5 does not survive for further consideration. Copies, learned counsel for the appellant submits that the copies are served on R4. Counsel for R4, office objection in that regard also should comply. ಆಯ್ತು. ಏನಾಗ್ಬೇಕು ಹೇಳಿ ಈಗ ಮುಂದೆ ಸೆಟಲ್ಮೆಂಟ್ ಮಾಡ್ಕೊಂಡು ಹೇಳ್ತೀರಾ?
I will check regarding this thing as I am not instructed.
ಲಿಸ್ಟ್ ಆನ್ ಅದು ಮೊದಲೇ ಬರ್ದಿದ್ವಿ. ಇಲ್ಲಾಂದ್ರೆ ಕಂಪ್ಲೈನ್ಸ್ ಎಲ್ಲ ಮೊದಲು ಹಾಕೊಂಡು ಸೀಕ್ಸ್ ಟೈಮ್ ಟು ಟೇಕ್ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ ಅಂತ ಇದ್ದಾರೆ, ಅದನ್ನ ಕೊನೆಗೆ ಹಾಕೊಂಡು ಲಿಸ್ಟ್ ಆನ್ ಅಂತ.
Next week.
To report settlement, if any, list on
6-2.
6.
Please. Ajay.
Section 19, no, exercising under 120. ನಾವ್ ಯಾವ ಜಡ್ಜ್ಮೆಂಟ್ ಅಲ್ಲಿ ಮಾಡಿದ್ವಿ ನೆನಪಿದೆಯಾ? ಒಂದು ಜಡ್ಜ್ಮೆಂಟ್ ಫ್ಯಾಮಿಲಿ ಕೋರ್ಟ್ಸ್ ಆಕ್ಟ್ ಕೆಳಗಡೆನೆ ರೂಲ್ಸ್ ಮಾಡಿದ್ದಾರೆ, ಕನ್ಸಿಲೇಷನ್ ರೂಲ್ಸ್ ಅದರಲ್ಲಿ ಇದ್ದಾರೆ. ನಾನು ಲಾ ಕ್ಲರ್ಕ್ ಆಗಿರ್ತೀನಿ. ದೀಸ್ ಆರ್ ಮೀಡಿಯೇಷನ್ ಸಲುವಾಗಿರೋದು. ಇಲ್ಲ, ಇದು ಮೀಡಿಯೇಷನ್ ರೂಲ್ಸ್. ಮೇಡಮ್ ಫ್ಯಾಮಿಲಿ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಜಾಸ್ತಿ ಪ್ರಾಕ್ಟೀಸ್ ಮಾಡ್ತಾರೆ. ಒಂದು ದಟ್ ಸೆಕ್ಷನ್ 9 ಕೆಳಗಡೆ ರೂಲ್ಸ್ ಮಾಡಿದ್ದಾರೆ about confidentiality of conciliation proceedings, that shall not be taken in, that shall not be brought into judgment ಅನ್ನೋದ್ರ ಬಗ್ಗೆ are you aware?
ಅದು ರೂಲ್ ಇದ್ದೇ ಇದೆ ಇದರಿಂದ ಮೀಡಿಯೇಷನ್ ನಲ್ಲಿ.
I think it is framed under section 9 of the
section 9 of the
family court.
Family court
Act. ಏನು ನೋಡ ನಿಮ್ಗೆ ಗೊತ್ತಿದ್ರೆ ಅಂತ ಕೇಳಿದ್ವಿ ನಾವು. ನಾವು ಹಿಂದೆ ಯಾವ್ದೋ ಒಂದು ಜಡ್ಜ್ಮೆಂಟ್ ಅಲ್ಲಿ ನೋಡೋಣ, ಇದು ಇಟ್ಕೊಂಡಿರಿ. ನಮ್ಮಿಬ್ರು ಪರ್ಸನಲ್ ಸೆಕ್ರೆಟರೀಸ್ ಅವ್ರು ಕೇಳೋದು ನೋಡೋಣ ಯಾವ ಜಡ್ಜ್ಮೆಂಟ್ ಅಲ್ಲಿ ಮಾಡಿದ್ರು. ಲಕ್ಷ್ಮಿ ಸರಿ. ಎಸ್ ನಿಮ್ದೇನಿತ್ತು?
ನೆಕ್ಸ್ಟ್ ಮ್ಯಾಟರ್
Yes.
Oh my.
Srimati, Seal number
But
46.
then we'll take up in the afternoon.
Yes.
Yes.
If your lordship kindly, my lord, serial number 47, my lord, kindly
Yes.
have this matter next week.
Yes. Yaar other side are.
I might be for
Yaar if you're.
appellant in this matter,
Huh.
first matter.
It's a case of injury, my lord.
You are ready or not ready?
ಇಲ್ಲ ಅದರಲ್ಲಿ ನಿನ್ನೆ ಒಂದು ಡಾಕ್ಯುಮೆಂಟ್ ಹಾಕಿದ್ದೆ ಇವನ್ ಥರ್ಡ್ ಕಾಪಿ ಟು
ನಮಗೆ ಕಾಪಿ ಕೊಟ್ಟಿಲ್ಲ ಅವ್ರೇನು.
ಪುಟ್ ಅಪ್ ಆಗಿಲ್ಲ ಅಲ್ವಾ ಲಾಸ್ಟ್ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಏನಿದೆ
As requested by both sides. List on. ಏನ್ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದೀರಾ?
ಅಪ್ಲಿಕೇಶನ್ ಅಡಿಷನಲ್ ಡಾಕ್ಯುಮೆಂಟ್ ಅದು ಟ್ರಯಲ್ ಕೊಟ್ಟು ನಮ್ದು 2,98,000 ನೀವು ಇದ್ರ
ಆಯ್ತು ಅದೇನೋ ಆಮೇಲೆ
ಕಂಪ್ಯೂಟರ್ ಜನರೇಟೆಡ್
ಲಿಸ್ಟ್ ಆನ್ 13. ಸರಿ.
ಹಾ. Received from pending transfer. ಇಲ್ಲಾಂದ್ರೆ ಅವ್ರಿಗೆ ವಾಪಸ್ ಕರ್ಬಿಟ್ಟು ಕೊಟ್ಬಿಡೋಣ. ಇದು ಅರ್ಜೆಂಟ್ ಆಯ್ತು ಅಂತ. Three two ಅಲ್ಲ 4-2 ಅದು. 4-2. ಬಿ ಫೈಲ್ ನೋಡಿ ಇಲ್ಲೇ ಇಟ್ಟು ಏನ್ ಬೇಕು ಮಾಡಿ ಸರ್?
ಅದೇ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ದಾರೆ ನಾವು ಅದ್ರ ಮೇಲೆ ರಿಮಾಂಡ್ ಆಯ್ತಲ್ಲ ಆದ್ರೆ ನಿಮ್ಮ ಫೈಲ್ ಅಲ್ಲಿ ಇರುತ್ತೆ ಮೈನ್ ಫೈಲ್ ಹಂಗೆ ನೋಡು
ಕೊಟ್ಟೆ ಅಪೀಲ್ ಮೆಮೊ ಮಾತ್ರ ಕೊಡ್ತೀನಿ ಕೊಡಪ್ಪ. TCR ಕೆಬ್ಬಿನ ಹಾಕಿದಿಲ್ಲ ಏನಪ್ಪ 63 ಅಲ್ಲ ಈ ಸೆಕ್ಷನ್ ಫ್ಯಾಮಿಲಿ ಕೋರ್ಟ್ ಕೆಳಗಡೆ ಮೀಡಿಯೇಷನ್ ರೂಲ್ಸ್ ಅಂಡರ್ ಸೆಕ್ಷನ್ 9 ಆಫ್ ದಿ ಫ್ಯಾಮಿಲಿ ಕೋರ್ಟ್ ಆಕ್ಟ್ ಮಾಡಿದಾರಂತೆ ಅಂತ ಮೇಡಮ್ ಹೇಳ್ತಿದ್ದಾರೆ. ಅದೆಲ್ಲ ಇನ್ನೂ ಒಂದು ಬರ್ತಾರೆ ಫ್ಯಾಮಿಲಿ ಕೋರ್ಟ್ ಅಂತಾನೆ ಮಾಡಿದ್ದಾರೆ ಬಟ್ ಈ ಲೈಬ್ರರಿ
Anything more than
ಏನ್ ಫೈಲ್ ಆದ್ರೆ ಅವ್ರು ಏನ್ ಯಾವ್ದು ಇಲ್ಲ ಅಂತಿದ್ದಾರೆ ಬಟ್ ಮೇಡಮ್ ಮಾಡಿದೆ ಅಂತ ಮಾಡಿದ್ದೀನಿ. ಮೀಡಿಯೇಷನ್ ಫ್ಯಾಮಿಲಿ ಕೋರ್ಟ್ ಆಕ್ಟ್ ಕೆಳಗಡೆನೆ ಮಾಡಿದ್ದಾರೆ ಅಂತ ಟ್ರೈ ಮಾಡಿದ್ದಾರೆ ಅಂದ್ರೆ ಕಾನ್ಫಿಡೆನ್ಶಿಯಲ್ ಮೇಂಟೈನ್ ಮಾಡ್ತಾರೆ ಅಂತ ಎಲ್ಲ ಇದ್ದಾರೆ ಪ್ಲೀಸ್ ನೋಡಿ ಅದು ವಿಶ್ವ 25ಕ್ಕೆ ನಾಳೆಗೆ ಬಂತು. ಅಯ್ಯೋ ನಾವು ಇವಾಗ್ಲಿಕ್ಕೆ ಅಂತ ದುಡ್ಡು ಇವಾಗ್ಲೇ ಕೊಟ್ಟಿದ್ದಾರೆ ಇದೊಂದು ಅಂತಲ್ಲ, ಡೇಟೇ ನೋಡ್ಲಿಲ್ಲ ಗುಬ್ಬೆಗಳ ತರ. ಈಗ ಯಾಕೆ ಕಳಿಸ್ತಾ ವಿಷಯ ಅಂತ. ಯಾಕೆ ರಿಸರ್ವ್ ಆಗಿಲ್ಲ ಅಂತ ತೋರಿಸ್ತಾ ಇದೆಯಂತೆ. ಗೋವಿಂದರಾಜ್ ಕಂಪ್ಯೂಟರ್ ಅಲ್ಲಿ ರಿಸರ್ವ್ ಆಗಿಲ್ಲ ಅಂತ ಬರ್ತಾ ಇದೆ ಅಂತ ಅಂದ. ಇಷ್ಟು 20ನೇ ತಾರೀಕು ಅವ್ರದೆಲ್ಲ ನೋಡಪ್ಪ. ಇವ್ರದೊಂದ್ ಸ್ವಲ್ಪ ಅದೇ ಏನ್ ಗೊತ್ತಾ, ಸ್ವಲ್ಪ ಕಡಿಮೆ ಇತ್ತು ಅಂದ್ರೆ ತರ್ಸ್ಕೊಂಡು ಏನ್ ಮಾಡಕ್ಕಾಗಲ್ಲ. ಅವ್ರ ಏನ್ ಗೊತ್ತಾ, ಈಗ ನನ್ನ ಕೊಡ್ತಿದ್ದಾರೆ ಮೇಡಮ್, ಅದಕ್ಕೆ ಇವರು ನಾವೇ ಬೇಡ ಅಂತ ಹೇಳಿದ್ದೀರಾ ಅಂತ ನೀನ್ ಅದಕ್ಕೆ ಹೇಳ್ದೆ. ನಾನು 2 ಸೆಷನ್ ನಾನೇ ನನ್ಗೆ ಗೊತ್ತಿದೆ, 2 ಸೆಷನ್ ಕೊಟ್ರೆ ಬರೀ ಇದನ್ನಷ್ಟೇ ಅವ್ರ ಎಸ್ಒನೇ ಹೇಳಿದಾರೆ ನನ್ಗೆ. ಬೇಕಾ ಬರೀ ಈ ತರ ಲಿಸ್ಟ್ ಕೊಟ್ರೆ ಲಿಸ್ಟ್ ಅಷ್ಟೇ ತೆಗಿಯೋದು ಪದ್ಮ, ಇನ್ ಬೇರೆ ಯಾರು ತೆಗಿತಿಲ್ಲ. ನಾನು ಅದಕ್ಕೆ ಹೇಳ್ದೆ, ನಾನೇ ಹೇಳ್ತೀನಿ ಇಷ್ಟ ಇದನ್ನ ಅಂತ ಕರ್ಕೊಂಡು ಹಾಕಿ ಏನೋ ಮಾಡ್ತಾರೆ. ಬಂದಿಲ್ಲ ಅಂತ ಹೇಳಿದ ಅಂದ್ರೆ ಬ್ರಾಂಚ್ ಅವರೇ ಕಳ್ಸಿಲ್ವಾ ಡಿಗ್ರಿ ಬ್ರಾಂಚ್ಗೆ. connected with double 7 money of
ಇವತ್ತ ಕೊಟ್ಬಿಟ್ರಲ್ಲ ಡೇಟ್ ನೋಡ್ಲಿಲ್ಲ. ಯಾಕೆ ಇವತ್ತು ಬಾರ್ಡರ್ ಕೊಟ್ಟಾಗ ಅವ್ರೆ
ಅದ್ರೊಳಗಡೆ ರಿಸರ್ವ್ ಆಗಿಲ್ಲ ಅದು ಅಂತ ತೋರಿಸ್ತಾ ಇದೆ ಅಂತ ಅವನು. ಇಲ್ಲ ರಿಸರ್ವ್ ನಾನು ಹಂಗೂ ಕನ್ಫರ್ಮೇಶನ್ಗೆ ಚೇಂಬರ್ಗೂ ಕೇಳಿದೆ ಮೇಡಮ್ ಅಂತ ಅಂದ್ರೆ. ಯಾವ್ದು ಗೊತ್ತಾ ಇದು? ನೋಡ್ತೀನಿ. ಅಲ್ಲ ನಾಳೆ ಕನ್ಸಿಲೇಷನ್ ಇದೆ, ನಾಳೆಗೆ ಯಾಕೆ ಹಾಕಿದ್ರು? 225 ಗೆನೆ ಇದೆ. ಶುಕ್ರವಾರ ಇಲ್ಲ.
ಇದು ಪ್ರಭು ಇಷ್ಟ ಅಲ್ಲ.
Finally, 10 days to comply. Order dated 21/3/24. Failing which appeal stands. ಅದೇನೋ ಮೆಮೊ ಕೊಟ್ನಲ್ಲ. Mhm. 19 to the post along with ಹೇಳಿದ್ವಿ. ಅದಕ್ಕೆ 19. ಅವ್ನು ಮಧ್ಯಾಹ್ನ ಹಾಫ್ ಡೇ ರಜಾ ಅಂತ ಅಂದ್ರು. ಏನೋ ಬ್ಯಾಂಕ್ ಏನೋ ಪ್ರಾಬ್ಲಮ್ ಅವಾಗಿಂದ ಮಧ್ಯ ಬೆಳಗ್ಗೆನೇ ಹೋಗಿದ್ವಿ. ಓದಾಡ್ತಾನೆ ಅಂತ ಕರೆಕ್ಟ್ ಕ್ಲಿಯರ್ ಆಗಿ ಹೇಳಿದ್ರು. ಬ್ಯಾಂಕ್ ಪ್ರಾಬ್ಲಮ್ For pronouncement of order, seal number 1, Annamala, yes.
Review petition is dismissed.
For admission, seal number 2, Shatabish Shivanna, Archana KM.
I appear for the respondent's counsel.
Yes, you represent the petitioner.
My lords, I represent the petitioners.
Yes.
My lords, due to some urgent circumstance, my lords, I am physically in Delhi today. My lords, if your lordships can kindly post the matter tomorrow or day after. Day after, my lords, I'll be physically present before your lordships, my lords.
No, see, you know now the time constraint.
I understand, my lords, and I'm.
Then how is that? You can argue from there only. What is your point?
It is also a special order, my lords, by which this bench is constituted. I'm cognizant of that. I'll be there physically, my lords, day after tomorrow, if your lordships
You
can
can
kindly
argue
post.
from there only. What is your ground of review?
My lords, I don't even have my file, my lords, at the moment. Due to some immediate urgency, I had to fly to Delhi, my lords. Otherwise, I would physically be present. I've never missed a date, my lords, before your lordships.
Now we are left with 2 days.
Please, I'll argue the matter on day after, my lords. Day after morning, first thing I will be physically
Thereafter,
present.
not possible at all. Otherwise, we'll dismiss it for non-prosecution.
No, my lords, it is my humble request, my lords.
Pronouncement. Tomorrow we have some other pronouncement matters. You have to make it convenient to argue tomorrow.
My lords, I am actually back tomorrow evening, afternoon.
Correct, you ask some of your colleagues to do that. Otherwise, Shatavisha Sivan, he is Shatavisha Sivan.
I am Shatabish Shivanna, my lords. I'm the only person on record. Your lordships could kindly take it up first thing day after tomorrow, my lords.
In fact, if your lordship were to permit me, in para 24 and 25 of the judgment, the court has held the suit is not maintainable. That he has not challenged in review petition at all. He has not taken any ground. Para 24 and 25 of the judgment, it clearly says the suit is not maintainable.
Was
He has
not
not challenged
urged
that.
by the defendant. In fact, he waived
The
off
suit
that
is
right
not
before the-
maintainable. Where is the review petition?
Let's see. As a final chance, we are going to list it tomorrow because we have another special bench.
Please,
We
my
cannot
lords-
afford to give you any more opportunity than that.
My
You
lords-
want to argue tomorrow, you can argue. Otherwise, we'll dismiss it for non-prosecution.
My lords,
Vice is yours.
my humble request, my lords, if it is taken up day after morning, I will physically be present before your lordships, my lords.
31st is 31st is afternoon. We'll be having program.
Not 31st, my lords, the 30th. 30th is the Thursday. my lords.
Special
The last occasion, my lords, tavu papa 25th happana andre. They took a date 25th beda anta 27th ಹೇಳಿದ್ರಿ 27th ಇರಲ್ಲ
Lords,
ಅಂದ್ರು.
I understand it was a date that was fixed at my request.
ಅವ್ರನ್ನ ಕೇಳ್ಬಿಟ್ರೆ 28th ಕೊಟ್ಟಿದ್ರು.
ನೀವು ಆರ್ಗ್ಯೂ ಮಾಡಿದ್ರು ಮಾಡದೇ ಇದ್ರು tomorrow we are going to dispose it.
My lords, kindly have it, my lords, on the day after morning, my lords. It's 30th morning. I will physically be present.
Adjournment.
ನಾಳೆಗೆ ಪೇಪರ್ ಎಲ್ಲ ತರಿಸ್ಕೊಂಡು ರೆಡಿ ಆಗಿ ನಾಳೆ ಸಬ್ಮಿಷನ್ ಮಾಡಿ.
Now everything goes digital. You get the papers there only.
Please, my lords. I'll try to physically be present.
No question of trying. We are telling.
I will be there, my lords.
Very
I'll be
clear that tomorrow, if you do not argue,
We will dispose of the review on merits.
Please.
We'll take it as you have been heard.
I'll make arrangements to physically be present tomorrow morning.
We'll parent the grounds from urged in the review.
admission, we can do that
No,
also.
no,
But,
I wouldn't, it would.
And seeks adjournment. At his request only, today the matter was fixed. As a final chance, list tomorrow at 2:30 ನಮ್ಗೆ ಇನ್ನೊಂದಿದೆ. 220 ಕೊಟ್ಟಿದ್ದೀವಿ ನಾವು.
25.
ಕೊಟ್ಟಿದ್ದೀವಿ, ಅದು ಮುಗಿದ ತಕ್ಷಣ
Yeah,
225. Could it be at 2:30, my lords?
At 225.
2:25.
Tomorrow,
Much-
because we have some other special bench matters. tomorrow.
Obliged.
See, others are waiting. ಕೂತ್ಕೊಂಡಿವ್ರು.
No, no, I understand, my lords. I am deeply apologetic.
ಇದು ಕಾಲೇಜ್ ಬೇಕಾ ತಗೊಂಡೋಗು.
NC generate ಮಾಡಿದ್ರಾ ನೀವು? ಆಮೇಲೆ NC generate ಇಲ್ಲಿ update
ಇದನ್ನ
ಇಲ್ಲಿ QR ಕೋಡ್ ಎಲ್ಲ ಬರುತ್ತಲ್ಲ.
ಇರ್ಲಿ ಬಿಡ.
ವೈಟ್ ಶೀಟ್ ಅಲ್ಲಿ ತರ್ಬೇಕಾ? ನಾಳೆದೆಲ್ಲ ಹಂಗೆ ಮಾಡಿ ಆಮೇಲೆ
ನಾಳೆಗೆ 2:25.
ಇದು ಇವಾಗ ಇವ್ರು ಹೆಂಗಿದ್ರು ಇದಾರೆ ಎಲ್ಲ
ಹೋಗ್ಬೇಕು ಮೇಡಮ್.
ನಾಳೆಗೆ ಇದು ಬೋರ್ಡ್ ಹೋಗ್ಬೇಕು.
ಅದಿಲ್ಲ ಅಂದ್ರೆ ಸ್ಕ್ಯಾನ್ ಆಗಲ್ಲ. ಈಗ ಮತ್ತೆ ಇವಾಗ ಸಾಹೇಬ್ರಲ್ಲಿ ರಿಟರ್ನ್ ಆಗಿ ಹೋಗಿ ಅಂದ್ರೆ ಮತ್ತೆ ಅದು ಪ್ರಾಬ್ಲಮ್ ಆಗ್ತಿತ್ತು ಆಮೇಲೆ ವಾಪಸ್ ಮಾಡ್ತೀವಿ.
ಬಟ್ ಆ ಡೇಟಿಗೆ ಇರುತ್ತಲ್ವಾ?
ಡೇಟ್ ಹೋಗ್ತಿಲ್ಲ, ಬಟ್ ಅದೇ ಫೈಲ್ ಎಲ್ಲ ಕೊಟ್ಟು ಕಳಿಸಿ ಮತ್ತೆ ಮಾಡಿ
ಹೋಮ್ ಆಫೀಸಿಗೆ ಕಳಿಸ್ಬೇಕು. ನೋಡೋಣ, ಪುಟಪ್ಪಗಂತದ್ದೇನಿಲ್ಲ ಅಲ್ವಾ? ಹಾಗಾದ್ರೆ ನೀನೇನೆ ಆರ್ಡರ್ ಶೀಟ್ ಸೇರಿಸ್ಬಿಡೋಣ ಅಂತ ಸೇರಿಸ್ಬಿಟ್ಟು 10049.
ಪ್ರಿಪ್ರೇಷನ್ ಒಂದು ಹೆಲ್ಪ್ ಮಾಡಬೇಕು. ನಾವು ಒಂದು ಅಡ್ವೊಕೇಟ್ ನೇಮ್ ತರ್ತೀನಿ.
ಅದು ಇರೋ ನಾನೇ ಹೇಳ್ತೀನಿ ಒಂದು ನಿಮಿಷ.
ಹೆಂಗೋ ಗೊತ್ತಿಲ್ಲ, ನನ್ನ ಫೋನ್ ನಂಬರ್ ತಗೊಂಡಿದ್ದೀನಿ.
ಏನ್ ಗೊತ್ತಾ, ಕೆ ವಾಣಿ ಅಂತ ತಿಪ್ಪೇಶಿ, ಆದ್ರೆ ಆ ಎಮ್ಮಂದು ಇದ್ರೊಳಗಡೆ ಇಲ್ಲ, ಇದ್ರೊಳಗೆ ಎನ್ರೋಲ್ ಆಗಿಲ್ಲ, ಬೋರ್ಡ್ ಬ್ರಾಂಚ್ ಅಲ್ಲಿ ಇಲ್ಲ. ಅಸೋಸಿಯೇಷನ್ ಅಲ್ಲಿ ಸಿಗ್ಬೋದೇನೋ ನೋಡೋಣ. ಇಲ್ಲಾಂದ್ರೆ ಇಲ್ಲಿ ಫೈಲ್ ಬಂದಿತ್ತು, ಆ ಫೈಲ್ ಒಳಗಡೆ ಇಲ್ಲ, ಒಳಗಡೆನೆ ಇದೆ. ನೋಡೋಣ, ಆಮೇಲೆ ನೋಡ್ತೀನಿ. ಇವ್ರ ಬೇರೆ ಹೇಳಿದ್ರು ಯಾವ್ದು ಮಾಡಿಲ್ಲ, ಯಾವ್ದು ಮೇಡಮ್ ಹುಡುಕಿ ಎಲ್ಲರಿಗೂ ಕಣ್ಣೂರು ಬಂದಿತ್ತು, ಮೊನ್ನೆ 5 ಗಂಟೆ ಅದು ಫೋನ್ ನಂಬರ್ ಬೇಕು. ಬಂದ್ರು ಕೊಡಕ್ಕ ಅವ್ರಿಗೆ. ಬೇಡ ಅದು ನಾನು ಫಸ್ಟ್ ನಾನೇ ಬರ್ಕೊಂಬಿಟ್ಟಿದ್ದೆ.
ಅದು ಮೇನ್ ಮ್ಯಾಟರ್ ವಾಸ್ ಫಿಕ್ಸ್ ಇದೆ ಅಂತ ಹೇಳಿದ್ರು, ಮಿಸ್ಟೇಕ್ ಇದೆ ಅಂತ. ಅದು ಫಿಕ್ಸ್ ಮಾಡಬೇಕು. Regarding speaking documents. Mediation. You didn't get that. ಅವೊಂದು 15 ಅಂತ ಯಾಕೆ ಮಾಡಿದ್ದಾರೆ ಅಲ್ಲಿ? ಅದದ್ದು ನೋಟಿಸ್ ಅದೇ ಕಮಿಷನ್ ನೋಟಿಸ್ ಮಾಡಿದ್ದಾರೆ. ಕೋರ್ಟ್ ಆಫ್ ಹೈಕೋರ್ಟ್ ಎಲ್ಲ ನಮ್ಮ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಅದಿದೆ ನೋಡಿದ್ವಿ. ಆ 2 ಫೋಟೋ ಅದಕ್ಕೆ ರಿಜಿಸ್ಟರ್ ಆಗಿ ಇದು ಮಾಡಿದ್ರು.
Anything relevant in this?
Yes, yes. Good. Passport matter, bill number 24, Vilas Rangnath Tata, Vijay A.M.
2 applications they had already passed order, 2 applications. And that shall be heard along with the main matter. Yes, 1 and 3 shall be heard along with the main matter anta madidvi. I2 is to bring subsequent events anta ಹೇಳಿದ್ರು. I2 Yes, A2. What is that subsequent event you want to bring on record? Yes, what is that subsequent event you want to bring on record? So you want to produce this compromise proposal?
The mediator.
Hmm.
The mediator did not accept it. And therefore, I'm producing it, what exactly we had in mind to be, involve the other side, and the mediator.
What was in your mind? No, this was your proposal, no? So it was not accepted by the mediator.
Yes.
So what can we do now?
No, I just,
Mediation. Supreme Court judgment ಕೊಟ್ರಲ್ಲ ಅವರು ಇದನ್ನು ಹೇಳಿ orders on number 2 of 2024. Under this application,
I say that I mean, so appellant appeal.
the appellant is.
I say that the appellant appeal may be put the order.
Is that we've read it? We've read it.
Not for the
Again, only that context, my lord, because the proposal on their side was exhausted.
the application is filed perpetually produce essentially to produce the proposal for compromise suggested by the appellant to the respondent before the mediator. It is contended that the said document is a subsequent event which contained certain proposals and counter proposals allegedly made by the parties. Okay. Now, counsel for the respondent opposes the application on the ground that any discussions or proposals made during the mediation it cannot be brought in the form of evidence. In support of his submissions, he relies on the judgment of the Honorable Supreme Court in Ashok Motiram versus Ashok Kumar and another.
So that my submission is that it is not applicable to the facts of this case, my lord. So that is a different context. Because under these, see,
And mediation rules illa ide. Mediation rules. Correct. Kodi.
Reported in 2011, 1 SCC, page 466. The order on 31st April 2010, he had referred the matter from mediation to mediation center at
Same judgment. ಇದು ಒಂದೇ judgment ಅಲ್ವಾ? ಮೋತಿರಾಮ್ versus ಅಶೋಕ್ ಕುಮಾರ್.
Reported tonight. In connection, you would like to say that mediation proceedings are totally confidential proceedings. This is unlike proceedings in court, which are conducted openly in public case. If the mediation succeeds, then the mediator should send agreement signed by both the parties to the court without considering what transpired during the mediation proceeding. If the mediation is unsuccessful, then the mediator should only write one sentence in the report and send it to the court stating that the mediation has been unsuccessful. Beyond that, the mediator should not write anything which was discussed, proposed or done during the mediation proceeding. This is because the mediation very often offers counter offers and proposals are made by the parties, but until and unless the parties reach an agreement signed by them, it will not amount to concluded contract. If the happening of the mediation proceeding that is closed, it will destroy the confidence in the mediation process. What we are submitting was only to the mediator and also to the other side. So that could have been taken as a confidential.
So you are also relying on the same judgment, no?
It is a confidential matter. They are not disclosing it.
2011, 1 SCC 466. In para 2 of the judgment in Modira's case, referred to Supra, the Honorable Supreme Court has held that proposal and counter proposal. The offers and counter offers and proposals made by the parties during the mediation until and unless parties reach to an agreement signed by them, will not amount to any concluded contract. It was further held that if the proceedings in mediation are confidential one, and if the divulging the same in the proceedings amounts to destruction of confidentiality of the mediation process. In the right of state judgment, I-2 of 2014, in the I-2 of 2014, whereunder a request is being made to the court to consider proposal and counter proposal, which was not signed by both the parties, is contrary to the aforesaid judgment in Motiram's case. Therefore, the application is liable to be dismissed and dismissed accordingly. Yes.
The next amendment which I am trying to bring about.
Amendment, we said both of them have to be heard along with the main matter. In how the original. See, we have already passed the judgment that they have to be heard along with the main matter. Yes.
Respect to the submission. He has not filed any.
Correct. See, that you have to argue at the, I'll arguing the merits. Okay. If we find that there is a ground to grant permission to amend, we'll amend and then the proceedings, based on that, the proceeding. Admit ಆಗಿತ್ತಲ್ಲ list for final hearing on yes. ಏನ್ ನಿಮಗೆ ಏನು ಅರ್ಜೆಂಟ್ ಇಲ್ವಲ್ಲ ಮಾರ್ಚ್ ಅಂತ ಕೇಳ್ತಾ ಇದ್ದಾರೆ
ಆಗ್ಬೋದು
20th March.
20. ಅದು ನಾವು ನೋಡಿದ್ವಿ. I don't remember. We don't remember whether we had referred to mediation rules only because judgment ಬಿಟ್ಟು ಇದಕ್ಕೆ mediation rule 20 ಅಲ್ಲಿ ಇದೆ ನೋಡಿ, confidentiality and it is inadmissible ಅಂತ ಇದೆ.
Proposal which was given was to be.
To divulge the information.
Confidential, please, madam. This would remain with the mediation.
Parties shall maintain confidentiality in respect of events that transpired during mediation and shall not rely or introduce the said. 22(4). Yes, stenographer adding.
It says, receipt of revision of the preparation of records, reports, or other documents by mediator. So this could have been also been other documents, which could have been accepted. In 20.
Shall not rely on. ಇದು ಅದನ್ನೊಂದು ಬರ್ಕೊಂಡ್ಬಿಟ್ಟಿದ್ರಲ್ಲಿ ರೂಲ್ 24 clause.
Three, I have got 3. When it says receipt of revision of preparation of records, reports, or other documents by mediator.
24 ಅಷ್ಟೇ ಬರ್ಕೊಂಡ್ಬಿಟ್ಟಿದ್ವಿ. Bars the court from court and parties from relying on or introducing the information which is divulged during the mediation proceedings in the proceedings before the court. Okay.
24.
Rule 24 of Karnataka Civil Civil Procedure Mediation Rules 2005. Yes.
For final hearing, cell number 46, Bhushni Kumar, O Mahesh.
ಇಲ್ಲ ಅವರೇನೋ ಡಾಕ್ಯುಮೆಂಟ್ ಕೊಡೋದಕ್ಕೆ ಕರೆಕ್ಟ್ ನಾನು ಚೇಂಬರ್ ಅಲ್ಲಿ ಹೇಳ್ತೀನಿ ಮತ್ತೆ ಸೀರಿಯಲ್ ನಂಬರ್ 46 ಓ ಮಹೇಶ್ ಎಸ್
O Mahesh, cell number 46.
ಆಯ್ತು.
Yes,
You can proceed.
I'm ready.
Yes. Yes.
Time for responding.
All right, we are hearing the other side now. Yes.
Yes.
You can just, madam, you can take that mic. Speaker on the other.
And we passed away after 2 months. That's on 15/5/2014. The
Data.
accident took place on 14/3/2014. And he died on 15/5/2014.
15?
5/2014.
Hmm. Yes.
The claimants are the wife and the father of the
Yes.
deceased.
Hmm.
The Honorable Tribunal was pleased to award a sum of rupees 16,62,747.
Yes.
Aggrieved by the insufficiency of the award, I have preferred this. That's one of the grounds. The other ground is that liability is fastened on the owner of the
Yes.
vehicle. Medical expenses they have awarded as per the medical records, that is 10,63,747, my lord.
Hmm.
Under other heads, they have awarded 25,000 towards transportation of dead body and funeral and obsequies. Love and affection 30,000, loss of estate 30,000, and loss of consortium 1 lakh, and loss of dependency 4,14,000, taking the income of the deceased as 5,000 when he was an income tax assessee, and taking the multiplier. Yes, my lord.
5,000 per month.
Yes, my lord. 5,000 per month.
Age?
Age, he was age 57 years.
There is no dispute about that.
About all those things, there is no dispute at all. And he was working as a real estate agent. And the income tax return show of 2013 to 2014 that he was earning 2,30,280.
Exhibit income tax return is exhibit 23. You have submitted only one income tax return.
Yes, only one has been produced, my lord.
It was submitted after accident or before?
This
Accident
is
was-
for the year 2013 to 2014. He passed away in 2014. That is 14/3 he met with an accident.
P23.
Yes, ma'am.
P23 IT returns.
Hmm.
Returns for 2000 assessment year 2013-14.
13/14, ma'am. The court has not considered this.
Submitted on.
At page 25 of the judgment, paragraph.
2013-14 ಅಲ್ಲಿ ಕೊಡ್ಬೇಕಲ್ಲ ಅಸೆಸ್ಮೆಂಟ್ ಇಯರ್ 2013-14 2000
That is previous year. He passed away in 24.
ಫೈನಾನ್ಷಿಯಲ್ ಇಯರ್ ಯಾವ್ದು ಇದರಲ್ಲಿ?
ಹೌದು.
ಫೈನಾನ್ಷಿಯಲ್ ಇಯರ್ ಫೋರ್ಟೀನ್ ಅಲ್ಲಿ ಸಬ್ಮಿಟ್ ಮಾಡ್ತಾರೆ. 14 ಅಲ್ಲಿ ಸಬ್ಮಿಟ್ ಮಾಡ್ತಾರೆ ಆ ಫೈನಾನ್ಷಿಯಲ್ ಇಯರ್ ಅಲ್ಲಿ.
When was exhibit 223 filed?
That
No, when it was filed, because on this there is a date is 31/7/2013. It says it is for assessment year 2013-14. 2013-14 is 2013 ಅಲ್ಲೇ ಹೇಗೆ ಫೈಲ್ ಮಾಡಕ್ ಸಾಧ್ಯ ಆಗುತ್ತೆ? And bank statements or any other record is produced in proof of his income. Previous year statements are not filed.
Yes, all those things are not filed, my lord. Even in this, the court has considered that he was getting interest and
2014 notional income ಎಷ್ಟಿತ್ತು? 8,500. 57 ಅಂದ್ರೆ ಫ್ಯೂಚರ್ ಪ್ರಾಸ್ಪೆಕ್ಟ್ಸ್ ಬರುತ್ತಾ?
8,500 ಬರುತ್ತೆ.
8,500, 57 years ಗೆ ಫ್ಯೂಚರ್ ಪ್ರಾಸ್ಪೆಕ್ಟ್ಸ್
ಬರುತ್ತೆ 10% ಬರುತ್ತೆ.
ಎಷ್ಟು 50 to 60, 10% ಬರುತ್ತೆ.
10% ಬರುತ್ತೆ.
So 8,500 plus.
Plus 850.
9350.
9350, ಡಿಪೆಂಡೆನ್ಸ್ ಎಷ್ಟು?
ಇಬ್ರು.
How they are related?
Wife and father.
His father.
His father.
Okay, 88 ಅಂತ. ಅಂದ್ರೆ 2 ಡಿಪೆಂಡೆನ್ಸ್ ಅಂದ್ರೆ
1/3.
So ಇದ್ರ 2/3 ಎಷ್ಟಾಗುತ್ತೆ ನೋಡಿ?
6,233.
Annually madam. 9,350 probably may not be taxable. ಇದು ಮಾಡಿ ನೋಡೋಣ, ಟ್ಯಾಕ್ಸ್ ಏನಾದ್ರು ಪೇ ಮಾಡ್ಬೇಕಾಗುತ್ತೆ ಅಂತ. ಹೀಗೆ ಮಾಡಿ 9,350 into 12 ಮಾಡಿ. So that
1,12,200.
1,12,000. I think it is below income tax. 2014 ನಲ್ಲಿ it was 2,50,000 again. Okay. ಇದರದ ಎಷ್ಟು 2/3?
6,233.
6,233.33. 33.33 ಬರುತ್ತಾ?
Into 12 into 9.
ಅಲ್ಲ 12 ಅಲ್ಲ, ಇದೆ annual income ಇದು.
ಅಲ್ಲ, monthly income. 8,000
9,350
is
into 12 ಮಾಡಿದ್ವಿ, 1,12,200 ಬಂತು. ಇದು ನೀವು ಅಮೌಂಟ್ ನೀವು ಏನೋ ತಪ್ಪು ಮಾಡಿದ್ರಿ ನೀವು. 1,12,200 2/3 ಮಾಡಿ ಅಂತ ಹೇಳಿದ್ವಿ. ಇಲ್ಲಾಂದ್ರೆ 12 ಮಾಡಿ ಮಾಡ್ಬೋದು ಅದ್ರಲ್ಲಿ.
6,73,270.
ಅಪ್ಲಿಕೇಬಲ್ ಮಲ್ಟಿಪ್ಲೈಯರ್ ಎಷ್ಟು ಇವ್ರಿಗೆ?
9.
9 57ಗೆ. 57 56 to 69. ಓಕೆ, ಎಷ್ಟು ಆವಾಗಲೇ 2/3 ಮಾಡೋದು. 1,12,200 into 9. 1,12,200 into 9.
10,09,800.
10,09,800.
ಅದರಲ್ಲಿ 1/3 ಕಳಿಬೇಕಾಗತ್ತೆ.
ಅಲ್ಲ ಅದಕ್ಕೇನೆ ಅದ್ರ 2/3 ತಗೊಂಡ್ಬಿಟ್ರೆ ಆಗ್ಬಿಡುತ್ತೆ.
ಅದೇ 2/3 ತಗೊಂಡು
ಎಷ್ಟು? 10,09,800. 800 ಅದ್ರ 2/3 ಎಷ್ಟಾಗುತ್ತೆ? ಐದರ್ ವೇ ದಿಸ್ ವೇರ್ ದಟ್
7,83,272.
6,73,200.
73,200.
ಅಲ್ಲ, ಈ 7 lakh ಬರ್ಬೋದು ನೋಡಿ ಮೇಡಮ್. ಅಲ್ಲ, ಐ ಹ್ಯಾವ್ ಆಡೆಡ್ ದಟ್. 6,73,200. ಎಸ್.
ಸೊ ಉಳಿದಿದ್ದೆಲ್ಲ
ಅದು ಕನ್ವೆನ್ಷನಲ್ ಹೆಡ್ ಅವ್ರು ಸ್ವಲ್ಪ ಡಿಫ್ರೆಂಟ್ ಆಗಿ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಅಲ್ಲ, ಈಗ ಮೆಡಿಕಲ್ ಎಕ್ಸ್ಪೆನ್ಸಸ್
10,63,747.
63,747 ಮೆಡಿಕಲ್ ಎಕ್ಸ್ಪೆನ್ಸಸ್.
ತಂದೆ ಮತ್ತು ಹೆಂಡತಿ
ಸೊ 88,000 ಕನ್ಸೋರ್ಷಿಯಂ.
ಎಸ್.
33,000 ಅದೆಲ್ಲ 16,000 ಸೇರಿಸ್ಕೊಂಡ್ರೆ
33.
ಎಷ್ಟು ಮಾಡಿದ್ರೆ ನಾವು why the liability is passed only to the owner of the vehicle?
On the ground that
ಇದಿಷ್ಟು
the check was issued and it has been dishonored.
ನೋ ಪಾಲಿಸಿ ಅಂತನಾ?
ನೋ ಪಾಲಿಸಿ ಅಂತ ಅವರು ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದಾರೆ.
ಚೆಕ್ ವಾಸ್ ಇಶ್ಯೂಡ್.
Exhibit check was issued. I am a claimant, but the owner had issued a check on 28/8/2013, my lord, for 18,205. The check has been dishonored, presented on 30th August 2013.
ಜಸ್ಟ್ ಆಮೇಲೆ ತಕೊಳ್ಳಿ, ಮತ್ತೆ ಬೇರೆ ನೆಕ್ಸ್ಟ್ ಶೀಟ್ ಕೊಡಿ. ಚೆಕ್ ವಾಸ್ ಇಶ್ಯೂಡ್ ಆನ್?
Check was issued on 28/8/2013.
2013.
28/8/2013.
2013.
Yes.
It was presented on 30th August 2013.
Yes.
Return date is 31st August 2013.
Next day only. ಏನು ನೋ ಫಂಡ್ಸ್ ಅಂತನಾ?
No funds ಅಲ್ಲ.
Signature.
Difference in sign, not
Signature differs.
signature does not tally ಅಂತನೋ ಏನು ಇರಬೇಕು ಇದು. Drawers sign not as per mandate.
Drawer signature is not as per mandate antala. Accident ಆಗಿರೋ date 14th. So it was before the check was issued.
Yes.
ಮೊದಲು ಪಾಲಿಸಿಯಲ್ಲಿ
ಪಾಲಿಸಿ ಕೊಟ್ಬಿಟ್ಟಿದ್ರು. ಅದನ್ನ ಮಾರ್ಕ್ ಮಾಡಕ್ ಬಿಟ್ಟಿಲ್ಲ, ಯಾಕೆ ಅಂದ್ರೆ ಇಟ್ ಈಸ್ ಓನ್ಲಿ ಜೆರಾಕ್ಸ್ ಕಾಪಿ ದಟ್ ದಿ ಕ್ಲೈಮೆಂಟ್ಸ್ ಕುಡ್ obtain.
But they did not produce the policy.
They say that they have cancelled it.
But even if they cancel, what was the policy earlier?
No, they have not produced it. But we have a copy of the policy, Xerox copy of the policy.
Check return memo, copy of written statement, office copy of the legal notice endorsement issued by the insurance. But you have the Xerox policy.
We have the Xerox.
Say that they have not issued the policy at all.
They say that they have cancelled it. No, they don't say that we have not issued. They say that they have cancelled it. As per exhibit R5, notwithstanding anything contained herein to the contrary, it is hereby declared and agreed that the above mentioned policy stands cancelled with effect from inception due to dishonor of check. They say that they had intimated this dishonor of check to the claimant. Your Lordship may kindly see exhibit
See that endorsement.
R4.
Notice. What was the commencement of the policy? The designer policy number so also. The policy issue ಮಾಡಿದ್ದಾರೆ. Your check bearing number so 28. ಅವ್ರಿಗೆ ಕೊಟ್ಟಿರೋದಲ್ಲ. What is the name of the owner? ಅದು ಮೊದಲು ಇಶ್ಯೂ ಮಾಡಿದ್ರೆ.
ಇದು ಯಾರಿಗೆ ಕಳ್ಸಿದಾರೆ, ಯಾವಾಗ ಕಳ್ಸಿದಾರೆ, ಡೇಟ್ಸ್ ಎತ್ತ ಇಲ್ಲ. 10/9/2013 ಅಂತ ಒಂದ್ ಮೇಲ್ಗಡೆ ಟೈಪ್ ಮಾಡ್ಬಿಟ್ಟು ಇವ್ರು ಕಳ್ಸಿರೋದಕ್ಕೆ ವಾಟ್ ಡಾಕ್ಯುಮೆಂಟ್ ದೇ ಹ್ಯಾವ್ ಪ್ರೊಡ್ಯೂಸ್ಡ್? Have they intimated to the RTO at least?
ಆಕ್ಸಿಡೆಂಟ್ ಆಗಿರೋದು 14/3/2014. ಇವ್ರ ಪಾಲಿಸಿ ಕ್ಯಾನ್ಸಲ್ ಮಾಡಿರೋದು 31 ಅಲ್ಲ. ಪಾಲಿಸಿ ವಾಸ್ ಕ್ಯಾನ್ಸಲ್ಡ್ ಅಲ್ಲ, ಚೆಕ್ ಬೌನ್ಸ್ ಆಗಿದೆ.
ಚೆಕ್ ಬೌನ್ಸ್ ಆಗಿದೆ. ಕ್ಯಾನ್ಸಲೇಷನ್ ಫ್ರಮ್ ದ ಡೇಟ್ ಆಫ್ ಇನ್ಸೆಪ್ಷನ್ ಅಂತ
ಡೇಟ್ ಯಾವುದು ಕ್ಯಾನ್ಸಲೇಷನ್ ಡೇಟ್?
Exhibit R.
10/9/2013 ಅಂತಾರೆ. 10/9/2013 ಅಲ್ಲ, ಈ ಲೆಟರ್ ಅಲ್ಲಿ ಒಂದು ಕಾಲಮ್ ಅಲ್ಲಿ ಬರ್ದಿದ್ದಾರೆ. ಎಕ್ಸಿಬಿಟ್ R5 ಅಲ್ಲಿ.
R5
issued at on 10/9/2013.
issued on issued on ಇದು ಇಶ್ಯೂ ಮಾಡಿ ಎಂಡಾರ್ಸ್ಮೆಂಟ್ ಇಶ್ಯೂ ಮಾಡಿದ್ದು ಅಲ್ಲ. ಪಾಲಿಸಿ ಯಾವಾಗ it had commenced when?
Commenced, the policy commenced. ಅವರು ಪಾಲಿಸಿ ಹಾಕಿಲ್ಲ. The policy commenced from 29/8/2013 to 28/8/2014 midnight.
13 date of issue of policy.
29/8/2013 to 28/8/2014.
ಇವಾಗ ಪಾಲಿಸಿ ಇಶ್ಯೂ ಮಾಡಿ.
This is the document that was given to us by the police.
20 policy was date
29/8/2013.
ಕ್ಯಾನ್ಸಲೇಷನ್ ಮಾಡಿರೋದು
10/9/2013. 13.
Prior to accident.
Prior to accident.
prior to accident.
Supreme Court judgment.
What was the proof that it was served on the owner of the vehicle? Exhibit R4. ಏನಾದ್ರು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ರಾ? ಸರಿ. 29, date of issue of policy 29. Yes. What is held here?
This is the latest judgment, my lord,
Karnataka.
where they have dealt with Oriental Insurance Company, Indrajit Kaur and Seema Malhotra, New India Assurance Company Limited versus Rula and others, and Damadil Lal and others versus Parashram and others,
Correct.
and all.
Para 26 and 28. Para 26 and 28. They are not obvious of the distinction between statutory liability. Concerned have been intimated.
Yes, I will read para 26. We are not oblivious of the distinction between the statutory liability of the insurance company vis-a-vis a third party in the context of section 147 and 149 of the Act and its liabilities in other cases. But the same liabilities arising under a contract of insurance would have to be met if the contract is valid. If the contract of insurance has been cancelled and all concerned have been intimated thereabout, we are of the opinion the insurance company would not be liable to satisfy the claim. The beneficial legislation, as is well known, should not be construed in such a manner so as to bring within its ambit a benefit which was not contemplated by the legislator to be given to the party. The Regional Director, Employees State Insurance Corporation, Trichur versus Ramanuja Match Industries, this court held. We do not doubt that beneficial legislation should have liberal construction with a view to implementing the legislative intent, but where such beneficial legislation has a scheme of its own, there is no warrant for the court to travel beyond the scheme and extend the scope of the statute on the pretext of extending the statutory benefit to those who are not covered by the scheme. We therefore agree with the opinion of the Hague. However, as the appellant hails from the lowest strata of society, we are of the opinion that in a case of this nature, we should, in exercise of our extraordinary jurisdiction under Article 142 of the Constitution of India, direct the respondent number 1 to pay the amount to claim to the appellants herein and recover the same from the owner of the vehicle, vice respondent number 2, particularly in view of the fact that no appeal was preferred by him. We direct accordingly. We therefore allow the appeal with aforementioned directions in the facts and circumstances of the case. However, there shall be no order as to pass.
Cancellation presupposes issuance.
ಡೇಟ್ ಹಾಕ್ತಾರೆ, ಬಟ್ ಆದ್ರೆ
10-9.
ಯಾರಿಗೆ ಕೊಟ್ಟಿದೀವಿ ಇಲ್ಲ, ಎಲ್ಲಿ ಅವರು RP ಇಲ್ಲ, ಒಂದು ಅಕ್ನಾಲೆಜ್ಮೆಂಟ್ ಇಲ್ಲ, ಅಟ್ಲೀಸ್ಟ್ ಫಾರ್ ಹ್ಯಾವಿಂಗ್ ಪೋಸ್ಟೆಡ್ ಇಟ್.
The evidence of deportation of
Our evidence ಮಾಡ್ಯಾರ. RW?
RW1.
RW1 and RW2. RW1 is the officer of the insurance company.
Cross-examination.
Cross-examination ಏನ್ ಮಾಡಿದ್ದಾರೆ ಅಂತ Yeah, the deportation of that RW1.
Huh? Yes.
Read the cross-examination of RW1.
It is true to suggest that we have filed written statements stating that the check bounced for want of sufficient funds. It is true to suggest that as per Exhibit R2, check returned as drawer signature is not mandate. It is false to suggest that in the written statement, we have not stated that we have informed to the RTO authorities and we have only stated that we have informed to concerned party. It is false to suggest that I have only stated in my chief affidavit that we have informed to the RTO authorities about cancellation of insurance policy. We presented the check on 28/8/2013 and it returned on 31/8/2013. We returned letter to the RTO authorities and owner of the vehicle on 10/9/2013. The postal receipts have been misplaced and they have not been produced before this court. I do not know that whether unserved postal cover returned back from RTO authorities and the owner of the offending vehicle. We have done efforts to search RPAD cover and postal receipts in our office. We are searching the registered post cover or postal acknowledgement since last 1 month. We have not filed complaint to the postal authorities for furnishing information about the service or non-service of note concerned parties till today. It is false to suggest that we have not informed to the RTO or owner of the party and we have created documents and produced before this court. We sent intimation to the RTO office by registered post. The postal document about service of intimation to the RTO has been misplaced in the file of our office. Exhibit R5 is document taken print from our office. It is false to suggest that Exhibit R1 to R5 are created and concocted documents and we have not issued any intimation either to the owner of the vehicle or to the RTO authorities. We have not taken action against the concerned party for dishonest checks.
Yes. Just what was the answers elicited about service of notice? Cancel again, cancel it, endorsement of it. Yes, this is about.
They have not intimated that is
the only ground for.
Yes, because they have not intimated and pay and recovery may kindly be added in this case because we are not parties to any of these things.
Owner did not contest.
No, my lord.
MG Raghavendra ಯಾರು ಅಪಿಯರ್ ಆಗಿದ್ದಾರಲ್ಲ MG Raghavendra
ಅಲ್ಲ ಇಲ್ಲಿ ಯಾರು ಬರ್ಲಿಲ್ಲ
ಅಲ್ಲ ಇಲ್ಲ ಅವ್ರ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ವಾಸ್ ಕಂಡಕ್ಟೆಡ್ ಬೈ ಹಿಮ್ ಆರ್ ಕ್ಲೇಮಂಟ್
the respondent number one has appeared through his counsel. He has not filed his written statement. Hence, the written statement of respondent one is taken as not filed.
ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಮಾಡಿದ್ ನೀವೇ
ನಾವೇ
RW1 ಅನ್ನ
ಹೌದು.
Counsel for response, chief examination response. Counsel for petitioner.
ಅಷ್ಟೇ.
Who is RW2?
RW2 is from postal department.
Postal department. Our exam
ಮಾಡಿದ್ದಾರೆ.
Summons in this case. Reserved for 18 months. In this case, pertaining to date 11/9/2013 and reservation period has been lapsed. Receiver ಇರ್ಬೇಕಲ್ಲ. Correct. If that is misplaced, I mean that is destroyed, they may be having records, I mean at least postal receipt.
ಇವ್ರ ಹತ್ರ ಇರ್ಬೇಕು for having sent it.
ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ಟಿಲ್ಲ ಅಂತ ಅವ್ರು ಹೇಳ್ತಾರೆ.
ಹೌದು, ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ಟಿಲ್ಲ, ಇವರು ಫಾಲೋ ಅಪ್ ಮಾಡಿಲ್ಲ. If they had informed to the RTO office nor to the party. Signature vary ಆಗಿದ್ದಿದ್ರೆ if they had called him over phone, he would have come and signed it.
That is exhibit ಎಷ್ಟದು ಚೆಕ್ ಕೌನ್ಸ್ Not for want of fund ಅಂತ ಇಲ್ಲ. Notice ಅಲ್ಲ. Check return memo.
Check return memo is exhibit R3
R2
from
ಅಲ್ಲ.
HDFC.
Check return memo is.
Memo is R2. Copy of written statement issued by HDFC stating when it was presented and when it was, that is R3.
Check return memo ಅಂತಿದೆ. ಇಲ್ಲಿ reason. ಅದು main reason. Drawer signature not as per the mandate. Funds ಇಲ್ಲ ಅಂತಲ್ಲ. Yes. Yes, Mr. Mahesh.
Yes. Lord, first of all, my lord, the appeal against the owner is not maintainable because the owner, my lord, before the tribunal had not contested and not disputed, my lord, the evidence of the insurance company. And he has accepted the verdict of the MACT, making him liable. He has not challenged that order. Therefore, the claimant have no locus standi to make any allegation against the second respondent insurance company.
Yes.
Great. Then, my lord, I invite your lordship attention to my lord reasoning of the tribunal, para 31 of the judgment.
Page number?
32 of the judgment, my lord.
What is?
I put page 32,
Yes, yes, what do you want to show us here?
para 31, my lord.
Yes.
May I read, my lord?
Yes.
The learned counsel for the petitioner has relied upon the judgment of Honorable Supreme Court reported in Dedappa and other versus the branch manager National Insurance Company Limited, wherein it is held that check issued by the insurer was dishonored. As a result, the policy of insurance was cancelled and insured was intimated before the accident occurred, and insurer is not liable to pay the compensation. The respondent insurance company has examined its manager and produced the check bearing registration bearing number 690853 dated 23/8 28/8/2013 for rupees 18,205 issued by the respondent number 1 drawn on Vijaya Bank branch. The said check was presented to the HDFC Bank and it returned with an endorsement as per endorsement as prior signature is not mandate on 31/8/2013. The respondent insurance company has produced a copy of the endorsement and as per the said document, the check was not realized due to difference in signature of drawer. The respondent insurance company issued notice to the insured on 10/9/2013, that is prior to the date of accident, by register post about cancellation of the policy from the date of inception. The intimation has been given by the insurance company to the insured to the address furnished by him in the insurance policy. It is deemed to be served under section 114 of the Indian Evidence Act. The learned counsel for the petitioner has submitted that there is no seal of Vijaya Bank authorities about the presentation of the said check to the bank, and the bank authorities are the competent person to say about the presentation of the check and dishonor of the check, and the respondent insurance company has not examined the bank authorities to prove the same. He has also submitted that the check is returned with an endorsement and a royal signature, not as per mandate and not for funds insufficient. But this contention is not at all acceptable because the check has been presented to the HDFC Bank, and due to the online transaction, it is necessary to send the check to the concerned bank even in the check return memo. The return consequences number is also mentioned and the said check was presented on 30/8/2013 and returned on 31/8/2013 from the Drawers Bank. Even RW2 has admitted that the number bearing number so and so was pertaining to the register post and the date of article registered post is given on 11/9/2013. The accident took place on 14/3/2014. This date is important. This goes to show that much prior to the accident, intimation was given to the registered post by register post and copy is also sent to the RTO, Bangalore Central. Though there is no postal acknowledgement, the letter has been sent to the address of the respondent 1 and the same address is also shown in the claim petition. And the notice has been served and the respondent 1 has appeared through the council. Then it cannot be believed that the notice issued to the address of the respondent 1 is not served upon him. Even though respondent 1 has appeared through the council, he has not placed any material on record to show that as on the date of the accident, premium amount was paid. So I hold the respondent insurance company has discharged the liability. He has appeared, my lord, he has not controverted the.
Yes.
Yeah. Then, my lord, the ruling which has been laid upon by the other side, my lord, it was under Article 142. It's an extraordinary jurisdiction. It is not a precedent as such. Now, my lord, I invite your lordship attention to Insurance Regulatory and Development Authority Manner of Receipt of Premium Regulation 2002. This is very important. Regulation number 4. You must kindly have, my lord, insurance
Which regulation?
Regulatory and Development Authority Manner of Receipt of Premium Regulation.
Place the copy of that on record. You placed a copy on record, Mr. Mahesh?
But this was, my lord, placed, my lord, before the court and court has also made an observation in the order sheet dated 30/5/2022. If it is not there, my lord, I'll supply a copy of it.
Just
It
a
is
minute, can see.
30?
35/2022, no?
22. If it's not there, my lord, the copy is available in the library, court library. Otherwise, I'll supply a copy of that. Section 64 VB and Regulation 4. Order sheet dated 30th of May 2022.
Only there is reference, therefore, in terms of regulation number so and so, that is wide on the submission money.
Para 5 of the order.
Para 5 only says your submission. So
Yes,
and so counsel for respondent insurer representing the contended that owner, though represented by counsel, has not filed any written statement or challenged the defense taken by the insurance company. Therefore, in terms of regulation number 4 of regulations and 64 VB, 5B of Insurance Act 1938, general insurance is wide. There is no contact between the insurer and the owner of the vehicle as on the date of accident. Your submission is anyone will place
for there, my lord, but otherwise I will supply the copy also. I'll read, my lord, the regulation. I'll supply the copy to the court also.
What that regulation says?
Regulation, my lord, you say is 4, commencement of risk. Regulation 4. The book is available in the court, my lord. Anyway, I'll read, my lord, Regulation 4. Commencement of risk. In all cases of risk covered by the policies issued by an insurer, the attachment of the risk, and except in cases where the premium has been paid in cash, that is important. Right? In all other cases, the insurer shall be on risk only after the receipt of the premium by the insurer. And even in the policy, my lord, it has been
Even in
mentioned.
this, what are those regulations ಅಂತ ಇಲ್ಲಿ reference ಎಲ್ಲ ಹೇಳೋದಿಲ್ಲ. Regulation number 4 of regulations. What are those regulations called?
The Insurance Regulatory and Development Authority Manner of Receipt of Premium Regulation 2002. If it's not there, my lord, I'll supply the case.
IRA.
Regulations 2002.
2002. Yes.
Yes. Regulation 4, my lord, is commencement of risk. In all cases of risk covered by the policies issued by an insurer, the attachment of the risk to an insurer will be in consonance with the terms of Section 64 VB of the Act, except in cases where the premium has been paid in cash. In all other cases, the insurer shall be on risk only after the receipt of the premium by the insurer. Here is the case where there is no receipt of insurance. It is not paid by the cash, and it was cancelled, and it was notified also. And the owner appeared before the tribunal. He did not file any statement. He did not dispute the evidence of RW1 and 2. Therefore, it does not lie in the mouth of the claimants, my lord, when the owner has accepted the verdict of the tribunal and has not challenged it. Even before this court, he has appeared through an advocate, and advocate retired. After that, notice to him has been held sufficient. He has not challenged, my lord, the defense of the insurance company and the evidence let in by him. That is exhibit R1 to R5 in the light of exhibit evidence of RW1, officer of the insurance company, and RW2, the postal authority witness. From the manner of receipt, my lord, it is clear only in case of cash the risk commences. In all other cases, only after the receipt of premium. Here it has been proved that there is no receipt of premium. Yes. And the owner, my lord, who appeared,
Yes, that's it. Yes, reply any?
They have issued the policy. If they could have stated that they will not issue the policy unless the amount is, the check is encashed. Why did they issue the policy? If there was a regulation to the effect that only cash and then the policy, they could have waited till the check is encashed. Why did they issue the policy?
Insurance is not disputed.
Insurance.
Simply because the defense is of one of cancellation.
Whether that defense is available to them in the MV Act is also to be looked into.
Take the defense of cancellation, they admit the insurance.
They have to prove that defense was.
Yes, that's all.
Whether it was proved was.
and owner, my lord, owner has appeared before the tribunal and also before your lordship, and he has not controverted any of these facts.
ನಮ್ಮ ಇವರು ಭಟ್ ಅವರು ಇದ್ರ ಮೇಲೆ ಏನಿದೆ, ಇದರಲ್ಲಿ ಬೇರೆ ಜಡ್ಜ್ಮೆಂಟ್ ನಮ್ಗೆ ಯಾವ್ದೋ ಇನ್ನೊಂದು ಬೇರೆ ಕೇಸಲ್ಲಿ ಓದಿದ್ ನೆನಪು.
ಅದನ್ನ that has been dealt with in that case.
Under Article 142.
ಅಲ್ಲಿ ಕ್ಯಾನ್ಸಲೇಷನ್ ಹ್ಯಾಸ್ ಟು ಬಿ ಪ್ರೂವ್ಡ್ ಅಂತ ಏನೋ ಇದೆ.
ಅಲ್ಲ, ಇದ್ರಲ್ಲೇ ಹೇಳ್ತಾರೆ. ಇದ್ರಲ್ಲೇನೆ 26 ಅಲ್ಲಿ if the contract insurance has been cancelled and all concerned have been intimated thereabout, we are of the opinion. ಅದ್ರಲ್ಲೇ ಅದನ್ನೇ ಇಷ್ಟ
Evidence of RW1 and the Milord
98 Supreme Court.
ಅದು 98 Oriental
98
Insurance
Supreme Court.
Company Limited versus Indrajit Kaur and others. That has been dealt in this judgment also.
98 Supreme Court.
98. 98 1 SEC 371.
Page ಹೇಳಿ.
1985 ಮಾಡಿದ್ದಾರೆ.
ಅಲ್ಲಲ್ಲ 98 Supreme Court.
98 1 SEC.
ಯಾವ ಪೇಜ್ ಅಲ್ಲಿ ಇದೆ ಅದು? 98 1 SCC.
ಅಲ್ಲಿ ಕೇಸಸ್ ರೆಫರ್ಡ್ ಅಲ್ಲಿ ಫಸ್ಟ್
ಪೇಜ್ ನಂಬರ್ ಹೇಳಿ ಮೇಡಮ್.
ಇಂದ್ರಜಿತ್ ಕೌರ್.
ಇಂದ್ರಜಿತ್ ಕೌರ್.
ಅದ್ರ ರೆಫರೆನ್ಸ್ ಮಾಡಿ
1998
ಕನ್ಕ್ಲೂಷನ್ ಇಸ್
SCC.
ಇನ್ಕರೆಕ್ಟ್. ಕನ್ಕ್ಲೂಷನ್ ತಪ್ಪಿದೆ ಅದು.
Page
Because
number
3 judges judgment says 164 VB is not mandatory. Once a policy is issued, insurance company should pay
371 man.
67.
1998 1 SCC 371 ಅಥವಾ 1998 AR SCW ಇಲ್ಲ.
SCW 183.
ಬೇಡ, SCW ನಮ್ಮ ಹತ್ರ ಇಲ್ಲ. SCC ಇದೆ, ಅದು ಲೈಬ್ರರಿ.
So in that case also, the insurance company had issued intimation to the owner saying that we are not at risk. In spite of that, what the apex court said is cancellation is strictly not a defense under 149(2), number 1. So we will not express any opinion on that. That is how they said. However, because 149(1) says cancellation is available, so notwithstanding cancellation, you should pay is the mandate of section 149(1) read with 147(5). So pay is a mandate once a policy is given. That is how they said.
is cancelled.
First ಪ್ಯಾರಾದಲ್ಲೇ ಬಂದ್ಬಿಡ್ತದೆ ಅದು.
ಕೊಡ್ತೀನಿ ನೋಡಂತ ಹರ್ಡ್ ರಿಸರ್ವ್.
ನಾನು ಆವಾಗಲೇ ಹೇಳಿದೆ ಅವ್ರ ಹತ್ರ ಇಂದ್ರಜಿತ್ ಕೌರ್ ಕೊಡಿ ಸಾಕು ಇದಕ್ಕೆ.
ಅಲ್ಲ ಇಲ್ಲೇ ಇದೆ.
That stand cannot be taken by the claimants. Insurer has not.
You furnish those regulations, whatever you are relying, because ಅದು 1998 ಅಂತ ಇದೆ.
I'll produce.
Authority Act 1999.
I'll produce a copy of 2002.
2000 ಅಂತ ಇದೆ.
ಅಲ್ಲ 2000.
Development Authority rules, regulations 2017.
ಅಲ್ಲ ಅದು ಇದರಲ್ಲಿ ಕನ್ಸಿಡರ್ ಮಾಡಿದ್ದಾರೆ.
2002 ಅಂತ ಹೇಳಿದ್ರು.
I'll produce the Milord copy to the court.
2002 2002.
Milord, I got the regulation
ಅಲ್ಲ
here.
ಆಯ್ತು, ನಮಗೆ ಕೊಡಿ ನೀವು, ಯಾಕಂದ್ರೆ ನಮ್ಮ ಹತ್ರ ಇರೋ ಬುಕ್ ಅಲ್ಲಿ 2000 2017 ಅದೆಲ್ಲ ಇದೆ ರೆಗ್ಯುಲೇಷನ್ಸ್.
I'll supply Milord. Tomorrow itself I'll file it. And moreover, I was informed, Milord, that there was an agreement between the claimants and the owner. And that has not been, Milord, brought forth before the court.
ಏನ್ ಅಗ್ರಿಮೆಂಟ್?
Therefore, the Milord owner is behind the screen. And another thing is, they are not taken any steps to execute the award against the Milord. The
ಆಯ್ತು,
owner.
ಈಗ ನಾವು your hearing is over.
Yes,
What
yes.
they do against owner is, that is different thing.
I'll produce the Milord the regulation.
Seal number 47 adjourned. Seal number 48, Uday Kumar RL.
Any date fixed, Milord?
Reserved.
Reserved, you furnish it, we have reserved it.
I'll file it in the registry, Milord.
ರಿಜಿಸ್ಟರ್ ಬೇಡ, ಕೋರ್ಟ್ ಆಫೀಸರ್ ಹತ್ರ ಕೊಟ್ಟಿರಿ ಇಲ್ಲಿ.
Right.
Tomorrow you furnish it.
Please.
48, Uday Kumar.
Claimant's appeal, my lord. It's only on quantum. It's a very short issue, my lord. The claimants are the wife, son, mother and father, my lords. The dependency taken only 3. Father is not taken. That is only the issue.
Father
Other-
is not entitled ಅಂತನಾ?
No, he is living together. There was no discussion except one line. It is at page 17. Loss of dependency. The
1 second. Internal page 17.
internal page, ink page 17, my lord, para 15, issue and second, this one.
Loss of dependency.
Loss of dependency. The ascertain the loss of dependency, the age of age, income of the deceased and number of dependents, the deceased are relevant. Petitioners are wife, minor, son, and parents are deceased. There is no dispute respect to the relationship with the deceased. Fourth, petitioner is father of deceased. In cross-examination, BW state that the father for fourth petition is doing agriculture. In addition to this, no special circumstances are pleaded and proved to show that the fourth petitioner is also a dependent of the deceased. Only on this ground, the
What is the age of the father?
62, my lord. More than that, the other point,
It has stage already 62.
more than that, my lords, as far as the awarding compensation,
Because he has the land, how can we say that father was not dependent? Because they say deceased was aged 38.
62 years.
Awas
They are living together also.
62.
There should be some evidence to show that. Otherwise, father normally is not as per Sarla Verma, unless they prove that he was also a dependent.
60.
My lord, another submission is there.
Even if he is the agriculturist. 67 ವರ್ಷ ಹೋದ್ಮೇಲೆ ಜಮೀನ್ಗೆ ಹೋಗಿ
No, another submission, my lord. ಅವರು proportionate ಮಾಡಿದ್ದಾರೆ 5% father ಕೊಟ್ಟಿದ್ದಾರೆ. When he is not a dependent. Yes, please, my lord. In that also inconsistent. The judgment is inconsistent.
So dependency considered as
Yes, my lord. Page 5, please see, my lord.
fourth 4 ಜನ ಆದ್ರೆ
ನಾಲ್ಕು ಜನಗೂ ಕೊಟ್ಟಿದ್ದಾರೆ.
reduction becomes different.
1/4 ಆಗುತ್ತೆ, my lord.
If this honorable court construes that the father was also a dependent in the facts of the case, but normally father is excluded.
No, it's already, lordship in this coordinate bench already considered.
What is
ಅಲ್ಲಲ್ಲ facts ಮೇಲೆ ಹೋಗುತ್ತೆ each case.
ಈಗ ಸಿ ಎಲ್ಲೋ ದೊಡ್ಡ ದೊಡ್ಡ ಇಂಡಸ್ಟ್ರಿಯಲಿಸ್ಟ್ ಅವರು ಇವರು ಆದ್ರೆ ಸರಿ.
62 is not much age in the present parlance.
ಯಾಕೆ ಷಷ್ಠಬ್ದಿ ಪೂರ್ತಿ ಮಾಡಿ ಕೈ ಬಿಡ್ತಾರೆ. ಫಾದರ್ ಅಬೌವ್ 60 ಸೀನಿಯರ್ ಸಿಟಿಸನ್ಸ್ ಎಲ್ಲಿದೆ ಎಷ್ಟಿದೆ ನಮ್ಮ ಇದರಲ್ಲಿ ಹೈಕೋರ್ಟ್ ಇದ್ರದ್ದು ಗವರ್ಮೆಂಟ್ ಸೀನಿಯರ್ ಸಿಟಿಸನ್ಸ್ ಬೆನಿಫಿಟ್ ಕೊಡ್ತಾರಲ್ಲ 65 or 60?
60, my lord.
60 ಮತ್ತೆ ಯಾಕೆ ಕೊಡ್ಬೇಕು ಅಬೌವ್ 60 ಇದ್ರೆ?
More than they are apportioned the amount also.
ಕೋರ್ಟ್ ಆಫೀಸರ್ ನಮ್ಮ ಇದಕ್ಕೆ ಮಾಡ್ತೀವಲ್ಲ ಅಬೌವ್ 60 ನೋ 65 ಸೀನಿಯರ್ ಸಿಟಿಸನ್ 60. ಆ ಸೀನಿಯರ್ ಸಿಟಿಸನ್ ಆಕ್ಟ್ ಅಲ್ಲಿ ಇದೆ ಅನ್ನಲ್ಲ ಅದು 60. Then they have to be taken as dependent. Very unsafe land ಇದ್ರೆ.
When there is no any weather.
So income proof ಏನಿತ್ತು?
Income is not, is the income tax assessment, my lord. As per the exhibit P18 income.
Judgment.
Please, my lord.
Judgment ಇದೆ.
Okay, the coordinate bench.
60 ಇದ್ರೆ.
Citing the National Insurance Company, Birendra. Page 5, para 6, my lord.
Para 6.
Learned counsel for the claimant submit that the tribunal grossly erred in deducting 1/3 from the income of the deceased on account of personal expenditure instead of 1/4, when it is clear that the number of the dependents are 4. Next panel, my lord. Comes to page 7, para 7, is last 5th line, my lord. I will read. In the instant case, the tribunal has not considered the father of the deceased to be dependent on the income of the deceased in the absence of evidence to that effect. The aforesaid findings of the tribunal cannot be sustained in view of the law laid down in the Supreme Court National Insurance Company. Birendra, my lord. Yeah, other insurance also. Jayashri versus Coromandala. In the mother-in-law was taken it as a dependence, my lord.
Instant case, so that is the.
In that he was 57, my lord. His age was 57.
When the son becomes, age of earning, highest obligation is there on him to.
No, not on that obligation. I am not disputing of that. Virendra case was of a different context. Virendra case only made children.
Even Jayashri versus Coromandala, my lords. In that mother-in-law, she was living with the deceased. There also it was considered that.
True. If there is an evidence that can be considered.
It is there. They are all living together, my lord. They are all living together.
Found in detail, irrespective of the fact that they were the concerned. fully dependent on the deceased. The other 2020. The other 2020 National Insurance Company versus Birender.
ಬೇರೆ that my lord. In that
Major children
major sons my lord. Mother dies.
ಡಿಪೆಂಡೆಂಟ್ ಅಂತ ಮಾಡಿದ್ದಾರೆ.
Mother dies.
ಅವ್ರನ್ನೇ ಮಾಡಿದಾಗ ಅವ್ರನ್ನೇ ಮೇಜರ್ ಸನ್ಸ್ ಅನ್ನೇ
ಅದು
ಮಾಡಿ
that's again all depends. There's no straight jacket formula in motor vehicle case.
Even
Depends
another
upon the
judgment my
facts
lord.
of each case.
Jayashree versus
ಆ ಕೇಸಲ್ಲಿ ಏನು ಎವಿಡೆನ್ಸ್ ಇರುತ್ತೆ?
in such cases, if they are major 25, 28 ಹೀಗಿದ್ರೆ children, sons, if they do not enter the witness box to say that they were dependent, at least they have not spoken about the dependency ಅಂತ ಹೇಳ್ಬೋದು.
That's
Till-
why-
another my lord. Consortium is given only 40,000. It should be given all the four my lord.
And otherwise deduction ಒಂದ್ಬಿಟ್ರೆ ಎಲ್ಲ
1/4 place ಇದೆ. Consortium ಅಲ್ಲಿ only ಒಬ್ಬರು ಕೊಟ್ಟಿದ್ದಾರೆ 40,000 ಕೊಟ್ಟಿದ್ದಾರೆ. Should
40,000 ಕೊಟ್ಟಿದ್ದಾರೆ. ಅದು
ಕೊಟ್ಟಿದ್ದಾರೆ.
ಇವ್ರು ಹೇಳ್ತಾರೆ ಎಲ್ಲ.
plus and 20% enhanced this one.
deduction is also given to only
One 48,000.
His annual income was 5,15,000.
No, my lord.
ಇನ್ಕಮ್ ಟ್ಯಾಕ್ಸ್ ರಿಟರ್ನ್ಸ್ ಪ್ರಕಾರ ತಗೊಂಡಿದ್ದಾರೆ.
Total 26,744 ಬರುತ್ತೆ.
ಅಲ್ಲ ಇಲ್ಲಿ ಜಡ್ಜ್ಮೆಂಟ್ ವೆರಿಫಿಕೇಶನ್ ಜಡ್ಜ್ಮೆಂಟ್
At page 15, para 18 ಅಲ್ಲಿ discuss ಮಾಡಿದ್ದೀನಿ.
page 15.
Para 18.
Hmm.
In the case of hand, the deceased was age 38 years. His income was 28,654 per month. As per the term of
Is
honorable.
working somewhere or what is that?
Is a independent this one. Is running a win fine security safety. He has a franchise with many big companies, my lord. That is not disputed.
ಅಷ್ಟೇ ಹೇಗ್ ಬರುತ್ತೆ ಅಂತ.
And income tax assess is income.
ಐಟಿ ರಿಟರ್ನ್ಸ್ ಪ್ರಕಾರ.
His
Exhibit P18, my lord.
per month ಅಂತ ಹೇಳಿದ್ರಲ್ಲ ಅದಕ್ಕೆ.
ಹೌದು, per month.
IT return is exhibit
Exhibit P18, my lords.
P18. ಯಾವ year ಇದ್ದದ್ದು? Date of accident is
2017. That is all not in dispute, my lord. 16 and 14 and 14, 15,
16/9/2017.
17, my lords.
335.
That is the previous period income tax was
Exhibit ಎಷ್ಟದು? P
18, my lords.
IT returns. ಅದು ಯಾವ ವರ್ಷದ ಅಂತ ಸ್ವಲ್ಪ ನೋಡ್ಬೇಕಾಗುತ್ತೆ. ಯಾವಾಗ ಸಬ್ಮಿಟ್ ಮಾಡಿದ್ರು? ಆಫ್ಟರ್ ಆಕ್ಸಿಡೆಂಟ್ ಆರ್ ಬಿಫೋರ್ ಆಕ್ಸಿಡೆಂಟ್?
Before.
P18.
2 years it was submitted, 25, 2015, 16 and 2014, 15.
So submitted on 18/8/2016. ಅಂದ್ರೆ ಬಿಫೋರ್ ಆಕ್ಸಿಡೆಂಟ್.
Before accident, that.
ಇದರಲ್ಲಿ annual income was shown as 3,52,329. Income tax payable 8,680. 3,52,330. ಇದನ್ನ ಮೈನಸ್ ಮಾಡ್ಬೇಕಲ್ಲ. 3,52,330. 330 minus income tax is 8,672. 3,52,330 minus 8,612. 3,44,718. ಏಜ್ ಎಷ್ಟು ಹೇಳಿದ್ರಲ್ಲ?
38, my lords. 15 is the multiplier.
ಅಲ್ಲ ಅದಕ್ಕೆ ಇದು ಸೇರಿಸ್ಬೇಕಲ್ಲ. ಈ ಇನ್ಕಮ್ಗೆ ನಾವು ವಿ ಹ್ಯಾವ್ ಟು ಆಡ್
40%.
ಅಲ್ಲ ಪ್ರೊಫೆಷನಲ್ ಟ್ಯಾಕ್ಸ್ ಒಂದು ಡಿಡಕ್ಟ್ ಮಾಡ್ಬಿಟ್ಟು 3,43,000 ಮಾಡ್ಯಾರ ಅಷ್ಟೇ.
8,006.
ಇಲ್ಲ ಅಲ್ಲಿ 3,40,000 ಅಷ್ಟೇ.
ಇದರಲ್ಲಿ ಆಯ್ತು, ಇದರಲ್ಲಿ 1,200 ಡಿಡಕ್ಟ್ ಮಾಡೋಣ.
ಅಲ್ಲ 2,000 ಮಂತ್ಲಿ 200
400 ಆಗುತ್ತೆ.
ಅವಾಗ 2,400.
3,43,718 ನಲ್ಲಿ minus 2,400 ಮಾಡಿ.
ಅಲ್ಲ ಅವರೇ ಮಾಡಿದ್ರು.
Everything was calculated there.
ಅಲ್ಲ ಅವ್ರು ಏನ್ ಮಾಡಿದ್ದಾರೆ, ಮಂತ್ಲಿ ತಗೊಂಡಿದ್ದಾರೆ.
ಅದನ್ನ ತಗೊಂಡು ಅಲ್ಲಿ ಮಂತ್ಲಿ ಇಷ್ಟು ಬರುತ್ತೆ ಅಂತ ಮಾಡ್ಯಾರ.
8,418. ನಾವು 8,672 ಇದೆ ಅದರಲ್ಲಿ ಇನ್ಕಮ್ ಟ್ಯಾಕ್ಸ್ ಪೇಡ್. ಟೋಟಲ್ ಟ್ಯಾಕ್ಸ್ ಅಸೆಸ್. ಟೋಟಲ್ ಟ್ಯಾಕ್ಸ್ ಇಸ್
3,480, 192 interest.
Tax payable ಎಷ್ಟು ಮಾಡಿದೆ? 8480 no?
Mistake ಮಾಡಿದ್ರೆ interest paid is 192, tax is paid.
Tax and interest paid.
8612.
Self.
For the 40%.
8612.
8672.
72 ಮೈನ್ ಅದು ತೆಗೆದ್ರೆ ಎಷ್ಟು ಬರ್ತಿತ್ತು? ಅಲ್ಲ ಹೇಗ್ ಮಾಡಿ? ಇದು 8672 plus 2400 ಮಾಡಿ.
11,000.
ಅವರೇ ಹೇಳಿದ್ರಲ್ಲ. He was what he was doing? ಏನ್ ಕೆಲಸ ಮಾಡ್ತಿದ್ರು?
ಅವರೊಂದು ಓನ್ ಇದು ಮಾಡಿ ಸೆಕ್ಯೂರಿಟಿ ಏಜೆನ್ಸಿ. ಫೈರ್ ಸೆಕ್ಯೂರಿಟಿ ಸಿಸ್ಟಮ್ ಮೇಲೆ.
Fire systems ಅಂತ
ಸಿಸ್ಟಮ್ಸ್ ಅಂತ ಒಂದು ಇವಾಗ ಫ್ರಾಂಚೈಸ್ ವಿತ್ ಮೆನಿ ಬಿಗ್ ಕಂಪನೀಸ್ ಮೇಲೆ.
ವಿಂಡ್ ಮಿಲ್ಸ್
Exactly, I don't know my lord, the details. In fires.
ಅದರಿಂದ ಅವ್ರಿಗೇನ್ ಪ್ರೊಫೆಷನಲ್ ಟ್ಯಾಕ್ಸ್ ಬರುತ್ತೆ? ಇಂಡಸ್ಟ್ರಿಯಲಿಸ್ಟ್
That I don't know.
ಅಂದ್ರೆ ಎಂಪ್ಲಾಯ್ಡ್ ಅವರಿಗೆ ಹಾಗಿದ್ರೆ ಕರೆಕ್ಟ್ ಇದೆ. 3,43,780.
329.
ಅದು ಮಾಡಿದ್ವಿ ಮೊದಲೇ.
8612 ಮಾಡಿದ್ವಿ.
72 ಮಾಡೋದು. 72 ಹೇಳಿದೆ. 3,52,330 minus 8672.
3,43,658.
3,43,658.
658.
ಇದ್ರದ್ದು 40% ಎಷ್ಟಾಗುತ್ತೆ ಅಂತ? 40% of 3,43,658.
1,37,463.2.
1,37,463.2. 463.2 ಅದನ್ನ 463 ಮಾಡ್ಕೊಳ್ಳೋಣ. ಈಗ ಇವೆರಡು ಸೇರಿಸಿ 3,43,658 plus 1,37,463.
4,81,121.
4,81,121. ಇದರಲ್ಲಿ ಡಿಡಕ್ಷನ್ ಎಷ್ಟಾಗುತ್ತೆ?
1/4 ಅಷ್ಟೇ.
ಎಷ್ಟು? 4 ಡಿಪೆಂಡೆನ್ಸ್ ಅಂತ ತಗೊಂಡ್ರೆ
Please.
1/4 ಆಗುತ್ತಾ?
ಹೌದು.
ಹಂಗಂದ್ರೆ ಇದ್ರದ್ದು 3/4 ಎಷ್ಟಾಗುತ್ತೆ ನೋಡಿ?
3,60,840.75.
3,60,000.
840.7.
3,60,087.
840.75.
3,60,000 ಇಂದ 841 ಮಾಡ್ಕೊಳ್ಳಿ, ಯಾಕಂದ್ರೆ ಇನ್ನೊಂದ್ಸರಿ ಇಂಟು ಮಲ್ಟಿಪ್ಲೈಯರ್ ಯಾವುದು?
15 my lords.
15.
15
3,60,841.
into 15.
54,12,615.
54,12,615.
615.
ಉಳಿದದ್ದೆಲ್ಲ ಮೆಡಿಕಲ್ ಎಕ್ಸ್ಪೆನ್ಸ್ ಅದೇನಿಲ್ಲ.
Medical and my lords. Consortium.
4 ಜನ ಇದ್ದಾರೆ. 1,32,000 16 ಅಲ್ಲ 1,76,000.
Plus even transport and just in that also enhancement.
44,000 into 4. ಇದು 33,000.
56,21,615.
21,615. ಅಷ್ಟೇ. That's all. 4, 6 ನೋಡೋಣ ಹೇಗೆ ಉಳಿದವ್ರನ್ನೆಲ್ಲ ಕಳಿಸ್ಲಿಲ್ಲ. ರಿನ್ಯೂ ಮಾಡಿ. So if we dictate, the other matters may not reach. ಉಳಿದವ್ರು ತಗೊಳಕ್ ಆಗ್ಲಿಕ್ಕಿಲ್ಲ ನಮ್ಗೆ. ಇದನ್ನ ಡಿಕ್ಟೇಷನ್ ಕಂಟಿನ್ಯೂ ಮಾಡಿದ್ರೆ.
ಎರಡು still number 49.
There are connected. Owner's appeal.
I mean, owner's appeal. 49.
49.1 and 49.
ಅದೇ 4 appeal ಇದೆ. ಎರಡು ನಮ್ದು ಅವ್ರದ್ದು ಎನ್ಹಾನ್ಸ್ಮೆಂಟ್ ಎರಡು.
ಒಂದು ಮಾತ್ರ ಓನರ್ಸ್ ಅಪೀಲ್ ಅದು.
ಈ ಸ್ಯಾಟರ್ಡೆ ತಮಗೆ ಇನ್ಕನ್ವೀನಿಯಂಟ್ ಇಲ್ಲ ಅಂದ್ರೆ
ಸ್ಯಾಟರ್ಡೆ ನಾವು ಯಾವುದೋ ಲಾಂಗರ್ ಮ್ಯಾಟರ್ಸ್ ಹಾಕೊಂಡಿದೀವಲ್ಲ ಆಲ್ರೆಡಿ. ಹಾಕೊಂಡಿಲ್ವಾ? ಇಲ್ಲ ಅಂದ್ರೆ ಯಾವ್ದು ಹಾಕೊಂಡಿಲ್ಲ ಅಂದ್ರೆ ಹಾಕೊಳ್ಳಿ. 49
1, 2.
as requested list on 1, 2.
1, 2 much of that.
Still number 50.
Sitting day.
Syed Zahiruddin.
Is from the owner and another is from the client.
ನಿಮ್ದು ಸೇಮ್
I have before responded, my lord.
ಲಿಸ್ಟ್ ಆನ್ ನಿಮ್ದು 1, 2 ಗೆ ಹಾಕೋಣ. list your matter also, want to.
Any date after February 22, my lord. My senior is not available.
You
Kindly.
represent owner. You
I represent climate advocate.
You represent owner. After March ಅಂತಿದ್ದಾರೆ
No, my lord. February 22nd, my lord.
February 22nd. We are also arguing, no? All right, is it okay? She is seeking a longer date.
I have no.
ಹಾಗಾದ್ರೆ as requested by ನಿಮ್ದು ಒಂದು ಅಪ್ಪಿಲ್ಲ ಅಲ್ಲ she is seeking time claimant she
Yes.
presented by
Appellant 8334.
Shri Gopal Krishna and Learned Council. List on 22nd February ಆದ್ಮೇಲೆ.
Yes, my lord. Kindly.
27.
Why you are going to Kumbh Mela?
No, my lord. My senior is not available, my lord. That's the reason.
27.
27.
Yes. Much obliged, my lord.
After 17. 17.
Under the compensation awarded, the claimants under the claimants by the tribunal in NEC number 74 of is just one is the question involved in this case. The appellants were claimants 1 to 4. Respond number 1 and 2 were respond number 1 and 2 in NVC number 7468 of 2017 and the file of the MACT and SCCH. And the file of 19th additional small cause court judge and MACT Bangalore. For the purpose of convenience, the parties are referred to henceforth according to the ranks before the tribunal. Claimant number 1 is the wife, 2 and 3 are 2 is the minor son and 3 and 4 are the parents of K. Rangaswamy, deceased Rangaswamy. On 16/9/2017 at about exhibit 1 is an charge sheet is exhibit 3. Fifteen 9/2017 at 3:30 a.m. When near Adivala village on Hiriyur Bengaluru, I'm sorry, on NH4. In NH4, we use the limits of Hiriyur Rural Police Station. Rangaswamy was boarding car number K80 P8513. The driver of lorry bearing registration number AP03 PE2232 hit Rangaswamy and caused the accident. Rangaswamy, he died on the spot. So complainant was one of the injured. Rangaswamy succumbed to the injuries when he was being shifted to hospital. The claimants, I'm sorry, at the time of the accident, respond number 1 and 2 were the insurer and registered owner of lorry number AP03 TE2232 canter lorry madu. The claimants filed MVC number 7468 of 2017 against the respondents claiming compensation of rupees 1 crore 50 lakhs, alleging that deceased Rangaswamy was earning rupees 1 lakh from his business Messrs. Winfire's Safety Systems. He was aged 36 years and they were all dependent on his income. They further contended that due to his death, they have suffered pecuniary and non-pecuniary damages to the tune of 1 crore 50 lakhs, and respondents are liable to pay the same. Second respondent did not contest the petition. Respondent number 1, insurer, contested the petition, denying the actionable negligence on the part of the driver of the lorry, age, occupation, and income of the deceased, and its liability to pay the compensation. To substantiate their case, on behalf of the claimants, claimant number 1 was examined as PW1 and exhibit P1 to P26 were 26A were marked. Respondents did not need any evidence. The tribunal, on hearing the parties by the impugned award, held that the accident and consequential death of Rangaswamy occurred due to actionable negligence on the part of driver of canter lorry number AP03 PE2232. The tribunal considered the age of the deceased, 38 years. 38 years. 38 his income at rupees 3,52,329. 3,43,849. Future prospects ಕೊಟ್ಟಿದ್ದಾರಲ್ವಾ? 25% ಕೊಟ್ಟಿದ್ದಾರಾ?
ಇಲ್ಲ 40% ಕೊಟ್ಟಿದ್ದಾರೆ.
Addition of 25%. ಅದು ಬರೀಲಿ. ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದಾರೆ?
18 ಮೇಲೆ
added 40% to the same by way of future prospects. ಅವರೆಲ್ಲ ಮಂತ್ಲಿ ಮತ್ತೆ ಬ್ರೇಕ್ ಮಾಡಿದ್ದಾರೆ ಅದನ್ನ.
ಆನ್ಯುಯಲ್ ನ ಮತ್ತೆ ಮಂತ್ಲಿ ಮಾಡ್ಕೊಂಡು ಮಾಡ್ಯಾರ. That was not necessary. In fact,
exercise ಅಲ್ವಾ? The tribunal rejected the contention that claimant number 4 was the dependent of the deceased. Considering only claimants 1 to 3 as the dependents, deducted deducted one third for the person, 1/3 out of the income of the deceased for his personal expenses. Applied the correct multiplier 15 multiplier and awarded compensation of this 48,13,920. Tribunal in all awarded compensation of this 48,83,920 on different heads as follows. Internal page 16 7.5% interest ಮಾಡಿದಾರಲ್ಲ. Further, tribunal directed respondent number 1, the insurer, to pay the said compensation with interest at 7.5% per annum. Next, the respondents are not questioned the findings of the tribunal regarding the occurrence of the accident due to the actionable negligence of the driver of canter lorry number AP03 PE2232. For the liability of respondent number 1, the contractual liability of respondent number 1 to pay the compensation. Shri, whereas the appellants have questioned the adequacy of the compensation awarded to them. Shri, so and so learned counsel for the appellant's claimants submits that respondent number 4 was aged 62 years and he was dependent on the deceased. The very fact of tribunal apportioning him 5% of the compensation awarded shows that tribunal has considered him as a dependent. Therefore, the tribunal finding that claimant number 4 was not the dependent is self-contradictory. So, he further submits that ಎಲ್ಲ ಉಳಿದದ್ದೆಲ್ಲ ಸರಿ ಇದೆ ಅಷ್ಟೇ ಅದು ಒಂದು ಬಿಟ್ರೆ ನಿಮ್ದು ಬೇರೆ ಇಲ್ಲ ಕನ್ವೆನ್ಷನಲ್ ಹೆಡ್ಸ್ ಆಯ್ತು ಇದರಲ್ಲಿ ಇರಲ್ಲ. Further submits that the compensation awarded on the other conventional heads is not in accordance with the judgment of the Supreme Court in Pranay Sethi's case and Magma Corporation case. Shri H.S. Ligraj, learned counsel for the insurer, submits that claimant number 4 was an agriculturist and he did not enter the witness box to say that he was the dependent of the deceased. Therefore, tribunal was justified in holding that claimants 1 to 3 alone were the dependents of the deceased. It further submits that the compensation awarded on all the other heads is just one. Next period. It is no doubt true that claimant number 4 did not enter the witness box to depose that he is the dependent of the deceased. However, PW1, that is claimant number 1, tendered the evidence on behalf of all of them. There was no dispute that that claimant number 4 was aged 62 years. It was only shown that agriculture land is
agriculture, even land wise are not discussed. No, again discussion not.
Agriculturist antana agriculturist.
Agriculture.
And PW1 has stated that fourth petitioner is doing agriculture. Cross examine.
That is all. Whether he is independent, is earning anything or is not dependent, there is nothing like that. They are not elicited.
Agriculture ಕೂಲಿ ಇರಬಹುದಲ್ಲ. ಅವರು ರೆಫರ್ ಮಾಡಿದಾರಲ್ಲ PW1 ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಅಲ್ಲಿ ಏನೋ ಅಗ್ರಿಕಲ್ಚರ್ ಮಾಡ್ತಾರೆ
PW1 is agriculture.
ಹೇಳಿದಾರ
there is not. They have not elicited anything whether he is dependent or not. They are all living together.
ಇಲ್ಲೆಲ್ಲ ಒಂದು ಪಾಯಿಂಟ್ ಅವ್ರು ಹೇಳ್ತಾರೆ ಟ್ರಯಲ್ ಕೋರ್ಟ್ನವರು ಶಿ ಹ್ಯಾಸ್ ಅಡ್ಮಿಟೆಡ್ ಇನ್ ದ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ದಟ್ ಹಿ ಇಸ್ ಡೂಯಿಂಗ್ ಅಗ್ರಿಕಲ್ಚರ್ ಅಂತ
Even
ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್
very first line deposition ಇದೆ ಮೇಡಮ್ ಕ್ರಾಸ್ ಅಲ್ಲಿ
the tribunal took out a stray sentence from the evidence of PW1 that claimant number 4 is an agriculturist, but there was no material to show that he was capable of maintaining himself or the very fact of the tribunal awarding 5% out of the compensation awarded goes to show that tribunal at one stretch considered him as the dependent of the deceased. Therefore, the tribunal lost sight of the fact that PW1, the claim PW1 in her chief examination had stated that all the claimants were dependent on the income of the deceased. And the same was stated and pleaded in the petition also. In the ordinary course, a father aged 62 years, depending upon his son aged 38, earning son aged 38, is quite natural and normal. Similarly, a grown-up son having some occupation has the pious duty to maintain his aged father. Therefore, the finding of the tribunal that if claimant number 4 was not dependent on the deceased is unacceptable. The income tax returns, as per the income tax returns exhibit P18 for the assessment year 2015-16, 15-16, financial year 14-15. ಇದರಲ್ಲಿ ಅಸೆಸ್ಮೆಂಟ್ ಇಯರ್ ಇದ್ರೆ ಫೈನಾನ್ಷಿಯಲ್ ಇಯರ್ ಇರುತ್ತಲ್ಲ. The income of the deceased was rupees 3,52,330. Out of that, tax payable was rupees 8,672. On deducting such tax, his annual income would be 3,43,658. Considering the age of the deceased and the nature of his employment, and as per the judgment of the Supreme Court in this case, 40% has to be added to the said income by way of future prospect, which comes to 3,43,658 plus 1,37,463.20, rounded to 1,37,463. Thus, his total annual income would be 3,46,658 plus 1,37,463, 4,81,121. Considering the claimant 1 to 4 as dependents, 1/4 of the income of the deceased has to be deducted for his personal expenses. Therefore, his annual income comes to 4,81,121 into 3/4, 3,60,840.75, rounded to 3,60,841. Applicable multiplier is 15. Therefore, the compensation payable on the head of loss of dependencies is 3,60,841 into 15, 54,12,615. In view of the judgment of the Supreme Court in Pranay Sethi's case and Magma General Insurance Company's case, each of the claimants are entitled to compensation of this 40,000 on the head of consortium with escalation at 10%. Similarly, in the light of the judgment of Pranay Sethi's case, claimants are entitled to compensation of this 15,000 on the head of loss of estate and funeral expenses with escalation at 10%. Therefore, the just compensation payable is as follows: loss of dependency 54,01,650, consortium 1,76,000, loss of estate 16,500, funeral expenses and transportation of dead body 16,500, total 56,21,615 minus awarded by the tribunal 48,83,920, enhancement 7,37,695, rounded to 7,37,700. The enhanced compensation shall carry interest at 6% per annum. For the aforesaid reasons, appeal deserves to be allowed in part as the following order. The appeal is allowed in part. The compensation awarded by the tribunal. Compensation awarded, the appellant's claimants are entitled to enhanced compensation of this 7,37,695 with interest thereon at 700 with interest thereon at 6% per annum from the date of the fiction till its realization. Respondent number 1, insurer, shall deposit the said amount before the tribunal within 4 weeks from the date of the receipt of a copy of this order. On such deposit in enhanced compensation release ಮಾಡಬೇಕಾ? Because 62. ಇಬ್ಬರದು ತಾಯಿ 62.
ತಾಯಿ died married during the pendency. Our daughters are brought on their rights.
ಅಲ್ಲ, ಇಬ್ಬರದು ತಾಯಿದು 62, ತಂದೆದು 62 ಅಂತ ತೋರಿಸಿದ್ದಾರೆ.
But that mother died, my God.
ಅಲ್ಲ, father is alive or not?
Father is alive.
And ತಾಯಿ ಕೂಡ mother died ಅಲ್ವಾ? This Valli died, Chitra Devi and Lalita married daughters alva. So ಇದಕ್ಕೆ ಇಬ್ಬರಿಗೂ ಕೊಡ್ಬೋದಲ್ಲ?
5% could be.
Wife and ಅಲ್ಲ.
Wife and son, minor children.
Wife and father.
Father.
ಅಲ್ಲ, ಮದರ್ಗೆ ಏನ್ ಬಂದಿತ್ತು ಅದ್ರಲ್ಲಿ ಅವ್ರು ತಗೊಳ್ತಾರಲ್ಲ.
Mother share will go to the daughters ಅಷ್ಟೇ.
ಇರೋ ಇಷ್ಟ ಅಮೌಂಟ್ ನಲ್ಲಿ ಮತ್ತೆ ಅವ್ರಿಗೆಲ್ಲ ಔಟ್ ಆಫ್ ದ ಫಾದರ್ಗೆ ಒಂದು ಔಟ್ ಆಫ್ ದ ಎನ್ಹಾನ್ಸ್ಡ್ ಕಾಂಪನ್ಸೇಷನ್ 80% shall be released, digitally released to claimant number 1 and 20% shall be released to claimant number 4 on furnishing the required documents.
Much. Your Lordship's indulgence, the earlier case, Mr. Omesh and Bhushne, there's a 2013 United India versus Lakshmamma on this one case, where they say if the intimation is prior to the accident, company will not be liable. If sometimes intimation as insurers don't send it at all. If the intimation is subsequent to the accident, because as on the date of the accident, the policy was still in existence.
Be proved.
That is true.
Postal receipt ಇಲ್ಲ
ಅದು ಕರೆಕ್ಟ್, ಅದು ಪ್ರೂವ್ ಮಾಡ್ಬೇಕಾದ್ರೆ.
Either prior or subsequent.
ಅಲ್ಲ, ಅದನ್ನ ಡಿಸ್ಟಿಂಕ್ಷನ್ ಮಾಡ್ಯಾರೆ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಅಲ್ಲಿ.
There's no intimation.
2013 ಲಕ್ಷ್ಮಮ್ಮ ಅಂತ ಅದ್ರಲ್ಲಿ ಹೇಳ್ತಾರೆ. That is a law actually. That is the law.
Whatever they take, it has to be proved.
Absolutely. Most of the time, the insurance companies will not have.
ಆಯ್ತಾ ಮತ್ತೆ? ಸ್ವಲ್ಪ ಬೇಗ ಮುಗಿಸಿದ್ವಾ?
ಸರ್, ಅದು ಲಕ್ಷ್ಮಮ್ಮ ಕೇಸ್ ಅಂದ್ರಲ್ಲ ಸರ್, ಅದು ಸೈಟೇಷನ್ ಗೊತ್ತಾ? ಸೈಟೇಷನ್ ಲಕ್ಷ್ಮಮ್ಮ ಕೇಸ್
2013 ಅಲ್ಲಿ ಇದೆ ಮೇಡಮ್.
Parties,
United India versus